Hey guys, day 3 of the Afroman trial. So if you missed yesterday, Afroman took the stand. He was called by the plaintiff as if he was on cross, like a hostile witness, and the defense direct examination, they're reserving it for their case in chief, which is starting today with this first witness that we see on the screen. The feed started in the middle of it. Right before we start playing, I have about 2 minutes that I want to share from the Watchdog Wire. Watchdog Wire is also trying to cover this case as well as several other cases in this area. He's familiar with Judge Jonathan Hein. You might have seen him if you haven't come across his channel on your own. You might have seen him in the Afroman playlist because he did an interview with Afroman and attorney David Osborne right before the trial started. I think what he says here about media access is very important. So let's hear it. I think we all need to know.
And I'm standing in front of the Adams County Courthouse where the Afroman trial starts today. They're doing jury selection right now. I came early this morning and met up with some Afroman supporters in front of the courthouse. Okay, so it is March 16th and it is Afroman first day of his trial, and I'm here with Afroman supporters out in front of the Adams County Courthouse. And let me just go one by one and ask each person.
Oh, I think I might have played the wrong one. Hold on. It's about media access. Maybe I'm clicking the wrong one. Let me go to Twitter because you guys shared it with me. Unless it was starting in the middle. But if you already have some questions about Judge Hein, you might have some more. All right.
Afroman Dream Team coming back to court.
Freedom of speech, God bless America.
Read the caption. Says, Judge Hein hearts WCPO, and I have no issues with WCPO. Only they are allowed video. And there are rules, Ohio court rules. It's like, hey, media requests. You know, there's only going to be one still camera. Like the fancy camera, there can only be one of those hooked up because it's large. It can be cumbersome. It can be a distraction. But the media outlets that request and have access to use video in this case, that whoever is running that pool needs to share that footage with others. That's what the Ohio rules seem to say to me. Apparently that's not how that rule works in Judge Hein's court.
So it's no secret that I'm not a fan of Judge Jonathan Hein. I think he's a hack judge, and I'm not the only one. The Enquirer ran an article on all of the complaints against him for his hackery. But I think one of the hackery things going on here has to do with media permission, which is called Rule 12. You file under Rule 12 of the Rules of Superintendents to be able to record in court. Well, I was trying to get copies of all the entries because we know WCPO has been live streaming, but they're the only ones having video. Well, there are I think there's three different ones here, media requests in which Judge Hein, not a fan of Judge Hein, the People's Defender, Pistolist Production and Company, I'm Not a Lawyer, but .com. You know,
Shout out to I'm Not a Lawyer.
All of those three entities were told in the order from Judge Hein that they can have no audio or video recording is permitted, no streaming, broadcasting, or other simultaneous distribution. So I saw WCPO's doing this. I asked for the judge's order relating to WCPO. The clerk did not have it. Okay, the clerk did not have it. I kept asking for it. Now they have it. It's actually stamped that it wasn't even entered in the docket.
It says March 17th, 2026. And I want to be clear, when I was figuring what to do over the weekend, do I have to drive up there? Is anyone going to be in there? And I saw that Mel had put in an application. Her application, and so did the People's Defender. They were there on the 13th already, but they didn't get a response until the 16th. And it wasn't posted until the end of the day on the 16th. So that's 3 days that go by that they didn't know if they'd have approval at all or not.
Today, Tuesday the 17th, at 12:14 p.m., no doubt because of me asking, where the hell is the thing giving them permission to do this? And what are the stipulations? So the normal stipulation in such a thing should be that WCPO has to share its video with any other media outlet wanting video coverage, especially when the court has prohibited video by other people. Well, I'm looking at this WCPO order issued by Judge Hein, not a fan of Judge Hein, think he's a hack. It says nothing about them needing to share any of their video with any other media outlet. So apparently Judge Hein decided that only WCPO TV is allowed to have, produce, or share video of this trial. It's absolutely ridiculous. It is absolutely the kind of hackery sloppiness, not thinking through stuff that I've seen Judge Jonathan Hein do again and again. It's completely unfair, and I, however, am going to get the actual court video because they have a good video system in the room and actually put it out in
He has
full,
all of day one up.
unredacted, no in and out, no WCPO stuff of the actual day-by-day court, so it'll all be there in posterity, kind of like what I did with the Kevin Gaffin hearing as well. But
so there we go, you guys. I thought that was, you know, my backstory on starting a YouTube channel was just to put up some exhibits that I didn't find accessible anywhere, and I covered a trial that did not have cameras, and with the help of a few interested people, we pulled together money and bought some transcripts, which were very expensive. So media transparency, access to courtrooms has always been something very important to me. It's the reason this channel started, although now, like, I have fun with it and want to treat it like we're watching trials sitting on a big comfy couch together, chatting. But if you could please take a second here, if that resonates with you, or if you want to see the interview that he has done with Afroman and his attorney, or he has the full footage of day one up, and he says he's going to keep putting them up. There's a ton of reasons to go and support what the Watchdog Wire is doing. So you know, there you go. Big fan here of transparency and media access to the courtrooms. Let's get into this. To no one's surprise, I'm sure, WCPO's feed starts in the middle of this lady's testimony. So we'll get caught up. We'll try to catch some missing pieces. Again, thanks to the Watchdog Wire for anything that wasn't part of the daily court feeds that we're watching. But to watch it live, it's going to be a little hodgepodge, as it's been for day one and day two. Hope everybody's having a good day so far. Hit that like button and let's go.
You got into the mind of the kids pretty well.
Yes.
When they would play Mr. Foreman's song Lemon Pound Cake, did they take that as a literal fact from your observations?
No.
Were they laughing and joking about it?
Oh, yeah. Absolutely.
Are you familiar with the song W.A.P.?
No!
I think I've
I'm
heard
sorry,
it.
no, strike that. I'm going to give you the complete song
Okay.
and then summarize it because I only want to say it once. Are you familiar with the song Wet Ass Pussy?
Yes,
Good morning, chat!
Is that a rap song?
it is.
Has your students played it in class?
Once, and I asked them to please turn it off.
When they were listening to it, did they think that was fact?
No,
So they didn't think that that was depicting anything in real life?
no.
So you didn't have to teach them that wasn't real?
Right, no, I did not.
You've heard the song, correct?
Mm-hmm, yes.
Do you believe it's a literal interpretation?
No,
Would you agree it's derogatory towards women?
no,
Even though it says nasty things about them?
yeah, no.
Liberation.
I mean, it's the artist's opinion, I guess. That's the way I feel.
Maybe not an opinion you like, but
Yeah.
you know, if I may have a moment.
Cardi B would be like, it's real, it's literal, it's literal. Just right into it.
So, Ms. Grooms, has Mr. Foreman's posts about Sean or any of the general posts about the Adams County Sheriff's Department as a whole affected your life any at all?
No,
Would you believe it would have affected your life while you were married to Sean?
if it had any effect, I guess that would be the time it would have an effect.
But as his spouse, you would have expected it.
Yes,
Okay. And I don't want you to go into too many details, but is it fair to say that Mr. Foreman, the posts about the police department, everything had not a damn thing to do with your relationship between you and Sean and why it came to an end?
No, it did not.
So the posts never affected your life, never affected your marriage?
No.
Okay. So any statement to the contrary would be false?
Yes.
Okay. Thank you very much. No further questions at this time, Your Honor.
Thank you.
And thank you, A.B. Schmidt. I'll opine on this in a little bit. Also, KLB,
Morning,
thanks
Mr.
for
Williams.
coming to me.
I'm sorry you have to be here.
I am too.
Thanks for coming. Where to start?
Ask about more songs.
You never sought a protective order against your ex-husband, did you?
Yes, I did when we divorced. The divorce, yes. I had a
you?
restraining order.
Did you got a restraining order?
Yes, I did.
Were you aware of the posts that were coming out after 2022 about the sheriff's deputies and calling them thieves and that sort of thing? Did you ever see any or hear any of the songs?
Some of my students referred to it and they would say, I saw your husband in the video. And I would say, yeah, that was him, and turn around and walk away. I didn't elaborate on any of that, no. And
Why?
they didn't either,
Why didn't you elaborate on it?
because I didn't think it was the student's business.
Okay, so they had seen your husband in videos,
Yes,
and did you tell your husband about that?
about,
That your kids had mentioned it?
no, it was just a mention and that was it.
Okay. And did you ever, you saw the posts yourselves or videos yourself, or did you just hear about it from kids?
I saw part of it and then I heard about it.
Okay. And did anyone else in the community ever say anything to you about these videos or posts?
No.
Just your kids?
Just my students in the school.
Students? Okay. The song that Mr. Osborne asked you about, does that song refer to a specific identifiable person?
I don't think so.
Those are all my questions. Thank you, ma'am.
Okay.
Rhonda, Mr. Klingler asked you about your students. Your students saw the posts
Yes,
and they articulated it to you?
yeah, just say, hey, I saw your husband in this video.
Students can, would it be a fair statement to say children can be mean? Cruel?
Absolutely,
You've seen instances of them being cruel?
absolutely.
Are they cruel to both other students and teachers?
Yes,
I don't like bringing up sensitive subjects, but has any of your students ever been cruel to you in the past?
oh, yes, definitely.
The sirens are so loud.
Would it be fair to say they've said some pretty mean things?
Yes,
You see, I'm trying not to ask you what they are, but are they shocking names?
coming from my students, I mean, in all honesty, it's, when they're mad at me because they didn't receive an A, yeah, they get mad.
And they
And-
lash out.
Yes,
But they're not calling names a fact or anything to you?
no, no,
And they've seen these posts.
yes,
Did your students treat you any differently?
no,
So, could you point to any instance where a student treated you differently due to the posts?
no.
So, for some context, I believe when her husband testified, he said something to the effect that part of the reaction that his family was getting, it caused the divorce. And now we learned from this witness that she didn't feel treated differently because of what her students may have been seeing by this. In other words, it wasn't a factor in the divorce. Whatever caused the divorce, she had to get a restraining order against her husband.
I'm going to ask this question. You said you're sorry to be here. Why are you sorry to be here?
Because from my recollection, my ex-husband had said that this was part of the reason we got divorced.
See?
No further questions, John.
Klingler? No further questions.
Yeah, because that was bad for you.
Am I right to understand this witness was a lay witness?
Pardon me?
This was a lay witness, not an expert, right?
She's a lay witness to testify to what she would have experienced in this.
Right. And the only reason I did that is to explain to the jury that people sometimes have training experience and can make opinions as experts. The doctor comes in a medical malpractice case, they're an expert. This is a lay person, the same as any other. Some of the questions spoke generally about society and public perception, which would seem like
There were no
more of an
objections.
expert opinion, when in fact, as a lay witness, she can only testify about what she experienced herself. So you have to understand the scope. She's just what happened to her, lay, average person, not educated expert. Thanks for being here. You can go ahead and be excused. Go ahead, Mr. Osborne.
Your Honor, I'd ask for a short 10-minute break so I can talk with Mr. Foreman. Based upon the ruling in the Rule 50, I want to juggle some of my witnesses, make some corrections to that, as I had anticipated a different verdict due to the evidence, or different ruling due to the evidence, so I'm going to need to shift for that. I'd like 10 minutes
That's
to
a
talk to
motion.
my client to strategize.
He's talking about a motion for directed verdict. Now, it seems like the Watchdog Wire will have this full footage, and I would love to watch this, so we'll definitely watch that when it's available. And again, please go over. Let me pin their link in the chat in a second, and put it in the description. They're also in the Afroman playlist video. But it seems like they probably move, which, why wouldn't you, for a directed verdict on, at least some of these officers that are like, you know what, I don't really think it damaged my reputation. People have always called me a thief, and that was really the only thing. The only commentary I was the receiving end of was they didn't like our performance as a whole. That should have been a directed verdict. I'm shocked that this judge, even though he seems to be leaning in such an extreme direction in favor of these plaintiffs, in my view, you would think for saving face, he might grant at least one, just to save face. But yeah, I don't know. I don't remember which cop was the husband. I mean, as soon as we see the full testimony, we'll see what her name is if she's introduced. If I were to go back and watch, I don't think it was, I don't know. I know Sean Grooms had some drama with an ex-relationship, but so did some of the others, so I can't narrow it down just because I'm sure that Sean Grooms has an ex-wife. Because I don't think that's the only person over here that has left their partners and is somehow attributing it to Afroman. So, anyway, you guys. We'll watch those arguments once they become available, but that's what he says when he says Rule 50. He's talking about the directed verdict.
Comments, Mr. Flanagan?
No, I have no.
The one from the second one from the left.
If you're doing
You say it's the one at the
managing
end?
time, I think that's a good idea. I would like to know how I did with getting the jury on schedule.
Your Honor, that's why I want to strategize, see how we can hopefully.
Yeah, well, I appreciate what you're saying. Take a break, go back to the jury room, stay there if you would please. Short break will be helpful.
Joe, follow me up, please.
All right, and they're just chattering. Oh, Jesus. All right, so we'll jump. We'll jump past that. Let me mute that till we see his face. There we go.
So there'll be a minute without objection.
And it starts in the middle. It cuts back into the middle.
Rebuttal, please.
No rebuttal, Judge, no further witnesses.
Okay, thank you.
What?
So, ladies and gentlemen, we're moving forward to the point where you get the case handed
They're
to
in
you.
closing arguments already.
What comes next is closing arguments and instructions of law. So closing arguments are meant to be the opportunity for the lawyers to tell you what they think the evidence means. If you want to take notes, do so, but like draw a line on your paper and say argument, not fact. Like I don't know how you keep notes, but I have to keep them organized. So I can realize who's talking. You've seen me do it a couple of times. Lawyers aren't evidence. The witnesses are. It's the same thing here. I don't think you would get confused or misunderstood. The plaintiff goes first because the burden of proof is on the plaintiff. The plaintiff also, because of that burden of proof, gets a privilege. So they get not only the first word, but they get the last word. So Mr. Klingler would start, Mr. Osborne would go second, and then Mr. Klingler would get the last word. Not because of favoritism or anything else, but because of the burden of proof. Then at that particular point in time, we'll give you jury instructions. And I'm going to take a break after their arguments because I need to make a few copies for the lawyers to read while I read. We give the instructions to you in writing, but I always like it when they can read over my shoulder because sometimes I put two words in different order and it changes the meaning. So then we have like three people reading to make sure it comes out to you right. So we'll hear their closing arguments, take a short break, you'll get the instructions, and then we'll turn you loose. Go ahead, Mr. Klingler.
Your Honor, if I may, procedurally, I'd like to renew my motion for the record.
Thank you. Very appropriate.
Rule 50.
With regard to the false light claims, the court overrules the motion. Outside the presence of the jury, I can give you a little bit more of the why, but when I give deference to the evidence and construe it in favor, especially with regard to
Don't say this in
highly
front of the jury.
offensive and reasonable juror,
Why is the jury still in here? They didn't get out that quickly, did they?
reasonable public
What?
perception, like those clearly become fact issues to weigh, which I shouldn't do. So as a matter of law, I couldn't dismiss the claims. There's at least enough evidence when I construe the plaintiff's evidence in their favor to get past the Rule 50 motion.
They got out that quickly?
You are spot on to remind me to do that.
Your Honor, there's also another matter we need to clean up. We probably should do at the sidebar before we go into oral.
Yeah.
Okay. I like cleaning things up.
No, you don't. I mean, maybe sweeping. Oh my gosh. He just opined on his reasoning for not granting a directed verdict in front of the jury. Wow. Oh. And it's like, I don't want to say too much in front of the jury, but... And then he goes and says it. Someone flush quickly. Like, crazy. Just wild. Yeah, you can appeal civil cases. I mean, it's slightly different procedurally because, you know, there isn't, like, the super, you know, restriction on freedom. You know, someone hasn't, they're not going to look at it like somebody's lost their livelihood. You don't have a habeas option. There's no pathway like that for civil, but you can appeal civil stuff. And appeals can be stopped for, like, interlocutory actions as well. Like, in the middle of a proceeding before the trial concludes, decisions can be appealed. So, this is crazy. Well, let me opine on this. I mean, I think it's a great question. I think everyone feel free to weigh in. In my opinion, how's it going for Afroman? I think it's going great for Afroman. I think it's going great for Afroman. I always have concerns. I'm not all that familiar with the elements of the first two counts, but for defamation, what are the damages? What are the damages for defamation? Like, if we get past the idea, and I really think this thief thing, I think that should be off the table. But maybe the jury might feel inclined to look heavily at the statements relating to Newland about the little boys, and maybe the sex change for Lickum Lolisa. Although I think the video was clearly not literal.
By a vote of 3-0, the lawyers all being unanimous, they want to see like this last draft of instructions, because often they use the instructions in their argument. So like the chicken scratching stuff that we've been doing in the past is distracting. So we're going to let me do my work. It's 30 minutes that we need. So we'll go take a coffee break, just stay back there. Instead of me doing it the other way, we'll just take the break now for the jury instructions.
Can't smoke, can we smoke?
What?
The bailiff doesn't like irritable jurors, so you should go smoke. Do you like irritable jurors?
I prefer not to have.
Okay, that's all. Yeah, go take a break.
All right, thank you.
You're pretty high maintenance.
Yeah, can they smoke? Can they smoke?
Yes, I think it was like, exactly, yeah, like you're supposed to.
Everything you need to know is right here. Is that yeah, correct?
All right, so they're not going to broadcast whatever they're doing as far as housekeeping.
Well, I'm here for
So I'm kind of curious if they're going to speak more about motions issues or if they're just going to get right into jury instruction conversations. But WCP09 is not broadcasting this part. So this is another thing that we'll want to look for some footage later. I do want to emphasize that Ron Wade, I agree, offensive speech is protected. And I'm still not clear on the specific statements made about Newland. But some of the statements that I saw, touching boys, I mean, if it's based on the way he's holding someone in a picture, I don't really think that that's necessarily crossing the line of accusing somebody of a criminal act outside their line of duty as a police officer. I don't really think I saw specific statements that went beyond that. So I personally don't think, I wouldn't be sitting there wanting to award anything to anybody on this lawsuit. But people don't always agree with me. So, in this trial, I believe they have a jury of 8. That seems to be according to the way Ohio does things that I looked up. Civil trials, they get a jury of 8. They need 6 of 8 or 3/4 at least to agree to render a verdict on a specific count, a cause of action. So they've got 3 causes of action that they've got to consider, but they've got all these different plaintiffs that they've got to consider. And then I don't know how they're going to do the considerations. Are they going to break it down supposed statement by statement, or is it just going to be a blanket, as far as this defamation count? Do you find that Afroman defamed and then go one by one through the individuals? And then if they do say, yes, we think he's liable for XYZ, then they have to go through the damages phase. And I still don't think that any damages were established by the plaintiffs. We had a little bit of the one guy still not working. Not really sure if that's because of Afroman. That wasn't established to me. But Brian Newland is getting higher pay. He's now a detective in another in another agency. You know? So, yeah. Award, I'm joking. In my mind, if they award someone something, I would love to see the amount just be $400 since you wanted that $400 so badly. So, oh man. I also said I was going to pin the watchdog wire in the chat. Let me open up YouTube to do that real quick. Get that in there. Please take a second, especially since we are awaiting their return. This is why we start late, guys, so we can miss some of the downtime. Watchdog wire. Let's see. Pin. Wait, pin the chat. All right, so that is there. So please take a second to go over there. I mean, this break was pretty long. I don't want to get in the weeds of starting to watch stuff that we didn't watch quite yet. Because I said about 30 minutes, and it's been like 20-ish. Maybe we could take a peek at opening statements in full. Ah, it's another angle, too. That's going to be fun. All right, let's just start. So what would be here that we didn't have from the day one feed? There's like some preliminary stuff that was being discussed. This looks like we're in the chambers. That's cool. Speaking to the jury. And then opening, you'll see it's at a different angle. It's like facing the table. So we'll get to hear the part of this guy's opening statements that were cut out. And then I think the end of the day. Did we end abruptly? No, we saw the end of the day. There was some parts of Brian Newland's testimony that cut out for like a minute. Yeah, so, but this is 5 hours, 30 minutes, and I think our stream for day one was like 2.5 hours. So there's obviously some stuff here that we missed. If you guys want to just like start, we'll play some of it, and as soon as court comes back, we'll toggle back over. It'll be kind of choppy. If you guys want to do that, we can do that. Sunshine for you, $2 for the cuss jar. Yeah, was it because of the judge opining in front of the jury? Thank you for the 2. Kristen says it sounds like he's grooming the jury. I mean, to me, it does feel like that. Yeah, factual lie. So this is Chris Hicks is his name. He says he's going to be uploading all of the days from the camera system in the courtroom. So that's why it's going to have those angles, which I kind of enjoy. I know they're not the best quality, but I kind of like when the camera jumps and shows different parts of what's going on. But he said he's going to do that for all the days. So we should be able to see what we missed from Lisa. We should be able to see the beginning of direct on the witness that started off today. And I don't know if... So this feed started in the middle. Maybe there was a witness before the lady that we caught. Because they moved through these witnesses pretty quickly in this trial. I think it's possible if they started around 8:15, they could have had another witness and we'd have no idea. So... Sheriff Chuck celebrating 7 months, says this is a trial that 7 months has led me to. Heck yeah. You know, it gets worse every time, doesn't it? Well, thank you for being a member for 7 months. We cannot watch Lisa's cross yet because it is not available. It's not available, you guys. So, I know everyone's saying they want to see the cross. It's not published yet. So, also, Sheriff Chuck bringing 5 more along. So, 5 people just got memberships. Thank you so much for gifting. Make sure if you just got a gifted membership, I can see them. So, Hate Hose here got one. Ron Wade got one. Scorpio got one. Real Happy got one. Make sure you guys are saying thank you to Chuck. And check out those lemon pound cake emojis in the chat. And I don't know why. I only see 4 gifted when I look. So, I don't know what happened to the 5th one. So, let's see. Barry Hugo sees another song in the future. Guys, so what we'll do whenever I see the day 2, we'll get together. We together will watch the cross of Lisa, and the rest of the direct, because I think the plaintiff attorney said he had like 15 minutes or so of direct left. So there must have been some direct and then cross, of course, and maybe some redirect, maybe some recross. Who knows? But that's just not available. Let's see. They're not back from court, so let's just see what happened with this in chambers thing. I gotta like this video.
Yeah, participant Channel 9, and as other members of the public want in, they'll be left in on a first come, first served basis. Once we get through the jury selection, have an impaneled jury, it won't be an issue because there'll be plenty of seats. But jurors would come in first. With regard to questioning, the seating chart has this layout. You'll get the names. We're going to talk to 12 at a time.
Okay.
So you don't have to try to focus on the 60-some people. Just direct your questions to people in the box.
All right.
I could never keep track of 57.
Yeah.
So I don't do that to you either. Why does it matter who's next if they never get to be next?
Yeah.
As we go through this, I'll do my questioning, warm up, introduce the facts, so you don't sound like you're prying.
Okay. Good.
Then you'll get your chances, plaintiffs first. When you go through at your first inquiry, I'll ask, do you have challenges for cause? And really what I'm looking for is a yes or no.
Yeah.
And then same thing, Mr. Osborne, I probably would deal with your challenge for cause by having a quick sidebar.
Okay.
I don't like coming back here. I think the jury misunderstands that. So to the side, they can make a record. I'll ask you what the deal is and give you a quick decision. And when you go through the peremptory challenge process, it'll be at the side in front of the jury, but off the record, so they won't hear why. I would expect you to shoot the jurors in front of the jurors.
Yep.
Never knew the psychology of how their best friend just got excused by the plaintiff's lawyer,
Right.
or whatever the psychology
Right.
is. So I don't like that. I just say the lawyers are allowed to excuse, and these people are gone. And every once in a while, I let one go. You would know that I was going to do that, but I could have my own reason, and that would be even more odd
Yeah.
if the judge excused somebody. So I can hide everybody, and I will. Okay? That doesn't happen very often.
Judge, I'm sorry.
Go ahead. That's what we're doing.
12 in the box. Let's just say nobody challenges, everything's perfect. The first 8 would be impaneled, and 2 of them, and then the second 2 would be
We'd let 'em go.
alternate? Okay,
9 and 10 are the alternates.
right.
If you call them an alternate, I'll correct you, because they aren't. They're not an alternate until deliberations start.
Okay,
What if number 3 has a health, a family, another problem? I'm not going to tell 9 and 10 that they're going to sit here for 5 days and do nothing,
right.
because I would be upset and I wouldn't be paying attention. So we don't know they're an alternate till then.
Okay,
Don't say alternate now. Otherwise, they fall asleep and they get upset or they wish they weren't here.
so we're just choosing 10, we're
We're
just getting
we're
10
picking
people.
10.
Yep,
And then and sometimes the alternate isn't 9 and 10 when you agree that the person who slept through 3 days of trial
right.
shouldn't be seated, because you can agree at the last hour to switch them. So I want to give you as much flexibility as possible.
I've had jurors fall asleep in trials.
Yeah, and I blame the lawyers,
Yeah,
because you got to entertain them.
There's only so much excitement you can get.
Yeah, that's right. Sometimes I let you argue your objections, only to show, A, a good record, and B, the jurors that you advocate for your clients, and then we can educate them. So if you want to stand up and say hearsay, I'll say, well, develop that for me.
Okay.
It's not meant to see if you went to law school.
sure,
It's to let them see advocacy.
yeah. Okay, that sounds good.
Do we have the jurors take notes? Are they allowed to take notes?
That's up to you, Judge.
Usually we should.
Okay,
So pull out the notebooks.
great.
Thank you. Quirks.
Can you imagine this guy, like, you're all together at a family gathering and you're about to break out the Uno and he's explaining his house rules. Like, you just gotta be like, wait, can we do this or not? Like, are we allowed to, like, stack? And he'll just change it when he feels like changing it. Also want to give a major shout out here. Christy also came in and dropped 5 lemon pound cakes in the chat. Thank you so much, Christy. Throwing out the gifted subs. Super generous, and I think it's such a fun way to... It helps me, and I think it's a super fun way for the chat to be involved. So big thank you here. We've got the Honorable That in the building. Been here for 19 months. Says shout out Cat, Chat, and the Honorable Pound Cake. Yeah, I should get one up on... While we're in the chambers, we'll put up a pound cake. There we go. And I know it's a bundt cake, but we're just calling it pound cake. Because I think the kitchen, it looked like it was a bundt cake, right? It didn't look just like a log pound cake. Always good to see you, Honorable That. And then we have Mark Lyon, who says, imagine being the exclusive camera operator for the trial of the century and botching the job. So many missing parts. I mean, getting it wrong, I thought maybe they had an okay excuse with the 8:15 if they missed that. I don't know why you'd miss something like that. You could ask the court when they're supposed to start, even if you don't hear the judge the first time he says that. But it happens. But it's like every bit of broadcasting has been late or in the middle of something, and to hear that they're the only ones that had the access to do so when several other people were willing. I'm not a lawyer, but I had a cameraman ready to go and be in there, and she was going to do a test run to make sure they could do the live stream and get it right. The People's Defender, I believe, it looks like he does videography, photography stuff on his own. He's been in the courtroom sitting there, but he also had asked for permission to record. So, and then the Watchdog Wire. I think there were at least 3 other outlets who would have been ready and willing and maybe been able to get critical parts of footage disseminated. So, but I'm very glad that Watchdog Wire is getting the court footage, and this is kind of interesting to see in the chambers here. I still have the live today's court in the background. It's still on the commercial break music. Yeah, so they're not back, but we will jump back over there, I promise. Yes, me too. I'm going to drop her link right now. Make sure you guys follow Mel. I'm about to drop her link in the chat. She's also in the playlist link in the description.
I know I was going to say one thing about jurors. Bob, I've let the court know there is one lady who's been called as a juror. Her husband came over to talk to me at my office. I have an active case in the Court of Common Pleas here in which I represent her.
What's her name?
Gordoff.
She's gone already.
I've told her that. She's just waiting for everything.
Now,
Thank you.
it's odd, but people are allowed to know people in rural areas. Like, I don't know how far out of urban land you go.
Yeah.
But when I go to cities, if you have a breathing relationship with anybody, you're gone. But in a small area, if you don't know people, you're living under a rock, and you don't want to have them as a juror.
Yes.
So, like, a certain amount of familiarity is expected in a rural county. But active representation is a disqualification.
Yeah.
So that's just, they're going.
And that's where I appreciate her husband coming over and letting us know so we could take care of that before we start.
So, like, that person doesn't have to sit here for hours. We won't mess with them. I don't even know where they are and they've been hired.
I didn't know clue either. I just know they got the sticker that says
It doesn't matter, but because you won't see them in the courtroom. We're just going to let them go, and we'll keep track of that. Time, as I told you on the phone, is a big thing for me, because there's a lot of work to do in a limited amount of time. So, always be pushing forward, to be ready with the next thing. If you need more time than I'm not giving you, try to get my ear.
Okay.
Redirect and recross examination are privileges.
Okay.
They're not rights.
All
Like,
right.
if I think we're struggling for time, that's where I'll, like, chop you off,
Okay.
right? Sometimes you want to save the good stuff for later,
Okay.
but if you don't get it later, you wish you wouldn't have saved it, right? So, like, there's your warning,
All right.
because we aren't going to be here on Saturday. Chris already told me that there's a special place for judges who make orders, not on Saturday. No, right?
Yeah.
To do this
Sure.
case, actually, you can't be presenting your evidence on Friday.
Yeah.
You've got to be making your closing arguments so I can do the jury instructions so they have time to work on Friday.
Right.
We're calling witnesses this afternoon.
Yeah.
Like, just visualizing, I don't know how this is going to really work. We should have a jury by lunch. I don't know what time that is, but it's lunch.
Okay.
And then I'm not going to give you as much time as you want for your opening, but you get one.
Okay.
then we're going to start calling witnesses.
Mine's 20 minutes, will that work?
Depends on how you do on jury selection.
Okay.
That's not unreasonable.
Yeah.
See what I just did to you? I manage time,
Okay, yeah.
right?
Gotcha.
I manage time. I don't know what time we're going to start tomorrow. Are you staying in the county someplace?
Yeah,
Yeah, of course. So like if I can have a panel who gets here earlier, I don't know what earlier means.
Yeah.
What time would you normally start?
We typically start at 9, but
Yeah.
we're always open
We're
today.
never going to start at 9. Because the only way to get more time is to start early and work late. So like I would start suggesting maybe we're going to start at 8:30 tomorrow. I just helped you.
Yeah.
I just gave you your 20 minutes because I
Thank you.
brought a half an hour. But I don't know that till I figure out what juror has a child care
Yes.
issue till, and if none of them have child care issues, then why are we not starting at 8:15? It's fluid. If Wednesday might be different,
Okay, all right.
right? It's
Yeah.
fluid, like
Right.
how we do it.
The craziest part about this, they slate 4 days for this, and, you know, day 1 is only 5 hours and change, including all of this behind the scenes stuff before opening statements even start, and then they end early. It was a short day of actual, like, trial record, and then, or testimony, and yesterday, we ended a bit early because the plaintiff rested, and, oh, can we call our witness tomorrow? And it's only Wednesday. So they still have Thursday, they still have Friday. He did more micromanaging here than the length of the trial even took.
Like I don't expect you to start a witness at 10 till 4,
Yeah,
unless it's a 5-minute witness.
yeah,
But if you're going to start somebody, you ought to at least be able to make it through the direct or whatever phase it is and start with cross tomorrow morning, because you're going to thank me in the end for getting all the evidence in as opposed to running out of time.
yeah,
Like, what are you doing on Monday? I don't care, but it's not this case.
yeah.
Exception is whether the jury can deliberate it. Once they get the case,
Yeah.
they own the case. If they work Friday and it's a late hour and decide they need to go home, then I'll see you Saturday morning. Not
Okay.
because of what I said, it's
All right.
because they own the clock
Yep.
when they deliberate. There are motions limiting. Thanks for doing that because it tees me up on legal issues.
Yeah, that's the point.
So it helps me, but remember, you got to renew your objection
Yeah.
in the moment so we can decide in the moment. Really helpful, so I could see what was coming. Like, I don't know how untimely disclosure gets passed. You both have the same issue. Like, you got a detective and a report on $400,
Yeah.
which I haven't heard about.
Yeah,
Like, we'll have to talk about, I want to call this person next.
okay.
And then we'll have to get to it before they get on the stand,
Okay.
right? And you have the harem of girlfriends and whatever it is,
Harem of
right? I don't know
girlfriends.
relevance in any of that, but I need to at the moment. Like, you listed 5 people that you said you had never heard of. Or what's the deal with Trinity White Knight Flyer? All of that stuff I'll have to hear in the moment, but it's very helpful to do motions in limine.
They're back
So
in
thank
court.
you for that. What do you want to know, Mr. Klingler?
We will pause here. I'll keep the same position. And it's really quiet. Oh no, why is the regular court feed super quiet? Alright, boosted it back. Had to boost it. Let me wait for the commercial to re-end because I rewound too far. Here we go.
For instance, I'm not submitting to the jury whether the 5 plaintiffs are private figures or public figures because Judge McBride decided that. So in the instructions, I've taken prior decisions of law where necessary and put them in. And you didn't deal with that, but sometimes I have to tell the jury how we got to where we are. That becomes instruction of law. The law of the case goes into the instructions. So I don't explain it to them. I'm just saying to the record, I took prior judicial law of the case findings and slotted it in where necessary, because that's what we always do. Sound right, Mr. Osborne?
Your Honor, I had no objection.
No objection, Judge.
Okay, any witness?
Yes.
Off the record, you want to start?
What?
Your Honor,
Yes, sir. We're off the record.
well, we have the 2 housekeeping things. I have to renew my verdict, and then we have to also discuss the music company.
Okay, back on the record.
We're back on the record.
Okay, so 2 points came up. You wanted to review your motion for Rule 50
Yes.
dismissal, which the court overruled. Mr. Klingler responded to your inquiry about the Access Incorporated.
Yes, Your Honor, just for the sake of the record, we had a telephone conference on this, we had discussed this issue. They had not pled, they are technically in default of the answer. During that telephone conference, which was not on the records, we discussed what would happen with that. Mr. Klingler said he would evaluate it. We are now about ready to do closing statements. No evidence has been presented against him. Mr. Klingler has not asked for a default judgment. He seems to be wanting to put everything on my client, which is very strange why when he has a default he wouldn't make a motion for such. But we would ask that the record be cleaned up in that issue.
Yeah, I'm going to clean up the record, and we are going to dismiss that party from the case.
Media Access Incorporated.
Yes.
We've registered an objection to him not doing a directed verdict, or sorry, doing a default verdict on that, and therefore increasing damages upon my client if they should be found.
No, I think he gets to own his own complaint, so I just have to follow his lead. But I get what you're saying, and
I can
appreciate
argue
your-
for mitigation of attorney fees and stuff that he has done.
No, if it gets to that, if it gets to that, that's not a part of the jury's of the verdict.
I just have to, I'm trying to think a step ahead.
I like that. Off the record, please. Go ahead and do it, Mr. Bailiff.
So it's time to go. See, I knew that. I waited the extra 30 seconds. You got 6 cents for it. Absolutely.
Okay, thank you, ladies and gentlemen, for your patience. Have a seat. That actually was about 45 minutes, so I didn't gauge my time very well, but thank you for your patience. We are moving ahead, as you know, so most people don't growl about that, but I try to at least respect your time and tell you what we're doing. We made it through, like, the corrections to the jury instructions. Like I've been trying to educate you all the way through. The jury instructions are the textbook at the end. So the lawyers had a chance to drill those down. As I said before, closing arguments are the attorney's argument about what they think the evidence means and how you should do whatever it is they think you should do. So they go first, Mr. Klingler, then Mr. Osborne, then Mr. Klingler. There's like a total of 35 minutes. So I'm going to think 20, 35, 15. But Mr. Klingler can kind of manipulate his time depending on how he wants to do it. So in an hour, you'll be talking to me for about 30 minutes of instructions before you start your deliberations. That's what's ahead of you. If you take notes, just write down argument, not evidence. Go ahead, Mr. Klingler.
All right, plaintiff closing.
Morning, folks. When this trial started, I told you it was about intentional lies that are designed to hurt people. It's not about freedom of speech. It's about defamation. It's about false light defamation, intentional lies designed to hurt people. You've heard all the evidence. You've seen the witnesses. I'm not going to go over it. But I will say a few things to underscore what I think is most important for you to keep in mind as this case is turned over to you. From me, from the plaintiffs, to you. Mr. Foreman perpetuated lies intentionally, repeatedly, over 3.5 years on the internet about these 7 brave deputy sheriffs who've lived in this county for years, risked their lives for this county for years, done their job, been in the community for many, many years. Mr. Foreman did it intentionally. Mr. Foreman knew that what he posted on the internet were lies. He knew there was no theft. He knew there was no sex with Randy Walters' wife. And he
You didn't
certainly
prove that.
knew all of the stuff he's repeatedly posted about Lisa Phillips up until Friday and probably later were lies too. What are we going to do about that? Mr. Foreman told you from the witness stand, there's nothing we can do to stop him because he has freedom of speech to lie about people intentionally. During jury selection, we talked about that. And you all agreed that it's not okay to tell an intentional lie about someone that hurts them. We all agreed. And the judge is going to tell you that in the law that he gives you. So Mr. Foreman
That's what the
is
law says.
legally wrong when he says he has free speech to tell harmful lies about people and get away with it. That's just legally wrong. You also told me in jury selection that even if somebody does something to you that hurts you, that you think is wrong, like a search warrant execution that you think was unfair, even if somebody does that to you, you told me, we all agreed, that that doesn't justify telling intentional lies designed to hurt people. That's what you think. That's what the community thinks. That's what decent people think. But Mr. Foreman thinks it's okay to do what he's done over 3.5 years because they executed a search warrant that broke down his door and disconnected his cameras. You heard
The
from
judge
the witness
say.
stand from Mr. Foreman the
And the
callous indifference that he showed to what he's done, the harm he's done. It's imprinted in your minds, I'm sure, like it is in mine, the tears, the agony from some of these witnesses. Don't forget that when you're back in the jury room. That's what this case is about. You are here
Yes.
because you agreed to be here. You showed up on the first day. Not everybody does. A lot of people don't respond to their summons. You did. I asked you, do you want to be on this jury? And you all said, yes, I agreed to be on this jury. You're all here now, in this place, in this courtroom, for a reason. And I believe There's a power higher than us that brought you here today to do this job, and that you are the chosen people to do it. Nobody else is going to do it. There's not going to be another trial. There's not going to be a second chance. This is the day to decide whether Mr. Foreman gets away with what he's done, and whether these plaintiffs deserve something to make up for what they've been through, and whether the community is told that what he did is unacceptable. It's not okay. We talked about different kinds of damages. There's not going to be economic damages in this case. There's no doctor bills. There's no damaged property. There's damage to reputation. There's pain and suffering. There's public humiliation. There's everything you saw and heard from these detectives from the witness stand. And the only thing you can do as a jury to decide this case is to render a verdict of money that somehow stands in, somehow represents the harm that these deputy sheriffs have been put through over 3.5 years. That's all you can do. You can't issue an order that says stop. You can't issue an order that says, say you're sorry. All you can do is issue a verdict for an amount that fairly stands in, represents what they've been through, what they've lost. No one else is going to do it. The judge isn't going to do it. Court of Appeals isn't going to do it. It's your job. And you're the people meant to do it. Now, I told you in jury selection, if we got to this point, I'd try to give you some ideas about how to evaluate what kind of verdict might make sense in this case. I told you then, and I'll tell you now, there's no formula. There's no easy answer. But there is an answer. And it's the answer that you folks decide among yourselves fairly represents the injuries that these deputies have suffered. And I'll start by posing this question. Do you think that if there had been an advertisement in some newspaper that said, we will give you $2 million if you are willing to go through what Lisa Phillips has been through for the last 3.5 years? Would you take that deal? Do you think she would have taken that deal? Yeah,
I do. You just said render a verdict of money.
Maybe I'll go through that. Of course not. Do you think Randy Walters? Do you think Brian Newland? Do you think any of these deputies would have accepted some amount of money in order to go through, in exchange for going through what they've been through? I don't think so. And I think you know nothing is worth going through what they've been through. And, of course, He says he's not going to stop. He says nothing can stop him. Maybe something can stop him if you tell him through your verdict that he needs to stop. I'm going to tell you what I believe is a fair verdict for these plaintiffs. And it's up to you, of course, again, to make the decision. But I would ask you, I'm going to ask you, and there's a verdict form which, excuse me 1 minute. Folks, I'm going to show you these forms that you're going to be filling out, just so you're familiar with them. This is just an example. You're going to have a different form for each of these plaintiffs, okay? This one happens to be a verdict form for Lisa Phillips. And I believe the evidence is overwhelming that you'll find in favor of Lisa Phillips. This happens to be her false light claim. There's a separate claim for defamation, a separate form for defamation, and you'll see the jury instructions. Judge Hein has already talked some about that with you. So this is just an example of the verdict form that I'm going to ask you all to sign in favor of Lisa Phillips and all of the plaintiffs on their false light and their defamation claims. Now, there's another form called an interrogatory, and I'm just showing you Lisa Phillips's form. And it says, we, the jury, find damages for plaintiff as follows. And then it gives a little description of the kind of damages. And there's a line for your decision, and there's signature lines for each of you to sign. For Lisa Phillips, I'm not going to show you every form. For Lisa Phillips, folks, I'm asking you to put $1.5 million
Get the heck out of here.
in that verdict form.
Get the heck out of here.
$1.5 million for Lisa Phillips from what she's been through for 3.5 years. Maybe going through for who knows how long. For Brian Newland, I'm asking you to issue a verdict for $1 million
So you think it's worse
for
to
what he's been
suggest?
through with his family, the loss of his dream job here in Adams County. For Randy Walters, I'm asking you for a verdict of $1 million for what he's been through with the allegations and vile videos about his wife.
He has
For
to be
the other
contingency.
4 plaintiffs, Sean Grooms, Sean Cooley, Justin Cooley, and Mike Estep. I'm asking you for a total for all four of them of $400,000 divided among them however you see fit based on their testimony. You, of course, can award less. You can issue a verdict for more. That's what I'm asking you to say in your verdict form based on this testimony. Now, let me close my remarks by looking into the future here and looking at the future if there's a verdict for the plaintiffs and you award the plaintiffs a fair amount of money. What happens? The plaintiffs are vindicated. The court of public opinion out there, the press, which I know you haven't been looking at, they don't know the facts. You know the facts. And a verdict for the plaintiff will say they were wronged, he was wrong. A verdict for the plaintiffs will make up in some way for what they've been through. A verdict for the plaintiffs will say that we don't condone, we don't approve, you can't get away with what Mr. Foreman's done. Not in this community, not in this country. That's not freedom of speech where we live. That's what a verdict for the plaintiffs will say. Let's look at another possible future if there were to be a verdict for the defendant, or if there were to be a verdict with a small amount of money attached to it. In that case, in that world, in that future, the world is told what he did is okay. What they went through is no big deal. We don't really care. We think it's fine. That's what a verdict for the defendant or a small verdict would say. They would go home subject to even more ridicule. Yeah, you took him on and you lost. See, what he did was fine. I don't have to tell you, you know, that's not the message we want to send. It's not the message you want to send. Folks, I'm done. I've done all I can. These folks called me 3 years ago now
And you want to get paid too.
and asked, what can we do to stop this? And here we are today. I've done what I can. They've done what they can. They've suffered through the publicity. They could have stopped this case at any time if they would have kowtowed to the pressure, public humiliation that Mr. Foreman continued to put them through, but they didn't. They bravely stood behind their case and their right not to be dragged through the mud with lies in the media. They've done all they can. And now I am giving their case and this decision to you.
Oh, Lord.
It's out of my hands. You have to decide what to say to Mr. Foreman and what to say to the community about what he's done and the effects that it's had on these folks. I have full confidence, I fully trust you to make the right decision, to make a fair decision, and to come back with a verdict that's fair for each one of these plaintiffs and that tells the community what you really think about this case. Thank you very much.
Thank you, Mr. Klingler.
Come on, Osborne.
11 minutes after that, final. And Mr. Osborne?
So the total ask was 3.9 million.
Ladies and gentlemen, thank you for being here. This has been a long 3 days. It took a second for me to even count the number. It's been so long. A lot's happened. You've done your duty as jurors. You've paid attention to the evidence. I'm proud of that. What makes our country great is you have the right to have a jury trial. You have the right to people in the community to see this, weigh the evidence, and make a decision. And I'm proud that you guys are here and doing that. We started this time, I talked about this case was about freedom of speech. But let's talk about what it's also about. It's also about music. Not all music is tasteful. Not everybody likes all music. There's some songs I hate. I think we can find plenty of people that find songs they do not like. But Mr. Foreman, Joe is a rapper and comedian. It's what he's done his whole life is rap, make songs. We got to think of what rap is, because music does not exist in a vacuum. Music evolves over time. Take a look at jazz. It's evolved. At one time, it was distinct in a certain subculture, and it has now expanded. Rap is the same. Rap started out as a means for people to express social commentary, opinions through entertainment. Look at the song by NWA, or they call it Fuck the Police. I think I said that right. It's a social commentary on what was going on in their lives. Their personal effect, the personal things happening to them, combined with entertainment, which unfortunately is exaggeration. Opinion, nothing of fact in that song. It's a commentary on society. And so when you look at rap, you see that over and over again. I had my secretary print me a couple songs, the rap songs, while I was pouring a cup of coffee. And the first one is Carly B, WAP. I find it bad to say what WAP means, but it's a popular song. I think it's somewhat derogatory. But then again, I'm not the audience for that song, and I know that. I know nothing in that song. Nothing talking about is true. I know it's entertainment. I know it's social commentary. Miss Grooms testified even her students knew that at a young age. The same thing I knew when I was watching Johnny Carson, The Late Night Show, and SNL, Saturday Night Live, with my grandfather when I was a kid. That's all entertainment. They make fun of everybody for entertainment. And some of it is a social commentary. But it is not fact. And everybody knows that. Nobody looks at Lil Wayne's song Pussy Monster and says there's a monster in that song. Everybody knows it's exaggeration for entertainment. Is he commenting on something? Sure. But it's not fact. And I can keep going. Megan Thee Stallion with sex talk. I mean, It just goes on. They use derogatory language. It's designed to entertain. Drew Hastings, former mayor of Hillsborough, was a comedian. I got to go to one of his stand-ups. Some of it was funny, some of it wasn't. Some of his jokes, like those of Eddie Murphy and Richard Pryor, some of them are not tasteful, but they're still jokes. They're not facts. And we know that. That's what a reasonable person listening to that would understand. And that's the point. This is not a vacuum. We don't live in a vacuum. Let's face it, if we lived in a vacuum, we'd all be dead because we couldn't breathe. So we live in a world full of everything, where we see things. We watch SNL. We know it's entertainment. We know it's going to pick on people. We understand that they're picking on public officials. Hell, they picked on Joe. They pick on Donald Trump all the time, Sleepy Joe. I mean, go down the list, even Teflon Ron was made fun of. So as you go back, nobody thinks that's fact. Nobody's going to take it that way. When they post their clips on YouTube, when they post their clips on Facebook, people don't look at it and go, that's the truth. No, they understand it's comedy. They understand they're going to talk about it going forward. And if you look at his posts, you see the little signs of that too. Iteration. Things that you see in a song. I mean, because after all, you know, a song's catchy, right? It has beat, song, you know, words rhyme. You know, she thinks my tractor's sexy, and, you know, sticks with you. And we listen to Lemon Pound Cake. You heard the iteration. You heard how it came together as entertainment. So we don't exist in the vacuum, and a reasonable person doesn't exist in the vacuum. As the judge has said, you are a reasonable people. You get to decide what's reasonable, which means you get to use your experience. You get to use your understanding of what those are, of your understanding of Joe, of your understanding of rap music, music in general. I'm not going to sit here and say that these 7 people were happy about what happened to them. I'm not going to say that. That'd be stupid. But what I am going to say is they are public officials. We see it on the news all the time, public officials made fun of. Let's go back to voir dire. During my voir dire, we talked about, with the one juror that's gone, we talked about that, yes, I ran for public office. She agreed I put myself out as a public official. She agreed that it was an opinion when someone called me a baby killer. Even our witnesses on the stand, I asked that question. They said a crooked defense attorney is not a vine, it's a matter of opinion. Crooked cops, dirty defense attorneys. Oh wait, one witness did want to say I might not have taken a shower. But those are all opinions, exaggerations, not statements of fact. And we know that. And that's why public officials are held to a higher standard, because that standard is what is expected of them as subjecting themselves to public scrutiny. They all testified that people have criticized their work. I mean, after all, we look at the search. There is, even Mr. Newland admitted it wasn't perfect. I think we can see from how the money was handled, the investigation, I would have liked to have seen a more thorough job myself. I mean, we have a chain of custody, the money that just leaves it laying there. Mr. Newland didn't know that. We have an unsealed evidence bag. We have 10% of all evidence, money evidence in the Adams County evidence locker miscounted. And then, keep in mind that that miscount on those is less than what is alleged to miss here. We got people saying we had a miscount, yet they can't even bother to notify the court in an official document that they made a mistake. Just let it ride. As far as the public record knows, which they never corrected, Mr. Foreman never got back all of his money. They want to talk about an investigation, but they can't even put in a single piece of paper to correct his mistake. I don't know if I call that lazy or what. But I think it goes to what you consider a fact. Because what is a fact? We can't always know what a fact is. A fact is something you can disprove, right? But can we truly disprove that? Looking at all the evidence, there is questions. If there's questions, it's not a fact. Now, people will form opinions based on that. I formed an opinion. I imagine everybody here's formed an opinion. We know that they formed an opinion because they didn't like being called a thief. So that was their opinion. But people are allowed to have opinions. People are allowed to express them. What people are expressing when they call them a thief is not a literal statement. It is not a fact. It is a social commentary on the fact that they didn't do things correctly. And they can't even articulate how they could fix it. That is a social commentary if I ever heard one. They don't like it? That's not their choice to like it or not. They're public officials. They're going to be held to a higher standard. Their work's going to be criticized. I mean, that's just what happens when you're a public official. No reasonable person would expect a police officer not to be criticized. They've all been called names before. Has it affected them personally? Yes. Miss Grooms testified it made no difference in her life. Her kids didn't take it seriously. And she's taught for damn near 30 years.
That was Miss Groom's wife. I mean, Mr.
But they
Grooms.
seem to take it seriously. And I come back to Mr. Grooms. He's worried about going out on a call and being shot. Now, maybe I'm old-fashioned. But if I'm going out on a call, I'm worried about getting shot, I'm going to call my wife and tell her to be safe! Not sit here and go, I'm worried about me. That's not what you do. You take care of your family. Mr. Walters wanted to point that out. That just goes to show us he didn't take it seriously. Now, I'm not going to say they're not afraid. Anytime they go on a call, the highway patrol will tell you, scariest thing's a traffic stop. You know nothing about the person, you're there by yourself, and things can change in an instant. Is that scary? Fuck yeah. I'd be scared. But if you're truly scared, you take the steps for it. You start having your family do stuff. You start doing that. If you believe what you're saying, you take the steps towards it. You didn't take the steps. No one else talked about how they took the steps either, did they? And why does that matter? Because a reasonable person is going to look at that. After all, let's go back to me not taking a shower. How would you know I didn't take a shower? Hair clumpy, probably matted, probably got dirt all over me. That's how you would see. That's how you would prove if that's an opinion or fact. Now, even then you might say Dave just fell in the mud. But no reasonable person would take it in the vacuum. And I want you to think about everything in context. What rap is music, how it's entertainment, how the language works on it, how jokes are made. I want you to think back to that, because that colors how you see it. I love picking on Joe. He's a good sport for it. Look at that suit. Does this look like a man who thinks that everybody's going to assume that everything he's saying is fact? I mean, he's like a comedian. He exaggerates for the sake of entertainment. That's who he is. I'm not going to say it's tasteful to everyone, but some people do find it entertaining. I asked an important question about them. I said, do you believe everything in the newspaper? No. Do you believe everything you read on the internet? No. We all know that to be true. A reasonable person knows that. People can post opinions, social commentary, and hurtful things all over the internet. And it is just to be expected. That's why we are supposed to use our own filter, use our common sense, use our experiences in life. So while hurtful, it was not fact. It was music, entertainment. Stuff that no reasonable person would understand, especially not a public official, because we see it on TV all the time. We see it on the internet. You see it on Facebook. Sometimes people want to turn off Facebook because there's so much political commentary and stuff. But that's expected. Do I expect everything I read's fact? I don't even think most of it's fact. I think it's everybody's opinion, and opinions are like assholes. Everybody has one and it stinks. But that doesn't mean they can't have it. That doesn't mean they can't express them, and that doesn't mean they can't make a song about it. Truth is a defense. That's why we talk about the theft. That's why we showed all that. because I wanted you to see how the money was handled. There's a lot of confusion around it, and for that reason. Before I get to another point, I want to address something that's bouncing around my head. Bob says, what does this message send if you find for Mr. Foreman? I rephrase that question a little differently. What does this message send if we find that music and social commentary, while maybe not the most tasteful thing in the world, is silenced because a public official, while hurt by it, yes, unhappy by it, yes, pissed off, yes, emotional, yes. What opinion does that sound? I mean, if you can sue people, music artists, comedians, to shut them down, that's what we're looking at here. I'm sorry they feel the way they do. But there's a certain amount that you have to take as a public official. It's part of the duties as a job. As we talked about during voir dire, as I've talked about them being called a baby killer, there's certain things you take and you move on. It's part of the job. The plaintiffs, or I should say Bob, talks about how they wanted it to stop. Where was the certified cease and desist letter? Where was all this done? None of that was done until after they started the lawsuit. Until after they brought it to court to make it stop. That's what they wanted to. They wanted to make it stop. Yet they asked for money. The commentary on them is nebulous at best. You can see that when you look at it. We have Beetle Bailey, Gomer Pyle, Colonel King Kong Bundy. Some of these names are not as bad as others, yes, but they're all for artistic purpose. They're all for jokes. They're all for entertainment. This is not to paint them in a real light. No reasonable person would think that.
Don't be unreasonable, sirs.
It's kind of interesting because even Mr. Newland agreed that when he was called a pedophile by Mr. Foreman, yes, that is a horrible thing to call a person. But even he said it was Mr. Foreman's opinion. So he didn't believe it was a fact. If your own witness doesn't believe it's a fact, how can a reasonable person find it's a fact? Bob went to great lengths to say nothing will stop him. Shows us where we're at. We got to stop his expression. We got to stop entertainment. We got to stop exaggeration. That's what Bob's talking about. What chilling effect does that have on the world we live in? Think about it. You don't like what a commissioner does. You don't like what our prosecutor does. You don't like what any public official does, and you make a joke, and you're drugging the court. It may not have been a tasteful joke. It may have been a bad joke. It may have been the greatest joke ever. But what we're saying is if they don't like it, we're back here. What does that say to freedom of speech? What does that say to the world we live in? That's what this case is about. And Bob knows that. That's why he mentions it. That's why when you look at defamation and the jury instructions, you'll see that the first element of it is a statement. Portrayal of fact. Has to be portrayed as fact. No music video portrays as a fact. I don't watch Fuck Those Police and turn around and say, you know what, that's a fact. No. I say that's a song and it's entertainment and move on. Sometimes I try to figure out what the words mean, you know, what kind they're getting at, but I don't expect them to present a fact. Fourth element is the proximate cause. It's an interesting question there, because you'll get the definition of causation and proximate. And we never talked about that really during the trial, and it's going to be something that I want to discuss. They talked about getting phone calls. None of those posts. Joe never said, call them and tell them this. Mr. Cooley testified that they mailed pound cakes to the office. Joe never said send them a lemon pound cake. These are things that other people have done. Joe never directed them to do it. He didn't cause it. He made a joke. He cannot control how people take it. What they do, he's not that. All he can do is make a joke, make a song. So that's something to consider. Was he the proximate cause, or was it someone else? I want you to understand, when they get to the question of malice, if you get that far, it has to be actual malice. Public officials, it's a higher standard. Why? Because we hold public officials to a high standard. Let's talk about the false light. That's their second cause of action. That says that a reasonable person would be justified in the eyes of the community, feeling seriously offended and aggrieved. I want you to go in on the eyes of the community. They want to say people's humiliating them, calling them names. The reality is a reasonable person in the eyes of the community is going to say, it's a song. It's a joke. I was flabbergasted to hear it myself, that they even thought it was a joke before they brought the lawsuit. Go to a Halloween party and bring a lemon pound cake. That, I almost have no words for that, honestly, because I get, we're hurt, but it's a joke. Which one is it? So a reasonable person in the eyes of the community would understand it's a joke. Mr. Estep testified about the joke of the shirt. We got the pound cake joke. There's various jokes for this. This was not as negative. This has not changed their view in the eyes of the community, because your reputation, which is what they claim is hurt, your reputation is like a shirt. You eat a hot dog, you drop mustard on it, you get stains on your shirt. Nobody's reputation is clean. Everything you do affects your reputation. The way you perform your job affects your reputation. They all admitted to that on the stand, because I asked that question. They all said it does. How they counted that money affects their reputation. People can form opinions based on how they did their job and criticize them on it. That's a right we have. You have to forgive me, I have to flip through these some. We didn't have a lot of time to prepare as things change on the fly. I think as you go back and deliberate, take a look at all the exhibits, analyze it in the context of music, entertainment, opinion, social commentary. It's not a fact. And if you look at it, you can see that. Like I said, it may not be tasteful, may not be nice, but even SNL's not nice. South Park's not nice. These things are social commentaries, jokes, entertainment, and some of them are not nice. But you don't have to like everything. You don't have to like everything said about you, and you don't have the right to tell everybody that everything said about you should be sued for, especially if you're a public official. As such, I ask you to deliver a verdict in Joe's favor on all claims. I ask that because when you look at it, no reasonable person could see it as a fact. No reasonable person could see it as even false light. The community, if they called them, if people called them, that's because the social commentary resonated with someone, resonated with what people experienced in the world.
In this community.
We've lived through a turbulent year, so we've all seen on the news what people are experiencing all over the country. Social commentary resonates because of that. That doesn't make him the proximate cause. That shows a deeper concern in our country that we should be addressing, not sitting here trying to decide if a music video is a fact or not. That's what's at issue here. And I'm confident as you go back in deliberations, you'll come to that conclusion too. And with that, I thank you again for your service, because it is not easy, and what you're about to do is not easy. It takes time and deliberation. It takes hard work. And I appreciate that you guys are willing to do it. And I reiterate again, that's what makes us a great country. Thank you very much.
Mr. Osborne? Go ahead, Mr. Klingler.
Thank you, Your Honor. Nothing Mr. Osborne said about sexually explicit songs out in society refer to specific people in the community, like the songs that are at issue here. It's not the same thing. We all know that. These weren't opinions. Mr. Foreman didn't say, in my opinion, Brian Newland is a pedophile. In my opinion, they're all thieves. In my opinion, I fucked his wife doggy style. He said it like they were facts. And I think Judge Hein is going to instruct you, based on everything that's happened so far, that these were not opinions, they were stated as fact, and your job is to decide whether those facts were true or not. And we know they're not. The case isn't about lemon pound cake. It's about intentional lies designed to hurt people, and they hurt people. If somebody in the jury room says, well, what about his First Amendment rights? You know, and the law tells you, that doesn't allow lies that hurt people. If someone tells you it's just artistic expression, he ought to be free to say what he wants, the answer is he's not allowed to wrap up harmful lies into songs, so-called art, put them out there, and get away with it. The packaging of the lie doesn't make it okay. The message was clear. And Mr. Foreman doesn't get to wrap himself in the American flag
Yes, he does.
and say, you can't touch me, I can say what I want, no matter how untrue it is, no matter how much pain it causes people, no matter for how long, because I have freedom of speech. He can't do that. I'm confident you'll tell him he can't do that. Thank you.
I think there's concern they might tell him something, but I don't think the elements have been met.
Let me acknowledge Mr. Osborne.
Your Honor, I didn't mean to interrupt you. My thing is, I was going to ask before we read the jury instructions if I could if we could have a restroom break for that, because I know it's going to take some time to read it.
Everybody's going to stand.
Look at
in their
him. Why is he
seat.
sitting like that? Hold on. Look at what.
Everybody's going to stand in their seat and stretch. Nobody's going to leave the room but you. Because you're pretty prompt with that, so go for it.
Thank you.
I'll just stand
This
up.
whole thing is a mess.
That one's true.
Oh, you're on my team.
So if anybody missed it earlier, the judge had opined on his decision to deny the defense motion for directed verdict, a dismissal on some of the counts. he opined on his reasoning in front of the jury. You know, he finds that it's enough. There's sufficient evidence to go to the jury. And the jury might not understand the difference between a judge saying sufficient to go to the fact finder versus I think there's sufficient facts that these elements were proven. So to me, it was extremely inappropriate for him to opine like that in front of the jury. And then you've got this attorney in closing arguments like, you need to tell Joseph Foreman he can't do that. The judge is going to instruct you. And I don't know. I think there's major issues with that. And unfortunately, you know, it could translate into a verdict that's favorable for the plaintiffs. And I don't personally think that the elements are met there, especially for damages. Like, even if we say, all right, all the elements of defamation are met and there were some damages, what exactly would the damages even be? We really heard no information, no testimony about a loss of income except for the one guy who said he was unemployed, and it's not clear if he's unemployed because of anything to do with Joseph Foreman. And it's kind of weird to assume that it would be if the others are still employed. So, yeah, I think there's appeal issues for a few reasons here. And one of the reasons, you guys, it seems like the sentiment in the chat shifted. Like, it's been a lot of like, yeah, like free speech, and then the sentiment shifted when the defense attorney was starting to drop names. And I really think I thought he did it in a neutral way. He mentioned both Trump and Biden, right? That's clearly somebody trying to give examples on either end of the extreme spectrum in case somebody has an adverse reaction. But right around that moment, it felt like some of the chat veered back. And I think it'd be a good moment to have some self-awareness. Like, just because we hear a certain name dropped, should we really lose the message about First Amendment, about being able to comment on public officials? Also, the related point that everything you read on the internet, just because you're reading something doesn't mean that it's true. You know, kind of something that is not really as much a legal question as maybe something that we should walk with in our daily lives as we take in information. And what's so critical for this attorney to be doing is, if this has to go up on appeal, we've heard this attorney several times raise an issue with Ohio's, they recently passed in 2025, their own version of anti-SLAPP. And they're pushing the artistry. Afroman himself is a public figure. He's speaking as part of his artistry against what he saw these public officers do. And so part of what he's arguing in his closing is he's showing the emphasis and how important it was, each of these different characteristics, because my suspicion is if he does have to argue this up on appeal, he'll be able to point back to the record and say, these things that would fall under UEAPA, the new Ohio anti-SLAPP, match the facts of this case that we're here to appeal. And we had asked the judge during trial, at least for the newer exhibits, hey, because of this new statute that's been enacted in the spring of 2025, this Lisa Lickum video that came out a week ago, the court, they should have done an analysis under the three-prong analysis that they're supposed to follow under this anti-SLAPP, and they declined to do so. And we take issue with that. And not only that, but it's an important issue because that Lisa Lickum video from a week ago, after the anti-SLAPP statute that the judge didn't apply the analysis to, is something that the plaintiff relied on heavily in their closing when they asked for liability and damages. And really, the plaintiff's attorney didn't ask to find him liable. They said make him stop and also render a verdict of money. And then also we're hearing the defense attorney emphasize in his closing the points that he would argue if this is up on appeal. So, yeah. Anyway, yeah. Also, I don't know. I feel like the plaintiff was prepared for his rebuttal closing. Like, he was ready to say that, but wasn't necessarily prepared to do his first closing. And likewise, the defense attorney said, hey, kind of wasn't prepared. I got to shuffle through these papers. Because I think all of us are like, all right, we had a witness called by the defense, and then they rested. There's no rebuttal case. We're done. That was quick. I think that feeling was shared amongst the parties. So there is a poll up in the chat. We'll leave it up for a few more minutes here where you guys get to vote how you would vote, and then we'll do a prediction vote where you guys get to vote what you think the jury will end up doing. Remember, in a case like this, since it's civil, and we're in Ohio, it's civil, the jury, there's 8 people that will be deliberating. There are 2 alternates. I have no information about jury makeup, so sorry about that. We will continue to watch voir dire and see if we get any hints. But right now the poll is how you would vote. It's what you would do if you were back there. So simplified options: not liable, liable lots of money, liable tiny award or nothing. So go ahead, get your votes in. And again, if you want to do the prediction one, remember the prediction vote will come later. Always got to distinguish. So me personally, I would vote not liable. And a large part of that, I feel like maybe I could see 6 out of 8 wanting to award something maybe to Brian Newland, wanting to award something maybe to Lisa. The monetary amounts being asked for, it just seems like a knee-jerk, you hurt someone's feelings, here's some money because you probably have a lot of money and it's not our money. I don't really think there'd be a logical way to get to those damages. There was nothing presented that shows to me that even thousands of dollars in damages were incurred on any of these plaintiffs because of anything that Afroman did. I think the proximate cause argument was great from the defense attorney, because if he didn't go into that argument, imagine being back there, you're sitting there with 8 people, only 6 need to decide to render a verdict. So if 6 agree not liable, if 6 agree liable, they can render a verdict on one of the causes of action. Only 6 of 8 are required. And if you're back there and you're trying to figure out proximate cause, especially if this judge is going to kind of opine, if he stops midway and wants to give his own version of what he thinks this jury should do when they evaluate proximate cause, and if Afroman, his actions gave rise proximately to some person calling these people and saying, hey, you're a thief, I think it's very important that the defense attorney laid that out. Because somebody out there could be like, hey, well, if that music video didn't exist, nobody would think to send somebody a pound cake. Well, that's not how you're supposed to look at proximate cause. There was no agency in the conscious choice of the person that may or may not have even called these people, because it's just hearsay. There's no proof. Nobody presented proof that somebody was making threats on these people. These are police officers that claimed in their testimony that people are creating like reasons for physical concern, like physical harm, death threats. But they don't arrest anybody, so I find that hard to believe that was actually happening. Oh, it is back, okay. Is it? Okay, it's being weird. It had to refresh. But yeah, I think that proximate cause definition was very, very important. And I agree, we must be able to address our grievances with the government. At the end of the day, proximate cause, would we be here if that raid didn't happen? They weren't trying to disconnect a surveillance system. Would the Lisa Lickham Lowe video even exist if this lawsuit wasn't going on and on and on? So, oh gosh, sorry.
In the door. And then the court refines the instructions to account for the conduct of the trial. So to the extent that they might have gotten the instructions very quickly this morning, it's not that they didn't know it, it's the refinements, the little tweaks along the way. That's what they're talking about. But I want to thank them because they did good work making it possible for me to get to the point where I can give these instructions to you. The court has the legal duty to prepare the instructions of law. You've heard the attorney's statements, arguments, you've heard the evidence from the witnesses. The court's duty is to instruct you on the law. And then you have a legal obligation to accept the instructions the way they're given to you. It's your sworn duty to do that. You cannot apply what you think the law ought to be. You're obedient, as I am obedient, to the rules of the law.
I mean,
A person who claims that certain facts exist, in this case the plaintiffs, have to prove them, in this case, by what's called the preponderance of the evidence. You've heard me say this before. I'm going to try to go over things you know. But the obligation is called the burden of proof. Plaintiffs have to prove their facts by a preponderance of the evidence. Preponderance is more evidence in favor of their position than opposed to their position, tilting the scales in their favor. There's one element that has a different burden of proof. Clear and convincing evidence, a higher amount, a greater weight of evidence has to be proven with regard to the knowledge or the motive for publishing. But generally think, okay, can the plaintiffs prove their case by slightly more evidence in their favor than evidence opposed to them? There are two claims, what we've called defamation, and secondly, false light, invasion of privacy. In your deliberations, each of those claims is deliberated separately because there's separate rules for each. I'll give you more. But there's separate law for each of those separate claims. There's 7 plaintiffs, each of whom is entitled to their own deliberation. So when I refer to plaintiff or plaintiffs, what I'm saying to you is that side of the room, but you always have to apply these facts individually and separately deliberate each person's claims. If you rule in favor of one plaintiff, it doesn't mean you have to rule for all the rest of them. And if you rule against one plaintiff, it doesn't mean you have to rule against all of them. So it's not like an all or nothing verdict. It's 7 deliberations. And I'll use plaintiff and plaintiffs interchangeably, just understand the analysis and what I'm trying to communicate to you. So to go back to burden of proof, preponderance is the greater weight of the evidence, evidence that you believe outweighs or is overbalanced by the evidence opposed to it. A preponderance of the evidence is evidence which is more probative, more probable, more persuasive. It has greater evidence value to you. Look at the quality of the evidence, not simply the quantity. If it was only about quantity, there would be more plaintiff witnesses than defendant witnesses, so you'd think, oh, just because of the number of witnesses, someone must prevail, when in fact you look at the quality of the evidence. Don't get hung up on which side called the witnesses. Think about the quality of the testimony, what you took from it, regardless of numbers, regardless of where it came from. If it would turn out in your mind that there's an equal balancing, the evidence opposed to it and in favor are equal, then the plaintiffs have not met their burden of proof because they didn't tip the scale slightly in their favor.
slightly.
If you could decide a fact or an item in 2 different ways, you have to decide it based upon the facts, not guesswork or coin flips or I don't care. So in those areas where it's hard or it's difficult to resolve, you have to resolve it. You can't leave it up to I don't care and I'll just flip a coin or it doesn't matter. Guesswork's not what you're expected to do. The heavy work of sorting out the facts and deciding which side of the scale they go on is the role of the jury. Now, when we talk about preponderance, slightly shifting, we also have to talk about clear and convincing evidence, a different standard for that one element of motive to publish. Clear and convincing evidence is a higher or greater amount of evidence. You have to be more convinced. Clear and convincing means the evidence produces in your mind a firm belief or a firm conviction that that item is true. So preponderance might be, by example, slightly tipping the scales. Firmly convinced is more convinced, greater evidence offered by the plaintiffs with regard to the motive or the knowledge of publication. What's the evidence of trial? Evidence is testimony and exhibits. Evidence is direct and circumstantial. People scratch their heads on this, but it makes sense later. Direct evidence is when a witness has an opportunity to see or hear those things about which they testify. I sat here, I watched the jury take their notebooks and write in their notebooks. Direct evidence, an eyewitness. Circumstantial evidence is different. Circumstantial evidence is when you look at the facts and circumstances surrounding something you saw, and then you make a conclusion that something else actually occurred. I saw the jury box empty, I saw the pencils, I saw the notebooks, I saw the end of the day, the notebooks were all open, there were words written there, so it's circumstantial evidence that the jury took notes. I didn't see you take notes, but from the facts and circumstances that I did see, it's a reasonable conclusion of fact that you did take notes. Why do I tell you that? Most evidence came at you both directly and circumstantially. Things that I personally saw, and then things that happened as a result of what I saw. Circumstantial evidence is fair game as much as direct evidence. Direct evidence isn't better. You might think it's better when in fact it's not always better, because the witness didn't tell you that they were blind when you thought they saw something, or it was foggy, or the lights were bad. So when you think about the evidence and how to weigh the quality of it, what a person saw, what they heard, what they personally experienced is good evidence, direct evidence. But so is the circumstances around that testimony. They're both fair game. Often people infer that something exists based upon the circumstances and inferences. I inferred it's a reasonable circumstantial evidence that you wrote in your notebooks. That's fair. But I'm not allowed to infer, because you took notes, therefore you also did something else. You can't stack an inference that something else occurred on top of something else you thought occurred, on top of something else that could have occurred. The idea here is what we call remoteness. It gets more and more unreliable the more remote you get from the first circumstantial evidence. If you want to say the circumstantial evidence is reliable, great. If you want to infer that that's reasonable, great. But don't stack another, well, now I suppose something else happened, and if that happened, then something else should have happened. It's stacking, it's called remoteness, then it gets unreliable. With regard to the exhibits, you saw exhibits, there was testimony related to them. Consider whether the exhibits are in fact what they are portrayed to be. You decide what weight, if any, the exhibits have to have when thinking about the testimony involving them. Exhibits in video can speak themselves, but sometimes paper and other exhibits don't. So you have to consider what the witness said in light of how the exhibit was portrayed. Don't make inferences or conclusions based upon the number of exhibits. Remember, I want you to look at the quality, not just simply the number. Like theoretically, the plaintiffs had more number of exhibits than the defendant. Don't care, don't count numbers. Look at the quality, make the content important. You'll have like physical, tangible paper exhibits back there. When you get to the video or the data-driven exhibits, you'll have a computer back there so you can use that to look at the exhibits. So if it never works that way, so I always offer the bailiff services that he can come back and, as you saw, make the technology work. So if you struggle back there with plugging in a thumb drive and finding the drive and then turning it on, we would expect that. I'll tell you how to communicate with us, but just ask for help. We'll send back a very capable bailiff and he'll save the day. Evidence is not what the lawyers say. You heard opening statements, closing arguments. That's not evidence. It's helpful, it's necessary, it's built into the system, but it's not evidence. If a statement was asked and the question was not answered, there's no evidence from the question. I did that once or twice to show you how it works. Just, you might have thought the answer was going to be yes because the witness was shaking their head yes. The witness is, yeah, I understand the question, and the answer is no. So you can't use body language to get an answer that wasn't spoken from the record. I don't think that happened too often. But remember where the evidence is. It's the exhibits and the witness statement, not the lawyering side of the case. There was times where I sustained objections and handled the lawyers the way I thought was necessary. I always ask people to apologize or accept my apology if you thought how I handled the lawyers is any kind of a comment upon the quality of the case. Like, I try not to do that. But you might misunderstand that in scolding a witness or handling a lawyer, I was expressing an opinion. I love it when you guys show up because I don't have to decide. It's like I always try to make
So
sure
it is
I'm
an opinion then?
neutral in my facial expressions and my voice tone, but sometimes I just don't get that done. An important role for the jurors is to weigh credibility. Credibility is assigning believability, assigning weight to the evidence, assigning weight to the witness testimony, assigning weight to the exhibits. When you weigh evidence, you're basically deciding truthfulness, and as odd as it sounds, it's what we do all the time. We weigh credibility continuously each day. In weighing credibility, you should look at, consider the appearance of the witness on the stand. Consider the manner in which they testified. Did it seem straightforward? Did it seem honest? Did it seem evasive? What did it seem to you? So you're using your eyes and you're using ears to weigh credibility. Think about how reasonable their testimony was in light of the subject matter of the trial. Consider education, interest, bias. Consider if they were frank with you or not. We use these tests every day to decide whether we want to rely upon or find a person believable or not. As I told you before, every witness took an oath to be honest in their testimony. The oath does not bind you that just because they're talking, I have to believe it. In fact, you have to parse it out, because people could very honestly get up and say, I believe this to be true, when in fact they're misunderstood and wrong, not lying. So recognize you can parse the evidence. You can believe everything a witness said. You can believe nothing a witness said. You can pull out the pieces you think are credible and ignore those that you think are not credible. And then you shuffle that entire deck with every witness along the way. As a rule, we want people only to testify, general rule, about things they heard and experienced and saw, firsthand testimony. So that's the general rule. But then we violate that general rule because we let people express their opinions about what the facts or circumstances mean that they experienced. So in deciding what their opinion means and how you weigh their opinion, you do the same thing. You're allowed to hear their opinion. It's evidence. But you have to, again, parse it out in terms of the credibility test. A person can give you an opinion, and you might go, I don't believe that because that's not in their subject matter, or they don't have enough knowledge, or their emotions got the better of them, or they have an interest or a bias or whatever. And you might go, no, it's a completely valid opinion because of whatever credibility factors you have. So we give you direct testimony, we give you circumstantial, we give you opinions, and then tell you to weigh out those things that you find believable, credible, and otherwise. In this process, the jury sits around as a committee. And it might be that you find a person credible, the other person finds somewhat credible, and the other person finds not credible. Expect that to happen. And then resolve those differences back there. There's more about that later, but in this whole deliberation process, that's normal. Somebody said while they were here, yeah, I'd served on jury. No, it wasn't easy. It's not meant to be easy. It's important. I just have to explain the rules enough and then tell you don't get your feelings hurt when you get back there and begin the discussion. The instructions I gave you so far would be relatively common in most trials, because those are general rules for how to do the job as a juror. The next set of instructions in the middle, I call substantive instructions. These are the law that applies, the rules that apply to this set of facts, these claims. You'll have sets of these instructions to go back over, so I have to read them to you in the party's presence, but you're not expected to remember all this. You'll have your opportunities to go back over it and get schooled later. So these are the substantive instructions. Again, two claims. One's called defamation. The other's called invasion of privacy based upon this false light publicity. They have separate instructions. I put them right next to each other. But the rules for the one claim are not the same as the other. There's overlap, but they are a separate set of rules. So don't apply the rules for defamation to the false light publicity claim, because you went across the line of their two separate causes of action. With regard to defamation, each plaintiff claims the defendant defamed him or her that then caused them damages. To establish defamation, each plaintiff must show that a statement, that could be oral, written, video, was portrayed a fact that was published. So the statement was made, or statement of fact was portrayed and published. Second, that the statement was untrue. Third, that the defendant acted with malice, actual malice, or reckless regard for knowledge of the truthfulness, and that they suffered injury. I'm going to break those four apart. Okay, so again, the statement was portrayed as a fact. It has to be published, so that's all rolls together. That the statement was untrue. The defendant acted with either actual malice or reckless regard about the truthfulness of it, and then that caused injury. Plaintiffs are considered public officials. You heard a lot of that. So that's where the clear and convincing evidence standard applies. So what you're doing is taking on the element of the defendant acted with malice or reckless disregard about the truthfulness of it. That's the higher clear and convincing proof. So on that element, it's not just a preponderance. On that third element, it's thoroughly convinced about his motive for publication. Clear and convincing evidence means you're thoroughly convinced about the truthfulness of motive for making or publishing the statement. What's actual malice? This knowledge in the publication. Actual malice occurs when the defendant makes a false statement with knowledge it's false. The second part of that test, it's either published with actual malice or published with a reckless disregard about the truthfulness or not. So reckless disregard means that a defendant acted while aware that the statement was probably false, or that the defendant entertained serious doubts about the truthfulness and didn't inquire. The defendant's failure to investigate may be considered evidence of reckless disregard or evidence of falsity when the defendant had serious doubt about whether it was truthful or not. So actual knowledge of falseness or reckless disregard about something that's probably false. Those elements have to be proven by the higher amount of evidence. A statement is false when it's not substantially true. It's substantially true when the essence of the statement is true when you think about the statement as a whole. The defendant's statements or portrayals must be given their ordinary meaning in that context, in that circumstance. So you can't just pull a line out. You have to look at the whole portrayal of the statement. In deciding whether the statement is false, you're not to consider the defendant's subjective belief. You consider whether it's true or false from an objectively reasonable perspective. So it's your perspective about truthfulness, not what the defendant thought at the time, because we can all think of things that are unreasonably thought. So we apply an outside standard, an objective standard, not the defendant's subjective belief. Now, this idea about the concept of truthfulness is where we find the fact that truth is a defense. So if the statement is true, then there can be no defamation. Plaintiffs also have to prove that the statements were published, portrayed, made. Published means that the statement was read or heard by another person other than the plaintiffs. From the testimony, as a matter of law, the courts has determined that publishing or portrayal is not an issue. Nobody pushed back. It's not anything you have to decide. I'm telling you as a matter of law, that element is uncontroverted, that the defendant published, the defendant portrayed the statement. So of those four, one's been resolved by the court because there's no contrary evidence. Now you're down to analyzing those three statements, elements, if you will. You need to know how to differentiate between facts and opinion. In a defamation claim, this is important. This is over on this side of the first claim, fact versus opinion. The distinction between portraying a statement of fact and portraying a statement as opinion is crucial. It's an important distinction. Portraying a fact or portraying an opinion. Only statements of fact can be the basis for a defamation claim. Statements of fact could be untrue, which is the nature of a defamation claim. If I'm expressing an opinion, there's no way to decide whether it's true or untrue, so you can't defame someone in expressing an opinion because there's nothing verifiable about it. It's an opinion. So a defamation claim has to involve an untrue fact. To determine whether a statement is fact or opinion, you apply these four factors in their whole text. You look at the specific statement, the language in the statement. Consider, importantly, whether that statement is verifiable or not. Then apply the general context of the statement, and then think about not only the context of the statement, but then the broader, how the statement could be received or heard. Start with the statement, is it verifiable? Consider the circumstances of the statement in its context, and then go farther out to the statement's circumstances in general. Look at the precise wording. Determine whether a reasonable hearer or listener would view the words as portraying fact or portraying opinion. If a statement is made and it's considered an opinion because it's not verifiable, there could be no defamation. If a statement is made and it contains verifiable information, then it can be the subject of a defamation claim if the verifiable statement is untrue. If you find that the statement was portrayed to the public as a fact, that the portrayal was false, it's a fact and it's false, plaintiffs have proven their case. If you find that it's not a fact, or that the fact was true, then the defendant prevails. This is why I give it to you in writing.
Okay, I forgot about that.
General instructions for defamation are done. This is why I give it to you in writing.
Okay, I forgot about that.
General instructions for defamation are done. Those rules apply to that claim. These rules apply to the invasion of privacy false light claim. There's only one place where I'm going to tell you to overlap the instructions. But so don't overlap all the first instructions in the second bucket, separate set of rules. The person who invades the right of privacy of another person can be subject to liability and the harm that comes from invading that other person's right of privacy. The right of privacy is the right of a person to be left alone. It's the right to be free from the unwarranted appropriation or the exploitation of a person's personality or their private affairs in such a manner as to outrage or cause mental suffering, some sort of shame or humiliation to the person. Each plaintiff claims the defendant violated his or her right to privacy by publicizing false information that places them in a false light in the public. Each plaintiff must prove that the false light in which they were placed would be highly offensive. It's a highly offensive place to a reasonable person. Not their subjective, but would a reasonable person find that they were put in a highly offensive place. And the defendant had knowledge of or acted with reckless disregard to the falsity of the publicized matter. Reckless disregard, falsity, and actual knowledge are the same definitions from the first section. So that part of the first instructions you can carry over. Actual knowledge, reckless disregard, and falsity, I'm not going to redefine. That part you would read over. But it's a different test. Was the particular plaintiff put in a false light by the false information? False light means the defendants know that the plaintiff, as a reasonable person, would be justified in feeling seriously offended and aggrieved by the publicity. Seriously offended and aggrieved by the publicity. The plaintiff's privacy is not invaded when it's an unimportant statement that's made. It's only when there's such a major misrepresentation of the plaintiff's character, history, activity, some fact, that it might be reasonably expected that a reasonable person would be highly offended. Determine whether the statements made by the defendant would place a reasonable person in a position of false light, not merely whether the plaintiff believed they were in a false light. So this is the objective perspective that we use for juries. You're the outside public looking in. Do you consider it reasonable or not that they would be highly offended? It's not their subjective belief, it's the public's perception. To be highly offensive, the plaintiff must be justified in the eyes of the community as feeling seriously offended and aggrieved by the publicity. The statement must be such a major misrepresentation of their character, of their history, of their activities, of their beliefs or facts about them, that they would be seriously offended in the eyes of a reasonable person of the public. False has the same definitions I gave you, not substantially untrue. The fact versus opinion distinction doesn't apply from that, so you don't have to do the fact versus opinion analysis. If you find that any one or more of the plaintiffs proved all the elements of false light, invasion of privacy, then you would enter a verdict in their favor. If you find that any one or more of the plaintiffs did not prove all the elements of false light, invasion of privacy, then you would rule in the defendant's favor. I'll say it again, there's 7 determinations on false light, there's 7 determinations on defamation, and you make them separately. If you find for a plaintiff on either one or both of their claims, then you go to the question of whether the defamation or the invasion of privacy caused damages. There always has to be a connection between the false statement and the damage, or the false light offensive position they were put into, and the damages. A person who seeks to recover damages must prove not only that the other party caused the harm, but also that the conduct proximately caused them injury. Proximate cause is an act that in its natural and logical sequence caused the injury. There was an example of the defendant could have caused, but was something else actually the cause. You have to sort out whether the person's injury came from the defendant's conduct or came from somewhere else. With regard to damages, the purposes of damages are to compensate a plaintiff for injury to their reputation, for any kind of monetary loss, for emotional distress, so it's compensation, to vindicate the plaintiff, which helps restore their reputation, and to dissuade others from publishing defamation statements or false light statements. If you find that any one or more of the plaintiffs' claims should be ruled in their favor, then you have to have the greater weight of the evidence, a preponderance of the evidence about the amount, not clear and convincing proof about damages, but in your deliberations, slightly more evidence in favor of the amount to award is the test, the burden of proof. Take into consideration all the facts and circumstances and evidence, decide what amount of compensation should be awarded to each particular defendant or plaintiff. These are the kind of types or examples for which you can award money. Harm to their reputation, including exposure to public hatred, public contempt, ridicule, or public scorn, and or loss of professional income and or out-of-pocket expenses, and or physical, mental anguish, pain, and suffering, loss of society, companionship, and friendship. Those are all eligible factors or categories by which to compare or measure damages. It could be that the award of damages is not easily determinable and you can't put an amount on it. You can still order what's called nominal, or I'm going to use the word token damage.
$3.
So if you find in favor of the plaintiff, then you have essentially the opportunity to go from 1 to wherever. Nominal or token would be the 1 or 10 or some low amount as a statement that they prevailed and entitled to damages, but you're not bound by anything more than 1 in your deliberations. But if you find for a plaintiff, then there has to be an award for damages, assuming there's a causal link between the defamation or the false light and injury or harm to reputation, emotions, etc. As a matter of law, the court determined previously that the claimed damage to the defendant's home was permitted under the circumstances of serving the search warrant. Therefore, you do not make a reduction for any damage that the defendant said happened to his home during the search warrant. The court previously found, as a matter of law, that that's expected or permitted as a result of serving the search warrant. So you don't subtract based upon whatever you think happened to his home. In your deliberations, a plaintiff cannot have double recovery. If you find defamation and invasion of false light privacy, you don't issue an award under each category. You can't award pain and suffering, say this, emotional distress once and then emotional distress twice. You would issue one order as long as there's either a claim for defamation or a claim for false light, invasion of privacy. Don't double up if a plaintiff prevailed on both claims. Your verdict form doesn't really make that possible. You'll get there, we're getting close. Another concept that came up earlier was something called punitive damages. You are advised that punitive damages are not a part of the deliberations given to you right now. I haven't talked about punitive damages. Punitive damages are meant to be punishment damages for conduct. That's not a part of your deliberations. You're deliberating what we call compensatory injury-related damages. An award of punitive damages can only be given if there is a compensatory damage award. If a compensatory damage award is given, then you come back with a different set of instructions and you have arguably a second deliberation about punitive damage. You don't have to award it, but they aren't all lumped in. So don't think in this first phase, oh, the punishers are really mad. That's not where we are. If you find any plaintiff prevails on either claim and it caused injury, compensatory, actual repair damages, if you will, are what we're here for, not punishment. That's a second deliberation. The verdict forms aren't that hard to understand once you know what you're doing. Each plaintiff has 3 pages. Page 1 is the claim for defamation. We, the jury, being duly impaneled, find in favor of, and then it says Sean Cooley or defendant, circle 1. So you have to circle whether the defendant prevailed on Sean Cooley's claim for defamation. And then there's signature lines. Regardless of that verdict, you go to the second claim. So the next form is we, the jury, find in favor of Sean Cooley or defendant for the false light claim. The instructions at the bottom of each page say, now go to the next page. If you find for the plaintiff on either of the first 2 forms, then you go to form number 3, which is damages. Damages is 1 line, where you put a number in. You can take notes and you can split it out, you can do calculations, and you can decide how you get to it, but there's 1 line. So that would be for Sean Cooley, and it says Sean Cooley on the first 3 pages. And then the next 3 pages say Justin Cooley, same 3 pages. So the first 2 pages find in favor of that plaintiff or the defendant, circle 1. Next one in favor of that plaintiff or defendant on the second claim, circle 1 of those options. And then you go to the damages form only if the plaintiff prevailed on one of the first 2. They're all numbered, they all have names on it, they should be easy to follow. You can tell me later. What do you do when you go back there? The first thing officially you need to do is pick a foreperson. Now the foreperson's not the shop foreman, they're not the boss. They don't tell you what to do. The foreperson's job is to organize the discussion, engage people, keep track of the exhibits, be the committee chairman. But the foreperson doesn't convince you to do what they want, they organize the discussion. There's no way to pick a foreperson. You can arm wrestle, throw fingers, draw names out of a hat. Don't go to the bathroom first, because you very well could come out the foreperson. I don't care. I've heard people say that. They pick them because they weren't there. It doesn't matter. I can't tell you how to pick one. Just get one. Throwing fingers is fine. It takes too long. You probably already know who's willing to do it, or maybe you've talked to each other enough, or you just say, sorry, you lose, you're it. But it's just organizing discussion. That's all it is. Just organize the discussion. Make sure nothing leaves. You'll have in your possession the verdict forms, the exhibits. You'll have copies of these instructions. Keep all that back there. When you come out, the only thing left to bring back out here should be all these verdict forms. Leave your notebooks back there. Everything else in the foreperson should make sure that that goes on. How do you deliberate? Generally, the advice to you is to go back there and start talking about the case, replay the witnesses, but don't just say, I think something ought to happen. When you come out with your first opinion and then start discussing it, a lot of people realize their first opinion is not their best opinion. But once you threw it out there, then you got to figure out how do I get my pride back and retool. So generally, don't go back there and just say, here's what we ought to do. What do you think about this witness, and how did this one come across, and do you understand the rules? And start into this discussion process, however you can do it. But eventually, then you're going to need to start getting to the point where you see a consensus is being built. If you immediately express an opinion, changing is sometimes hard, so work together to build a consensus. Consult with one another in the jury room, deliberate with the view of reaching an agreement. You can do so as a group, but without surrendering your own conviction. Each of you ultimately has to decide this case for themselves in this deliberation process. You might find somebody leaning on you to change your opinion. That's good. unless you feel pressured against your will to change your opinion. If they come at you with good arguments, maybe you should rethink your position because their arguments really are good. So a certain amount of give and take and tension is usually the sign of a good deliberation. Just don't take it personally. Never surrender your own personal convictions just to get along. Don't be influenced by considerations of sympathy or prejudice. The law does not expect us to be robots and have no sympathy, no emotions, no prejudice, or no biases. That happens all the time. You have to set those aside. You're required to disregard them, to make your verdict carefully, to weigh the evidence, consider disputed questions of fact, apply the law to try to reach a verdict which the parties would be considering fair to both sides. Fairness is a big thing. Is this verdict fair to both the parties? Consider all the evidence regardless of who brought it forward. Do so with intelligence, impartiality, without bias, without sympathy, without prejudice. During the deliberations, if you have questions, you're welcome to write them down, which then comes to me, which goes to the lawyers to get you an answer. Like a magic doorbell. Knock on the door. Okay? The bailiff's like within earshot. He doesn't have his cup up against the door. So like pound on the door enough to get his attention. He'll come back, get the question, give it to me, I'll huddle with the lawyers, get you an answer. So when you get back there, there's a problem, you don't understand something, you want more information, you can get more information. Like we'll try to make sure you're not starving, like creature comforts will be provided, like we're gonna run into the lunch hour, so there's a way of taking care of it. I heard it yesterday, they'll do it today. So like we're gonna wanna cover all those bases. The clock is yours when the deliberations start. You watch me pay attention to the clock, right? I don't have a clock because you do. So how much time you need is up to you, not up to our expectations or our time commitment. We got to make sure that when you deliberate, you don't do so out of like human denial or fatigue. So yeah, we're going to watch to see how that goes. Like you might have me send you a question saying, is everybody fine? Are you awake? Do you need coffee? Do you need food? What do you need? One jury kept going, my personal record's 1:24 a.m. because that's what they wanted. If they didn't want to go home, they were not coming back tomorrow.
All right, don't make me uncomfortable
Because they were
now.
locked in and doing a good job. But it wasn't my clock, it was theirs. Until the verdict is announced in open court, you cannot indicate to anybody what it is. When you knock on the door saying we have a verdict, the bailiff will come, he'll tell me that you have a verdict. The foreperson brings the forms out here, and you hold on to them till everybody's here, and then we open the verdicts in front of all the parties. Don't say, oh, so-and-so, and this is the outcome, because the bailiff doesn't want to know that, and he shouldn't know that, because it has to happen in this room. Up to this point, like I told you, you'd like not to talk to people, that still applies. Anybody outside the jury, that's off limits. If we deliberate today, you went home tonight, came back tomorrow, the rule's especially important. You can't tell anybody anything at all. Once the case is done, you can, in case I forget to say that. With regard to deliberations, I've got 10 of you and 2 extras. So the 2 on the end, 17 and 19, you're alternates. So you don't deliberate, but you're not done. You're what we call insurance. There's no guarantee in an hour somebody's not going to get a call that they have to go, or that they hit the floor, or somebody had an accident, or the baby came early, or whatever it is. So you're not done. You're charged to not talk and to just wait. It's a luxury to have extras. I understand what I just did to you. I get it. But the number of times the jurors slot back in is not the majority, but it's enough that we're glad to have you for a reason. These folks get locked down and something happens along the way. We can't lose 3 days of trial work because somebody went through a stop sign or had a flat tire on a curvy road. Then all of a sudden you're back, we start all over, and the case gets done. So make sure the bailiff has your phone number. If you can be within like 15 minutes of the courthouse, I don't know what that means. If you live farther, just make sure Chris doesn't have to drive far to get you. He's not going to anyway, right? But he's big enough that you don't want to cross him, kind of guy. Anything you want me to deal with in the instructions, Mr. Klingler?
I had two minor issues.
Okay, we'll talk over there. Mr. Osborne, you got anything?
I do have something, yes, sir.
Okay, we're just going to see what I didn't do right. But we're close.
Oh boy. They're gonna put the white noise machine on. And he's a criminal lawyer. They zoom in on the suit. Oh man. It's so nice to hear silence. Auntie M, thanks for the 5, says, I wonder how many times this judge has been overturned. See, I'm not familiar, but I'm not hearing great things. I'm not hearing great things. I didn't watch the Pike County trial, but it's something that a lot of people have been speaking about. And also I've heard that the prosecution in that case might have been a mess too. So, sounds like a whole mess of a trial. So, let's see. Like I said, the plaintiff had 2 issues. All right, they're coming back.
Wait.
Thank you, Auntie.
The vote is 6 out of 8, not 8 out of 8.
Oh,
It's the
I
next
missed
paragraph
that.
down. So I've got 8 jurors. When you go back there, 6 and 2 is a vote in favor or opposed. So you always have to have 3/4. So if you take a vote and it's 6 this way and 2 that way, that's enough votes. It does not have to be unanimous to prove a case. In a civil case, it's 6 out of 8. That a big deal? Yeah. I ever forget it? Yes. It's 6 out of 8. So you can
Yeah.
have 2 people say, I don't agree, and if 6 people do, that's a verdict. And then the emphasis for the 2 alternates is not only not talking is important, but not talking to the media is important. So if you get hounded, it's anybody in the universe. Because you're still in the panel, and then if the jury reached a verdict without you, you're going to get a call saying, you're done, and now if you want to talk about it, you can. Anything else, Mr. Klingler?
Nothing from us, Judge. Thank you.
Mr. Osborne?
Your Honor, I just renew any objections for the record, but nothing else other than that.
Fair enough.
Sounds like Klingler, the plaintiff attorney, wanted extra caution for the alternates that they couldn't go speak with the media
Or rules, depending on.
during this point in time.
There's a few typos. It'll be like 5-10 minutes before it gets you some sets of instructions. When you look at the instructions, if you have a question about something, read the whole paragraph, not just the one sentence. Like you always think, I want to know more about something. The answer might be 3 words, but read the whole paragraph to do it. So you start your deliberations. We'll get the exhibits back to you, cleaned up sets of instructions. And thank you for your attention so far.
When's lunch?
Yeah, are you taking our lunch order?
Sure am.
Oh, they got a snack tray.
Phone numbers.
Yes, I will.
Look at Afroman looking at the snack tray.
And you can just leave that way right there.
Leave this later?
Yeah, and then if you would have to come back and deliberate, you'll have to notify. We don't look at them or anything, even afterwards, we just tear them out.
You wouldn't be able to follow them anyway.
Remember, dear.
Judge Hein?
All right, so they're icing us out of that. So they said they have to, so the 8 of 8 seems like it was, I don't think he said that out loud. He said that it was in the written jury instructions that are going to go back with the jury. So they have to correct what it says on the paper, which that's a very important thing to correct, but I would say it's especially important to correct if jurors plan to reference these written jury instructions because they aren't exactly following what was said, or they don't remember 10 minutes from now what was said in court that we just listened to over the last 30-40 minutes. So they're going to correct those typos, and then this is going to be deliberations. So you guys can predict, if you guys want to predict how long you think it'll take for them to come back with a verdict. Again, it is, and yes, it's going to the jury, so everybody's rested. The evidence is closed. Here also, I didn't know this, but Ohio, they are one of the states, I think it's more common that states separate the liability and compensatory damages phase 1, with the punitive damages phase, which is a separate phase. You guys might remember if you watched the Johnny Depp trial, Virginia is a state that combines, it's all one phase. So if you're wondering if that was new to you, I think it's more common that they're separated and that Virginia's one of the exceptions to that norm. But in case you're unfamiliar and you watched the Depp v. Heard trial and that confused you, it's just states do things differently. So we have some predictions for tomorrow. Oh no, I want to know today. I want to know today. We got an hour, 2 minutes, 2.5 hours. And I don't really think some of the videos might be long if they want to sit back there and rewatch the videos, but I don't really think that they had that many exhibits in this. A lot of the exhibits were just like a screenshot of a social post, which is a caption to read and a picture to look at, maybe 2 or 3 comments. The videos, I don't personally remember the full body cam coming in. And I remember the plaintiffs were opposing the admission of the full body cam and the full surveillance camera footage. So I'm not sure that they have those, which would be longer pieces of footage for them to review as exhibits if they wanted to. They might not have that stuff. So they might only have the clips that were admitted into evidence. And we did hear the judge trying to keep the record clean about what start and stop time was used for certain exhibits. So they did play the entire 13 minutes. The plaintiff attorney specifically played the entire 13-minute video for the Lickum Lalisa song. Or whatever exactly that time was. So there's that, you guys. We left off, we were watching, and we're going to continue to catch up on the missed footage from day 1 that's available. And again, pinned at the top of this chat, you'll see it's Chris Hicks, Watchdog Wire is his channel. He is covering this case as well as many other cases over in this area of Ohio. So good channel to check out. He got this from the court camera system, so we're able to see. And it's cool. They're doing like voir dire prep in judges' chambers. It's interesting to hear. MG Logit to see you says, I hope the jury goes back and jams out to all the videos and laughs their asses off at the absurdity. Yeah, I mean, I feel like that's what I would do. 6 of 8, I don't know. I feel like, they have options to split here. They could be like, all right, well, let's throw a bone to 1 or 2 of the plaintiffs, screw the rest. Here's a little bit of chump change. I don't know. I don't think it's clear cut, even though I wouldn't vote for liability on any of the counts. I don't think it's clear cut that 6 out of 8 jurors couldn't disagree with me. So, yes, Courtney Clenny's case is next month. So there's a ton of stuff on this channel if you go back 2 years, because that case has been going on forever, covering all the previous hearings and whatever. But I'm going to redo some of the stuff as trial prep for Courtney Clenny. That's the OnlyFans murder trial. So if that's on your radar, I might actually be going live later to look at, it's a third-party interest. It's Kim and Deborah Clenny, the parents. They're still caught up they lost their appeal to get their devices back. They're still, the Miami-Dade State Attorney's Office is still in possession of their devices in relation to the now dropped laptop charges case. But their attorneys, Jude Facadomo and Ratzlin, I forget her first name. Jude Facadomo is a great advocate, always doing interesting legal analysis, always interested in privacy rights on appeal. I recently found out because of his blog that I'm in Florida, you guys. Florida's trying to establish their own state-level agency that's similar to the CIA. In other words, Florida wants a statewide agency that would use intelligence to predict crimes before they happen and go after people like before a crime has actually occurred. And it would be the first of its kind, as far as I know, that Florida would have something, that a state would have something like that. And I saw Jude Facadomo raise some concerns about that. So I like his advocacy. I've looked at so much of the evidence in the Courtney Clenny case. I think there's a good shot she'll be guilty, but the jury might not see what I've seen. I mean, I read her journal notes on stream if you want to check those out. I'm not sure they'll be admissible, right? So there's a lot going on there. A lot going on in that case. Trial's set to start April 27th. There's a sounding hearing 10 days before. There's a status hearing this Friday where they will now also hear this third-party interest over the iCloud information. The Clenny parents are seeking a protective order since they can't get their devices back on that information. So looking forward to that. Might do a stream on Jude Facadomo's arguments in his motion for the protective order later tonight. So there's a lot there, you guys. If you're interested in the OnlyFans murder trial, I will redo a deep dive because it's been 2 or 3 years on like footage, video, journal notes, all of that stuff, and pretrial rulings. So we'll rewatch the bond hearings. There's been more than one. So sounding it's just a pretrial status check, but in Florida specifically, 10 days before, they want to make sure everything's good to go for trial. So it's like a sound the final bell is where I think they got the name for it. So no, so I don't think it would cut the CIA from out of working in Florida. Florida would just have its own state level. It would just be another version. So there's that. Also, big thank you. We're going to get into this catch-up footage, but thank you to everybody that's showing all this extra love. I appreciate it. We have Don't F with Justice here. Always good to see you. Great coverage and great. One of the things I love about Don't F with Justice is, and I'll drop an X link because I think that's where I see most of the sharing. Getting documents isn't always easy. With this court for Afroman, the docket's available. We can look at the documents without having to create accounts, find them, purchase them, pay per page. That stuff can be tiresome to try to figure out how to do with certain courts that aren't really so accessible, and they can get really expensive. Don't F with Justice shares a ton and does the work to find a lot of court documents for different cases. So if you guys are interested in like motions, documents, coverage, access to court trials, here is, I'm just going to call her Don't F. There is the link to her over on X. So I appreciate all that you do, and I'm glad you're hanging out with us in here. Thank you for the 2 as well. And this comment was, if AI hallucination was a person, as this judge was going on and on and on. Yeah, that got long-winded. I am Shout. Hope you're doing well. Says, hey, Cat in chat. I'm shouting, if he wants to teach, then go to a law school, not court. That might be his goal. He like really seems to want to teach this jury, and we heard about it in this little bit that's on screen. He told the attorneys during their voir dire prep, like, hey, when we get a hearsay objection, I'm going to stop and explain it to the jury, and we'll use it as an opportunity to educate. Which, I don't know, can be cool, but if you're interested in time management, and if your definitions go a little bit astray and start, you start opining instead of just defining. So yeah, I agree with you, and good to see I Am Shout. Thank you so much for the super. David says, judge cleared the next 2 weeks just for his jury instructions. Yep, he did his own version of opening statements, I felt like. As soon as the defense opening was done, he spoke to the jury for quite some time. It felt like a third opening statement. It almost felt like he wanted to do his own closing here. And he had to tell the jury, I'm glad you're here because normally if I don't have you, I have to do the fact finding. And I try not to show my facial expressions, but it's hard sometimes. I can't, in other words, it seems to me like he was telling the jury, you might have seen me in this case do certain things, and I can't always hide my opinion. And he didn't cleanly tell the jury that they're not supposed to look at him or anything that he does as a matter of a ruling to whatever he has to do to run his courtroom, that they're not supposed to take that as some opinion and it's not supposed to persuade them or move them in any way, shape, or form. His way of dealing with that seemed a little bit different than when I've seen other judges give that same caveat to the jury. So yeah, lots of talking. You know, me and him in the same room. I don't know if I'd be interested in having long conversations with this judge, but I could probably rabble on. That's why I'm not a judge. So Auntie says, I didn't know judge-splaining was a thing, huh? And he's embracing it. He's embracing it. So he's embracing the judge-splaining, and judge-splaining will now be a thing. Auntie, we're gonna adopt that for future trial watches, because this isn't the first time we've seen judges judge-splain. But I don't know if we've ever put a term to it. I think that is wonderful. So thank you for that. Sheriff Chuck out here gifting another 5. Super, super generous. He's giving so much pound cake out. So much pound cake. So make sure you eat the pound cake, guys. Don't let it go to waste. Take advantage of it. It's good for 30 days. It's the wonderful pound cake that lasts 30 days. It's a very nice thing to do. I appreciate the support here from Sheriff Chuck, always holding it down. And I'm happy you guys got some members. Use the pound cake emojis out there. Oh no, Florida Defense Team says I'd pay to see you and the judge talk. Maybe I would just sit there and stare a little bit and ask what? Ask a couple whats, you know. And shout out to Florida Defense Team. Florida Defense Team here. I had a learning curve, and it's always cool to learn her perspective on, you know, when she describes cases that are going on. She's covering several cases that are taking place in Florida, like, you know, the Alicia Andrews and the remaining co-defendants. It's always interesting to hear, hey, in Florida, we do this specific thing. It's unique to Florida. So wonderful channel to follow for case coverage in general, but also very cool to get the insight on this specific statute in Florida works this way because XYZ. So if you guys don't already know Lisa Figueroa, I'm about to drop her channel in the chat. You can go check that out. Florida. And there are some cool people in Florida. Like, we've got to support them when we see them. All right, so there is Lisa's channel dropped in the chat there. And most recent video was on Dirk's new lawyer, Brian Steele. So go and check that out. We've got, let's see, thank you, Sunshine, for the 2. Sunshine has been thrown in for the curse jar. And there you go, Mr. Defense Attorney, let them roll. This was right when we had the commentary about opinions are like assholes. Everyone has one and they stink. I remember when this came through, and very, very fitting. We also have, thank you for being a member for 8 months. It says, I need defense attorney to speak a little stronger. And right as you said that, he did. He started yelling. Moses is asking the question. Chat, share your thoughts. Okay, who doesn't like WAP? W-A-P. Wet A pound cake. So, we've got Tatum and Chicken Shite right in unison during the plaintiff's closing with boo this man. Boo this man. I think his rebuttal was stronger. I'm not sure it was necessarily an accurate assessment of the elements, what the instructions would be, but it was sharp, succinct, and I think it was a strong thing to put in rebuttal. But his opening drove me nuts. Sunshine for You says, would anyone take a pound cake to go through what they did? I think that was a ridiculous question. We had the plaintiff's attorney ask, would you take, and he asked to me in a way where he wanted people to say, no, I would never want to go through this. You can't put a value on the pain and suffering that your clients have gone through. This is horrendous. This is outrageous. This is so horrible. There's no amount of money that can make up for it. And he said, would you take $2 million to go through what Lisa went through? And the chat erupted with, yeah, I'd take $1,000. Like, you're going to put me in an Afroman video depicting me in a very crass light? I mean, maybe I'd be offended randomly, but if I'm going to be offended and also have $2 million to do it, sure. You know? I don't know. So I don't know. That question kind of backfired for me, at least the way it seemed like he wanted the jury to think about it, but I'm not the jury. I'm not the jury. KP, thanks for being a member for 17 months. So 17 months and still not as crazy as this trial. It's a pattern here. They get crazier as we go. Auntie says Afroman should sell the rights to these songs. And I wonder, like, Is it just like streaming revenue that he's getting off the music? Is he performing? I know he did like Lemon Pound Cake at certain concerts, but I feel like unless there's an injunction, next time he performs, the people are going to want to hear Lick 'em Lalisa. So, is it now going to become part of the performances? So, thank you for the 2. Mark Lyon says, we have no damages except our fragile emotions. Yeah, and that's the plaintiff's attorney. You said this earlier, but the plaintiff's attorney ended up kind of going to that route. I don't really feel like he focused that much on arguing, hey, somebody lost their job or had to switch jobs. It was would you go through what these people went through for $2 million? Render a verdict of money. David Trailer says, this is near me. If I wasn't still off my feet due to medical reasons, get better quick, I would have attended this trial. That would have been cool. That would have been legendary. So I'm sorry for you that you could not go in person, because how cool would that have been just to say you were there? But I do hope you get better, and I'm glad you're watching with us. So, and thank you for the 5. Auntie M says, this judge seems to be overly familiar with details prior to the trial. So remember, he came on midway through this case. You know, the original judge was Jerry McBride. Jerry McBride is the judge that dismissed the count 1 and count 2. That was his decision and order. And this judge, when he came in, this judge is the one that ended up dismissing Afroman's countersuit. And, you know, I don't have an intimate knowledge of the docket and the proceedings. You know, I kind of had to work backwards and look at what I could look at. But I'm disappointed. I'm on high alert, I feel like, about how the media requests and media access were handled in this case. To the point where, you know, before I saw that Mel from I'm Not a Lawyer But had applied for media access, I looked at that docket and I didn't see anybody have like a Rule 12 approval on the docket. And I'm like, nobody's asked? So in my mind, I'm like, I could hit the road. It'd be like a 14-hour drive. I could just go in case nobody's there. At least we'd have notes to take. Like, I just don't know. And when I saw Mel applied, I was like, all right, well, I'll wait on the judge's decision. And the judge just never, days went by, no decision. It came down late Monday night after trial had already started. Although she got electronic receipt, I think the morning of the 16th. But she wasn't granted access to do any streaming. The pool was, she just wasn't given access. And we watched at the beginning of this stream, we got our answer to why that was from the Watchdog Wire. Well, WCP 09 somehow had the permissions, but when the Watchdog Wire went to get a copy of the order was prepared and signed on March 17th. Yesterday. After he asked. So they never actually had an order granting, like, oh, WCP 09 is going to be the dedicated pool, and nobody else can live stream or redistribute or disseminate this. They have to rely on their footage. They never had that order, but they were operating as if they did. So, and again, that's no shade to WCP 09. That's just the way that the cookie's crumbling with what party was where. But WCP 09, if we didn't have this court camera system installed that the Watchdog Wire was able to access, we'd be missing footage, even with WCP 09 there. And I think that's restrictive on the access when you had 3 other parties who requested to be able to be in there to record. So I think it's a shame. So yeah, I have some thoughts, but they're not fully fleshed out. They're kind of just like eyebrow raisers right now. And thank you for the 5. Kristen says, can't see a full witness on the stand. Yeah, because of this media coverage access issue. But we can see them in judges' chambers, WTF. And this is a good clarification, Kristen. I agree with the sentiment. But the reason we're able to see the judges' chambers, and we will be able to see the full witnesses on the stand, this is only because Chris Hicks with the Watchdog Wire was like, this media access is awkward. Let me just get this court footage. But if they didn't have the infrastructure at all, there'd be no possible way for the Watchdog Wire to then go get the full footage that we've been missing. Because from all accounts, it seems like WCP 09, it's not like they didn't just disseminate. They didn't hit the start button at all to start recording, let alone broadcast, until the points that we're seeing. So, yeah, I think it's messy. Pretty big trial, too. So Mark Lyon says, imagine being the exclusive camera operator. Yes, for the trial of the century and botching the job. So many missing parts. Yep, and again, I think it's very lucky that we happen to even have this. Otherwise, we just wouldn't. And then you have the judge saying, like, you have the facts, the public doesn't have the facts. Well, at least we'll be able to watch gavel to gavel what was going on in the courtroom. Even though we're not there in person, we'll be able to see and hear through the screen the same information that was presented to the jury. So thank you for the 5 here. And there you go, you guys. We're going to get back into this contextually, guys. I'm going to put up a banner. We are waiting for deliberations. Any news on deliberations? Let's see. Jury to start deliberating soon, because they're going to do lunch. And we'll have lunch. I don't know the specifics of their lunch timing, so we'll just keep this vague. And rewatching footage from day 1. There we go. That way nobody comes in confused. So here we go. Can we call a sham? A flim-flam? Flim-flam? We left off, this is exactly where we left off. For context, guys, this is before they did voir dire. They are in the judge's chambers, and they're discussing, like, hey, I'm not going to tell you when, the judge says, I'm not going to tell you when I'm going to strike a juror. I'm going to let you guys try to decide first, and then I'll make my decision, so you guys won't know. And when we get to, you know, objections at trial in front of the jury, if you make an objection, I might stop and explain what the objection means to the jury. So that's kind of where we are.
Let's see, anything else? I think you've covered it. Will you, Judge, ask the panel if they know the plaintiffs, will you get into all that?
The quick rundown is like introducing people and parties and lawyers and things like that. Then going right to the jurors, like, here's what we're looking for, here's what we're doing, here's how the process works. And then, like, swearing them all in, obviously. Familiarity of parties, knowledge of the facts. Like, I'm going to ask about YouTube and social media, how many people frequent that? Because you're going to want to know that, and if nobody watches YouTube, they're smarter for it. Or whatever it is they are.
Hello?
Because there's the smart side and there's the dumb side of all.
Chat, did we just catch a stray? Are we on the other side? Which side? What? Sir?
Them all in, obviously. Familiarity of parties, knowledge of the facts. Like, I'm going to ask about YouTube and social media, how many people frequent that? Because you're going to want to know that, and if nobody watches YouTube, they're smarter for it. Or whatever it is they are.
Look at him!
Because there's the smart side and there's the dumb side of all sorts of online streaming. I get my CLE online. Not sure which way that pushes me.
It depends on the CLE.
Exactly right. Depends on the content. So when people start saying they use social media, I'm giving you the opening to get into, do you watch cat videos? Or do you do something that's got a certain amount of educational, knowledge-based something? I'm trying to set you up so you don't introduce a subject that sounds offensive.
Yeah.
Right? I'll talk a little bit about NIL. Do you understand the concept? Because in sports, people know what that means. Right? If that's sort of what you're thinking in this case is your client said NIL, that's theirs, not the public's. Or is it?
What's NIL?
Name, image, license.
Okay.
Likeness.
Name, image, likeness.
Yeah, it's in sports. You gotta be a professional when you're in college.
Okay.
They can't use your face unless they pay for your face
Yeah.
and your uniform number, things like that. So maybe we should let you pick your section. I'm going to ask about like the sheriff's office perspective and relationships and how you do with law enforcement. Prior jury experience. Like, I'm just trying to go with the obvious stuff.
Good.
And then I'll explain like legal processes, burden of proof, why lawyers go first and second. All the way through, I have a client. My client's the jury.
Yeah.
I'm not going to tell them what to do. I'm going to explain to them what they have to do. So my goal is always to educate. You'll see me stop and teach them hearsay is this, and here's why we allow some and not others. So like, do you care? Well, you already know it.
Doing this again?
But for them
I didn't rewind before playing this, so he's repeating this.
sitting over there, they don't know a thing. Good. That's sort of how I work. I'll do the same with you guys. You want to know what's coming next? Well, now it's Mr. Osborne's turn to do this because this is why the rules are written in such a way that he gets to do this. And you go, oh, that's what I'm going to do next. When you didn't know, I'm talking to the jury when in fact, if you listen, I'm really talking to you. Got the concept? Like the more communication I can do effectively, the more you'll feel comfortable, right?
Yeah.
Good. You know, publicity, media, explain how that all works. You know, like their functions, like the jury instructions, like you'll start seeing those concepts. Along the way, I'll introduce at a 10,000-foot level defamation and false light. Now you can drill it down.
Good. Yeah.
But like they have to have some idea what the case is all about.
Good. I'm glad you're doing that. Yeah.
I'm not going to like bring up the fact you have a three-piece suit on and you don't, and you have a pantsuit on. Like I don't do appearances until I do, because their use of eyes is a part of weighing credibility. So like at some point in time, I'll probably ask, who do you think's ahead, Mr. Klingler or Mr. Osborne? And they'll all look at me offended, and then they'll realize they are in fact judging you, weighing your credibility by your appearance. Why don't you do that? They do that with witnesses. So at some point in time, I start getting into a little bit of how people like and do they care that you have facial hair and you don't, just to prove the point. Okay, now you can deal with whether they like your client's attire. Okay, he has a very bold-looking suit. I'm good at that. I have no problems with that at all. But like, I'm going to try to avoid things that might be like misconstrued, right? The fact that we wear conservative colors or that I have a robe means something to people, and it's fair game. So like, if you want to get into appearances, like I would invite you to do that, because I sort of open the door to some of it. So when you enter the same room, subject matter, it's not the first time. If the judge talks about it, then it's okay. If the lawyers bring it up the first time, people will get offended.
Yeah.
Does that cover like most of what you would hope I did?
I think so. Will we have a charging conference then at the end of the evidence? Sit down for the jury instruction?
Oh yeah, I'm not going to take your jury instructions the way you submitted them.
Yeah.
But I work on them during the trial.
Sure.
I asked Mr. Osborne to send me a Word file.
Yeah.
Like I like the fact that you sent me a Word file.
Yeah.
That looked like my last defamation case.
Yeah.
And last false light.
Yeah.
Okay, so that was helpful, but then everybody has nuances. Every case is fashioned by the evidence.
Yeah.
So, like there's a laptop in there, whether I actually use it or I go back to my place and work there, which is probably what I'll do. But you'll get them hopefully Wednesday during the day.
Okay.
Right? Because you did your homework ahead of time.
Good.
What else do you have? Mr. Osborne, anything?
Nothing at this time.
We can get the juries started to come in if you want. What
Well,
else
do we
you got?
get questions? We haven't seen any questionnaires yet.
The papers haven't been ran yet, so when we get all the jurors checked in and run, then you'll get the papers shortly after.
They get jurors that show up and then you shuffle the list, right? So there's another
Shuffle, yeah.
shuffle. Like I was expecting the veneer to come out. Well, the veneer will come out after the shuffle.
Thank you. Yeah.
Which I didn't do back in Dark County, but they do in Adams.
So we'll know the number.
So you'll know the number, you'll number the list.
They'll have their juror number, and then there's 13 jurors per sheet. So
Okay.
you can judge where they are in the lineup by.
And then I'll try not to make you use a peremptory without knowing who's behind it. How many peremptories do you get?
3.
Plus?
An alternate for +1?
Yeah.
Yeah, okay.
Yeah, so I'm not going to want you to bend into the blind.
Okay.
Like you'll know who's behind, so you can pick the
Yeah, appreciate it.
less bad,
Yeah. right?
You agree with the peremptory numbers, right? 3 and 1. That's what I thought you were saying. Yes, that's what I was hoping you were going to say. We're not going to introduce you. You're going to be able to come in like you're a media person. It's one of the 62 seats. but like you're just here to watch, so with all due respects, we won't be introducing the lawyer for the party who's not, the claims that aren't before the court. Talking to the Court of Appeals is appropriate. Make your objections sometimes during the break. I want you to build it.
Okay.
Okay, like I don't expect to try a perfect case, right? So when I don't give you a chance to make the record right in front of the jury, just remind me on break, when the jury's gone, that you want the record to build out your issue. Maybe I can fix it, maybe I shouldn't fix it.
Okay.
Maybe you're just completely wrong and didn't realize it. Anything else you want on the record?
No, thank you, Henry.
Anything else? Okay, go ahead and turn off the record. Bill, you're going to start shuffling here pretty soon, bring people in.
Yeah, I'm gonna go check and see how many jurors and see
Okay.
what we got.
Water's good, coffee's good.
Oh, good.
In the courtroom.
Oh my gosh. I'm sorry. Did not know that was happening. Oh, sorry, chat. Let me... Oh, sorry if I can save the chat by typing quickly before it gets to some of you guys. I know it's gonna hear, some of you guys are gonna hear it. Yeah, ear flashbang. Sorry. It goes right to the next feed though. It goes right into it. And guys, by the way, when they say veneer, I always thought it was veneery. So I say things wrong because I do more reading than I hear things said out loud. But when he says veneer, that's the like total pool, like before a jury is actually sat. That's the total number of people that you could pick from. So, tiny little courtroom, people crammed in, they were trying to figure out the logistics. Here we go.
Okay, good morning. Before we start, would you please join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Go ahead and be seated. Good morning, ladies and gentlemen.
They got to do the Pledge of Allegiance with Afroman wearing an American flag suit.
Okay, let's just put that out there right away. I am not Judge Spencer. Good morning. My name is Jonathan Hein. I got assigned to this case by the Supreme Court. My home seat is Docket County. So go to Dayton, go up a county, go west a county, and right at the end of the world is where I spend my life. The earth drops off at the Indiana line. But we're here to try a civil case, and I want to thank you folks for responding by showing up.
This guy's ready. Look at this guy.
Questionnaires by rearranging your life. It's a strange duty around the world to bring the public in and let them make decisions. In most of the world, we don't trust the public. In most of the world, you have to be educated in the law and experienced to be a decision maker. But the founders decided that the best way to set the rules is to have the public do that. So jury service is how that manifests itself. So thank you for being here. We'll talk more about jury service, how this works. I'll introduce the case to you. But the goal would be to have a jury by noon or so. How that process moves along is always fluid. But we'll need a panel of 10 jurors. And then as we work our way through this, eventually, if you're not in the panel, you can go on and head back to whatever is in your normal routine. To help you get acclimated, let me put some names to face, because you may already know this. But the court staff is the bailiff, Chris Fight.
Good morning.
Mr. Fight's job is to manage me, or to tell me how things work in Adams County, or specifically as the jury to help you know what's going on, go where you're supposed to be going. If there's a security issue, or if he says do this, that, or the other, Chris would be the first person you'd hear from, so lean on him, understand his role is to be bossy. Shirley Thompson has her back to you. There she is. Shirley's job is to make sure what's said is recorded. We call that the record. The record includes documents. For the most part, though, she's monitoring the recording system to make sure that the mics are picking up things. If there ever had to be a transcript of what's said, that's her job. So if she stands up on the top of her seat and yells at me that something's not working, that's necessary, it's good manners. She might stop a lawyer midstream saying, nope, not working, do it again. Don't misunderstand that as rude, it's not. It's necessary. So Shirley's job is the record. Ronnie, where are you? Ronnie's job is to run the court. Court administrator, is the right title? She's got a lot of years' experience doing the, I'm going to say, back office, the management, the administrative side of things. So to the extent that she does that, that's her necessary role. There's a bevy of other people that have titles that are administrators or paralegals or bailiffs and everything else. For the most part, we work our way through there. Let's see, Miss Livingston, right there. Are you? No, I'm sorry. What remind me again? I got your name.
Leanne Liston.
Liston.
Yes.
Sorry, I wrote it down wrong. But she works in the clerk's office.
Good morning.
Clerk's office. Sorry, Leanne.
Okay.
Is to participate, keep track of you, summons jurors, make sure you get paid. So you want to be best friends with her. But also, to start the trial, she administers oaths. So, for the most part, you'll see Mr. Fight, Ms. Thompson, maybe Ms. Grooms here during the trial once we get the jury selected. So that's the introductions of the court staff. The case is 2023-0069, and it's called Cooley versus Foreman. So the plaintiff's case is over here. And we have 7 plaintiffs. And the plaintiffs are represented by Mr. Klingler and Mr. Kretzler. So those are the plaintiffs' lawyers, the first 2 people. And then the 7 plaintiffs over there. And then Mr. Foreman is here, and his attorney is Mr. Osborne. That's the second side of the defendant's side of the case. I'll tell you more along the way, but I'm just trying to get you acclimated to who's here and why. I don't know anybody else here as far as I can recognize, but we're going to get to know each other better as this goes on. So the first part of selecting a jury is to ask questions of you along the way. Everybody that's here has to take an oath that when they are called to answer questions, they'll be truthful and honest. So Ms. Liston is going to come up and give an oath to you. If you're a prospective juror, not only the box...
Court teller.
Sorry. Like that's a big faux pas to not introduce an elected official, so mark me down first person in social awkward position. But thank you for having a website that works. I think it's very intuitive and helpful for foreigners. So he's going to administer an oath. If you were summoned as a juror, you folks in the back and in the jury box, please stand up right now. And if you'll raise your right hand, this is the oath for the questioning part of the case. Go ahead, Mr. Heller.
Yes, sir. You do solemnly swear that your answers to all questions addressed to you by this court and counsel, touching your qualifications as jurors in the case now pending before this court, shall be the truth, the whole truth, and nothing but the truth. As this you do, you shall answer unto God.
Go ahead, have a seat. Thank you, Mr. Heller. How many years you got elected? 13. Well done. Okay, so the process of asking questions is to learn about you and then have some idea whether you qualify as a juror. There's no perfect jury, there's no checklist of who qualifies to be a juror. We're going to focus on the first 12 people because it moves along a lot faster. It doesn't mean you're not important if you're sitting in the back, because as people get excused, you'll rotate up. But if we ask questions of 50-some people, it'll take forever. But if we focus on the first 12, it'll move along a lot faster. For you folks in the back, pay attention to what you would have told me had you been over here. Like the first question, number 13, is going to be, if you were up there before, what would you have told me? So I want you to pay attention, but only answer this question. Everybody in the room has to be an Adams County resident. So is there anybody here who does not live in Adams County? Congratulations, you're all qualified. That's the only requirement, but it's not that simple. So what we're going to do is now work our way through. In the questioning process,
I actually wonder if that's the case, that like clerically, like has everybody in that room really updated their license? And I wonder if maybe someone just like really wants to be on for this. Like they clearly know this is the Afroman trial. He's sitting right there in the suit. So also big thank you here. Anyone in the Tampa area ever been to a concert? I'm assuming this is at a larger venue because it's BTS. I think that's a larger group. It must be a bigger size. What's concert going like in Tampa? Gloria Smith is heading out there, and I'm on the other side of Florida, so I'm actually not familiar with the area. So I know I'm in Florida, but I'm boxed in. I'm sheltered over here on the Space Coast. So Gloria, I hope you have a great time, and maybe someone in the chat can let us know what it's like going over there and what the venues are like. Monique says, thank you for streaming. Thanks for hanging out. I'm hoping, you know, if we get a verdict, WCPO9 will go live. We'll be able to know that they have a verdict, and we'll be able to cut over there. So thanks for hanging out with us. And Black Butterfly. So this is the, he says venereal. I always thought it was venereal pool. Like venereal disease, I guess. I don't know. Maybe I just mispronounce things, and I'm not one that's known to pronounce things the correct way. But this is not yet the jury. So we'd have the petty jury, petite jury, petit jury. That's another thing that's up for debate on how it's actually pronounced, and that is the selected, seated jury panel. So they have not technically shown who those individuals are.
to help make the record easier, and so that out-of-town judge doesn't butcher your names, we're just going to use numbers. So the lady in the back and the right is number 1, 2, 3, 4, 5, 6, and don't take that as an insult, because everybody has an identity. But when I don't understand local names, it's a lot easier to get it right when we say juror number 1 and then go with it, because we'll have the list. That makes sense. Anybody remember my name?
John.
Thank you. Last name is Hein, but I don't spell it the way you think I spell it. And that demonstrates why we try to just use, because sometimes you can end up with 2 jurors with the same last name or close names. In Dark County, there's a lot of foremans spelled 3 different ways that I know of. And if you get 2 foremans, you don't know what you're talking about when you just say last names. So we're going to just refer to you by numbers. But everybody in the panel right now, these 12 or so, I'm directing my questions to, it's meant to be open-ended. It's meant to be you talk a lot about who you are. And it could be that, like, you aren't able to track this case, or you know too much about it, or you have an opinion about it too soon, that eventually somebody say, no, we're going to excuse you from service. But being honest right now is helpful, because it gets us to the point where what we're really looking for is 10 jurors who can be patient, listen to both sides, to not have an interest in the outcome, who's willing to be fair, to make a verdict that they would think was fair if they were one of the parties. And a lot of that has to do with your prior experiences. What's happened to you in the past, how you were educated, maybe what your job is, maybe not. It's a factor in how you think, how you decide. So that's why we probe into these things. So, juror number 1, thanks, you got my name right, appreciate it. Have I confused you so far? Okay, sort of understand what we're trying to accomplish. Yes? Now, thanks for doing what you just did, because I was hoping you would nod your head. But she proved that you have to answer out loud, because the recording doesn't pick up non-verbal communications. It only picks up words. So sometimes you'll hear the Shirley go, doesn't mean anything. Is that a yes or a no? We do that along the way. So, number one, didn't fall into the trap. Good job. This answer the question as clearly as possible out loud. Let's start with the introduction I just did. I'm not going to talk about the court staff because they don't factor into the case. But does anybody recognize Mr. Klingler, Ms. Gressler, Mr. Osborne? Anybody recognize those lawyers' names? Okay, I'm just working on 1 through 12 right now. But number one, you do. Okay, who do you recognize?
Well, I recognize David Osborne, and I recognize Afroman.
Okay, Mr. Foreman.
Mr. Foreman.
So, do you have an active case right now with Mr. Osborne? Is he your lawyer? As he's been in the past?
No, sir.
Okay, how do you recognize him?
From social media.
All right, way to go, because that's what this case is about. What's social media? Like, tell me what that means to recognize it from social media.
I've seen videos on Watchdog Wire, the situation, and
How recently did you see any videos?
a couple of days ago.
Okay. Anybody else look at social media or know anything about this case from social media? No? The number 11.
I've seen little bits and pieces about the case, but not the full story.
Okay, and number 12?
Same.
Same?
Same.
Okay. So this case, I'm sorry, number 6.
Does Channel 12 News count as social media? He was on the news report, I think, 2 days ago.
Well, let's say it doesn't matter if it's social media, it's a way of knowing about the case. Because there is a certain notoriety or information. I'm going to ask more about this, but it's typical for jurors to come into a case having some context. Let me tell you more about the case to get everybody up to speed. The 7 plaintiffs were, maybe still are, employed at the Adams County Sheriff's Department. They executed a search warrant at Mr. Foreman's house. In the course of the search warrant, there's recording, security cameras, and then Mr. Foreman uses this materials from the search warrant in his publication process. Plaintiffs find offense with that, so they file claims, in this case, for you to decide, which I'm going to call defamation, making false statements, or false light, which is a first cousin. It's maybe not false, but it puts people in the wrong impression. So the claims by the plaintiffs in this case are that the publication, the social media, the distribution was false, defamatory, false and hurtful, and false images, and or put the plaintiffs in a false light, a misimpression, and that's what this case is all about. So if you saw something on social media or on a traditional media site, that's not unexpected. The key point is to understand that's not evidence. The chair next to me right here is the witness stand. The evidence comes from the witnesses. The evidence also comes in paper form. The witness says, yep, this is something. Likely will be, you'll see video. The video that is evidence, moving pictures. So you have to, as jurors, disregard what you think you know about the case from outside the courtroom and decide the case from what goes on in this room. Understand, number 1?
Yes.
How about 6? That makes sense?
Yes.
Understand the concept. How about 11?
Yes.
And 12?
Yes.
Okay, so it's not wrong that you know Mr. Osborne as a local attorney or as introduced in something you saw on your screen. That's expected. What's wrong is for you to decide the case on evidence that's not presented in this room. Everybody understand that?
Yes.
So, number 11, does this cause you any heartburn?
I'm sorry?
Does divorcing yourself from what you heard beforehand cause you any problem?
No.
How about 12?
No.
Go back to knowing the lawyers. Anybody else know Mr. Klingler, Ms. Kretzler? They're from Cincinnati. They practice adjoining counties. This is not a home game, if you think of it that way, but not unfamiliar territory. Anybody know any of the lawyers?
No.
No.
Now, Mr. Foreman's right there, closest to you. Does anybody know him? He's an Adams County resident. So number 7, how do you know Mr. Foreman?
His son played basketball, and my daughter cheers for his son. Just seen him
Okay,
at a
what
basketball
school?
game, that's it. North Adams,
How old is your daughter?
8th grade.
And his son, same grade?
Yeah, so they're probably 13 or 14.
Okay. Ever talk with them?
No.
Mr. Foreman? Number 8?
I saw him at cheer competitions, like years back when my daughter was cheering. I didn't talk to him or anything.
He lives in Adams County, right?
Yeah, I
Same
guess.
school district or same area, right?
I'm in Manchester, he's not in Manchester.
Okay, so.
But yeah, same county, yeah.
Number 3?
My wife is a teacher at North Adams. She taught his children in school, spoke of him a few times, but that's all I know.
Okay, anything recently?
No. I mean, I've heard of the story, but same way as everybody else, just through news, bits and pieces, but no details.
Okay. Anybody else? A couple other hands might have gone up about number 12.
I just know of him and seen him in the area, driving.
Okay. But does anybody socialize with Mr. Foreman? Anybody have, like,
No.
same civic organizations, religious groups, sports, activities, club, boosters type thing, where you would be more than just a passing face in the crowd?
Yeah.
Got 1, 2, 3, 4, 5, 6, 7 plaintiffs were or are still employed at the Adams County Sheriff's Office. This will get a little bit bigger, but does anybody know any of the 7 plaintiffs?
Yes.
No.
No.
Let's go with number 8, 9, should I get them?
I just know him because I was born and raised in Adams County. And, just know him just from being around.
Which part of the county do you live in?
Adams. West Union, sorry.
West Union, so you're here in town?
Yes.
And the sheriff's department's in town?
Yes.
So higher probability you'll see their face in town, right?
Yeah, absolutely.
Is it more than that?
Is it what?
Like, is there any other social or civic affiliations you have, say booster group or anything?
Not really. Just knowing him around here.
Are all your clients still actively employed at the sheriff's department?
No.
Okay.
Two are no longer with the department.
Any of those folks ever give you a ticket?
Any what?
Ever give you a ticket? Speeding ticket?
No.
Equipment violation? Ever investigate you?
No.
See how that might make a difference?
Yeah.
Right? Thank you. So, and number 8.
Brian lives a couple streets down from me. I've never had a conversation with him. His kids go to the same school, so I know who he is, but I don't know him. And Lisa was my stepdaughter's resource officer several years ago, but I've never had a conversation with her. Randy, same thing, was my daughter's resource officer. I don't ever recall having a conversation with him, and I don't recognize the rest of them at all. I haven't been on social media, like, I've been off of that for about a year and a half.
But you tipped your hand.
Well, because I don't know them, but I mean, I know who 3 of them are.
Yeah, because you called them by their first name.
Yeah.
And that's okay. Dark County has got almost twice the population of Adams.
Yeah.
We're a small county. If you didn't know them, I would be concerned.
Well, I
When
know
you
3
called
of
them
them
by their
are.
first name, it told me something,
Yeah.
right? So there's a certain amount of affinity because you know them well enough to know that they have a first name, not new
Yeah.
adult respect, right? So how well do you know if you know by their first name?
All right, that was super coughing in the chat. So a ton of questions here. And again, this is the veneer, the pool from which the jury will be seated. But checking the latest iteration of Rule 12 in Ohio. This is from the Supreme Court of Ohio. The prohibition on recording jurors doesn't apply to the official court recording of the proceeding as part of its official record. So this footage here is Chris Hicks obtained this from the court's official recording equipment. So the prohibition, even if this would only apply to the seated jury, the prohibition doesn't seem to be in place. So there you go. That answers that question there. And that is part of Rule 12. I'll drop this if you want to go check out what was amended. A lot was changed, all of these crossouts. And this was changed back in April of 2025. So I'll drop a link to this in the chat. And we were over here.
I've never had a conversation with any of them. I don't know them at all.
That's okay. Like I know all my
I think Randy may have called me one time when he was at the school with something over it. I don't even remember. It's been a long time ago and it wasn't like a big deal, I don't guess.
Okay. Hey, who else knows any of the 7 players? Thank you for that. Anybody else recognize faces?
I recognize a couple, but
Okay,
I do not.
So you're number 5.
I do not know them at all. I've never had a conversation with them, but
Do you recognize them from the videos?
Familiar, as I was in the courthouse before.
Okay.
That's it.
Thanks. It's totally expected. I'm just drilling down to if it's your neighbor, literally your neighbor, maybe it's not easy for you to be disinterested and have the public think you were fair because it's your neighbor. Understand?
Yeah.
It's not wrong to call somebody by your first name and live 2 blocks over and you know them because you've been in the same neighborhood.
I speak to him when I see him out, when I go by.
Thank you. So anybody else recognize anybody over there? Okay. These are 7 individuals who at the time worked for the Adams County Sheriff's Department. Does that figure into any of your psychology? Does anybody have family members that work at the sheriff's office?
No.
Anybody have family members that work in law enforcement? Anyone?
No.
Anybody have issues, prior bad experiences with the Adams County Sheriff's Department?
No.
Anybody have prior bad experiences with any law enforcement agency?
No.
Why did I ask that? Because that might creep into your mind if you had a prior bad experience with a person in a different county wearing a badge, and for a living they wear a badge. Understand my point?
Yes.
The reason we go through this questioning is to try to unpack what affects your decision making. I did not have my traditional breakfast this morning. I got a better one. It's really good. I don't get eggs and bacon because I shouldn't eat eggs and bacon every day. So now I'm having a good food rush because there's a good experience in my brain. Does that affect my decision making? It better not. Because I can't afford to let my diet interfere with my duty, and you have the same duty as we go through this, to not be affected by anything besides heaven. Understand?
Yes.
All this questioning, when the lawyers get up here and start poking at you deeper, trying, is to see whether you can actually set aside prior experiences, your way of thinking, your prejudices, it's okay, your biases, your preferences, we all have them, and decide the case. That's what this process is all about. Understand so far?
Yes.
Now, who wants to volunteer something that's going through their mind that they don't know if they can get rid of? Anybody have a gut check so far? Okay. No. So this is where I pick on number 4 just because you've been smiling back there. Okay, so how's this process going for you so far?
It's going fine.
Okay. Are you hesitant about anything right now?
No.
You're not?
No.
Good for you. Work on it. If anybody tells you jury service is easy, I'll be surprised. Because during this process, I introduced complicated legal topics by saying defamation and false light. That's just to get you in the door. As it goes on, you'll find that it's much more than that. We'll take it apart and I'll educate you. That's still coming. But is there anybody here that doesn't do well following directions?
No.
No? Okay. The judge's job is to give you the instructions of law. That comes at the end. I know generally what they are, and so do the lawyers. But as the trial goes along, jury instructions get refined. And at the end of the case, I'll say, here's the law. Here are the rules that you have to apply. You have to apply. So then I look right now for people who say, I don't follow rules, I make rules. So is anybody one of those people that makes the rules and never follows them? No. Anybody?
No.
Anybody a business owner? Have your own business?
No. Yes.
Okay, so 8. What do you do for a living?
I own a crystal shop.
All right. Anybody else own it with you?
No.
Do you decide where everything goes?
Yes.
You decide where the inventory is?
Yes.
You decide the pricing?
Yes.
You run the shop from the door in, right?
Yes.
Who bosses you around?
My kids.
In the courtroom.
Was that the judge that laughed on delay? Like, the room laughs, and then the judge goes, ah ha ha.
Yes.
Who bosses you around?
My kids.
I think it was the judge.
In the courtroom, I give you the instructions to educate you, not to boss you around. But you have to
Look at his
understand
face. Look at Afroman's face.
to educate
It's brief,
you,
right
not to
here.
boss you around. But you have to understand that those then become the rules you have to follow. Some business owners struggle with that. We're in a different field, but their personality is they know they make all the decisions all the time, and then they fight with themselves. Do you think this will be a problem for you?
No.
Okay. Number 3, you said you own a business.
Yes and no. I run my own little business, but I still work full-time in the banking industry. So I'm just kind of starting. I'm starting a business owner.
But you don't own the bank.
No, absolutely not.
At the bank, you follow the policies and procedures and directions, right?
I follow them and I help create them, so yes.
Okay. So you have input.
Yes.
You understand how that works.
Yes.
But then once you write them, everybody's expected to follow them, including yourself, right?
Including myself, yes.
Same thing in the courtroom. At the business you're starting, you get all sorts of flexibility and freedom to make whatever decisions you want to and suffer the consequences and the rewards, right?
Yep.
It doesn't work that way in the courtroom.
Okay.
Got it?
I got it.
Everybody understand the example?
Yes.
Anybody think like it's a problem for them to take the law as given to you and then apply it?
No.
Very good. Let's talk about sports for a second, like the subject, but the point's the same. College athletes now can sell their name, image, and likeness. Have you ever heard of that NIL acronym?
Yes.
Where athletes have an image and a likeness, and it's now marketable, and they can get paid for that. Does everybody understand that concept, NIL?
Yes.
Okay, it's a commodity, right?
Yes.
So, like in some respects,
The counts that the causes of action that would relate to this were dismissed.
you could use that as an analogy in this case. If you didn't understand it, then I would be worried. But if you at least understand the concept, that's helpful. What about use of online streaming services? Does everybody have some sort of an online streaming service where they get their education, their entertainment, whatever it might be? Just do it this way. If you don't have one, raise your hand. Okay, so everybody uses Netflix or YouTube or ESPN online or CBS online, and understand how distribution works.
Yes.
Just that'll be a part of what happens. Again, if you didn't know about it, then I need to know that, because that would be like out of touch with what's common. Okay, so no problems there. What about prior jury service? Anybody ever served on a jury anywhere before? So number 5.
I served in Texas many years ago. When I lived down there. I served on one.
Okay, thank you. Number 6.
Yes, I served here. I think it was 4 years ago. There was a mistrial declared. And then 2 years ago, the prosecution didn't like me. Plaintiff's lawyer didn't like me. So he dismissed me.
Okay. Interesting that you think they don't like you. Because that's, I'm not saying you said anything wrong. That's the normal impression I always coach against. Because I don't know that any of the lawyers is going to invest enough emotional energy to develop a relationship with you to not like. Instead, what happens is they say, from your perspective, with your experiences, you're probably not inclined to think about my client the way I want you to. But we all take rejection, quote-unquote rejection, in a different way. So thank you for showing up. Thank you for serving. And don't take it personal. Because in this process, people are going to get excused. Like, you just helped me check off one of my boxes. And when I excuse people, I remind them, it doesn't mean you're not a good person or that you have a character flaw. It often means that one of the lawyers thought you wouldn't see the case from their perspective. Now, they're both looking for jurors who will think of the case from their perspective, so neither of them is going to get everything they want. Sometimes they're just trying to say, okay, if I get 4 out of 8, 5 out of 10, 6 out of 12, if I get half, that's good. And then in the end,
oh, we
I
gotta,
always remind you.
guys, we've been covering another case here. This jury deliberated for 12 days. This was a retrial for Ed Holly. It's a cold case. It had a low match DNA with multiple profiles. This is the case of Ed Holly. They found him not guilty of murder. Let me make sure there's no other counts there. I don't know if we have more reporting. But that would be the big one. Not guilty. Wow. That is the case where the jury has asked, they might have asked more today, I don't know, but they asked 27 questions. They had to swap in an alternate. They asked if they could Google DNA. Wow. So there's that. You might have heard me mention it yesterday on the stream a little bit. We looked at some of the coverage, and if you followed me before this case, we've been talking about it for like a week. So yes, I was going to look for EJF in the chat. So there we go. And no, there was no court feed for this case. The coverage I've seen has all been from Ben Nandy over on Facebook, which I've trying to, not everybody has Facebook, so I've been trying to say it out loud on here. So I'm going to drop a link to Ben. I think he might also be covering, if you guys heard about the Chester, New York, the DoorDash shooting, where the DoorDash driver was lost. And the house that he went up to ask for help, or I don't know if he knocked or was speaking through a Ring camera or something, but he asked for help and was walking back to the car to leave, and then is shot by the homeowner. So I think he's going to be covering that case. It's supposed to be happening in the courtroom right next door. So here is Ben Nandy's link in the chat, or just search Ben Nandy over on Facebook if you use the app. And of course, I'm going to message him and be like, Facebook's kind of hard to access. Do you do updates anywhere else to see? Because it's been some great coverage for Orange County, New York trials from his page. So there we go. Sorry for the interruption there. That was a big one. Back to rewatching day 1 of Afroman.
Jurors that the evidence is what you make a decision on, not personality and likableness, things of that effect. So number 6, what you said, I get to check that off, because that's very valid. When you previously served on the first case, did the jury get a verdict?
No. The first witness was a detective who mentioned the defendant's prior arrest record twice.
And you're doing it, yeah. So when there's a mistrial, first of all, understand this for 2 points. Sometimes evidence comes in, it's got nothing to do with the trial. And the judge says, you gotta ignore that because it's just a distraction. You should never convict somebody for a certain act based upon their prior conduct or their propensity to act. You can only judge a person's actions, not their state of mind or their prior action. That might happen in this case where I tell you, ignore something, it's a distraction, it's not relevant. I can't put the genie back in the bottle, but I can tell you to not deliberate it, not consider it, take it out of your mind. Everybody understand the concept?
Yes.
And reflection. Number 5, you said you served in Texas. Did the jury get a verdict?
Yes,
How long was the trial?
one day.
Lucky
It
you.
was simple, DUI.
Okay. This case is likely to take 5 days. Okay, so when we get 10, we're going to keep you first cousins by the time the week's over. Does being here for 5 days cause anybody any problems?
No.
Okay, so for 4, go ahead. What's going on this week?
Just my job. So I travel a lot for work all over the country.
Number 6?
I'm good for today and tomorrow, but I have to get my wife to a doctor Wednesday. The point that she's got
Okay, number 1.
My father-in-law is in the final stages of dying
Everybody, front row, number 11.
I am the primary income for my household, and missing a whole week's worth of work could be detrimental financially to us.
Who else? So, everybody is expected to invest in government, invest in democracy. There's no profession that gets a pass. In my experience, the doctors would show up before the nurses, because we all sort of knew where the work was getting done. So I would get calls all the time, and for the doctor, they would just send a doctor. But if the nurse was on the jury list, I'm getting calls from everybody, because they're the most important person for the most people at that place. At your workplace, you might be the line leader or the shop foreman, or you could be the owner, but to answer your question, the financial hardship, I understand, but it can never be a reason. Otherwise, you would only have people that are retired on some sort of like annuity or didn't have to work as responsible. But I need to know that, so thanks for the honesty about that. It's the first cousin now. I ask everybody who had issues. Okay, what about life that's distracting them right now? Number 1.
with my father-in-law passing. I mean, my mind is elsewhere. It's, I mean, not on this case for sure.
But is he in hospice care or something right now?
Pardon?
Is he in hospice care?
Yes, it's Seaman.
Man, let her
How many times
go.
have you thought about your father-in-law since I started bothering you?
Very distracted.
Do you have any problem, Mr. Osborne, with this? Would you be offended if she's excused?
Your Honor, I was just talking with Mr. Klingler
yes
about
or
that. Yes, Your Honor.
You would be offended if she's excused?
No, I would actually ask.
So the answer is no. What do you think?
Absolutely. I think she should be
Okay,
excused.
thank you. Just to hurry this along,
Right.
thank you for being here. you have her attendance, right? So how soon do you send out PIP?
Just out the clerk's office is the issue, the voucher, then she'll take care of stairs.
Nobody gets treated this well. Did you get paid today? But you can be excused, thank you. Okay, so 13 just come up here, thank you very much. So, Madam, just you can walk around the front to make it easier. So come around the front of the jury box. So now we're going to call you 13. Thank you, 13. And I saw you pay attention around there, so you went a few times to lean out of your seat. What did you want to tell me if I would have paid attention?
I don't remember the question you asked.
Okay.
What was the question?
Like I asked you to hold all your answers until you got up here. So, like, tell me what's on your mind that you would have answered or would have been a problem.
I don't remember. It was, I put my hand up in response to a question you asked.
Yeah.
Was it, but I don't remember what the question was.
I don't either. So it must not be important. Quick recap is whether something about social media or name, image, likeness you didn't understand. You understand the concept?
Yes.
And then I talked about defamation or false light. Generally understand like the concept. Okay. Do you know any of the parties or the lawyers?
Not personally, but I have had a Zoom interaction with Mr. Osborne when he was running for the prosecutor.
A couple years ago.
Yeah.
Okay.
Yeah. And I recognize some of the plaintiffs from being in the community. One of them knocked at my door when he was running for sheriff for their primary. I recognize Mr. Klingler, I think, from being in the newspaper. I'm a news hound. I've taken a lot of news, but I think I recognize your face from me. So, does that answer your question?
It does.
Okay.
Have you taken in any news about this case?
A lot.
How recent?
Since its beginning.
Okay. Did you understand the point I made about the evidence being what happens in the courtroom?
Absolutely.
So you have like this little electronic eraser that you put across your memory, right?
I try hard to.
Well, yeah, that's where I'm going.
Yeah.
You understand the rules, right?
Absolutely.
So anything that you think you know about the case is not subject to consideration. Right?
I understand. Right. I do understand how media filters information, and that's different than what we would hear in a setting like this.
Okay. And you just turned your head to the left and looked at the media guy.
Are you the media guy?
Yeah, I did that on purpose.
You know, I thought I was going to see Mr. Hicks, the watchdog wire guy, when I went back.
Oh.
No.
They're talking about the guy who we watched at the beginning of this footage, and he's the reason this official court footage was obtained and put on YouTube. So Chris Hicks runs the Watchdog Wire, which should still be pinned at the top of the chat. So please take a second if you haven't done so already. Click that. Go subscribe to him. He's giving us access that we wouldn't otherwise have had on this trial, and is also covering other stuff going on in this courtroom, in this courthouse, and with this judge.
The public has the right to know what goes on in this room and every courtroom in the state. So the public is allowed to attend. The media is allowed to participate. That's how we do democracy. Like you ever hear like dictatorships shut off the internet and they don't let people know what's going on? There's a reason for that. And then we guard the other reason, thinking that the public's right to know ought to be protected. So there is a place in society for distribution of information. So the fact that Mr. Foreman published information is not wrong. The standards then go to, is it wrong if it's false information, wrongly distributed type information, or it puts people in a false light. That's what this case is all about. Understand that? So when you take in social media, great. When you watch traditional media, great. It's what you do within the courtroom that I have to compare. So 13, you get this right. Everybody else is like, this is making sense to you, correct?
Yes.
Talk about some legal concepts. In a civil case, how this works often is a subject of questions. I'm going to let Mr. Klingler go first, not because he's a nicer guy or a better lawyer or has a neater suit. It's because the plaintiffs have to prove their case. So with the duty to prove the case is the privilege to go first. So you'll see Mr. Klingler get called on a lot first. Don't misunderstand that I think this case is stronger or he's a better lawyer or anything else other than the rules say he gets to go first. Everybody knows what tennis is. Somehow one person has to serve, so Mr. Klingler gets to serve. Mr. Osborne doesn't have to do anything until the ball goes over the net. So when Mr. Osborne goes second, it's only because it's his turn to go first, second, first, second. So the plaintiffs have the burden to prove their case. 7 plaintiffs. But we're not having 7 trials, we're having one trial with 7 claims. You have to keep in mind that if I say plaintiff or plaintiffs, all the evidence has to be there for each of the people. So you're going to deliberate 7 cases, all built around the same evidence. You wouldn't have 2 trials for 2 people in the same car when there was a wreck at the same intersection with one other car. You would have both the plaintiffs who got injured in the car wreck in the same trial. Otherwise, it would take 7 weeks to try a case you could do in one. But the jury needs to understand each of the plaintiffs has to prove their case. If 6 out of 7 do, that's fine. If number 7 didn't. So the verdicts would be different. What amount of proof do they have to have? In civil cases, generally you need to know what's called the preponderance of the evidence. There we go with law school. Preponderance means you push the scales a little bit in your favor. There's slightly more evidence in your favor than evidence opposed to you. So in the scales of judgment, everything's equal. Plaintiffs, if they don't prove by a preponderance, don't prevail. But they only have to tip the scales a little. Number 6 was in a criminal case. The judge might have said the burden of proof in a criminal case is different. It's beyond a reasonable doubt. Before someone can be deprived of freedom, which the criminal case is all about, the scales have to shift beyond a reasonable doubt. Significantly different. I'm telling you that to help you understand that in this case, the burden is slightly in favor. You convinced me slightly more than the other side. There's a few places where I'll tell you the evidence has to be a little bit greater, but for the most part, just understand now, plaintiffs individually have to prove by slightly more evidence in their favor than evidence opposing them, a preponderance of the evidence in order to prevail. A separate decision for each person. If the case gets to the jury, then you'll find 7 verdict forms. Actually more than that, but if you think of it, each plaintiff has to prove their case by a preponderance. And you have to keep track of this in your decision making. If 4 out of 7 prevail by a preponderance, then the verdict would be in their favor. If 3 don't prevail, then the verdict would be in Mr. Foreman's favor. Everybody understand that concept?
Yes.
Yes. Okay. With regard to media and publicity, I should have said it at the time to circle back. You're left out of it, like nobody's allowed to record your identity. The media knows, like when they start running their camera, that it's not the jury. We give you a certain amount of anonymity, but you don't get complete anonymity. Mr. Heller has to pay you. He gives you a voucher with your name on it. And the voucher with your name on it goes
Guys, one of my favorite gaming streamers is in the chat. I'm going to drop a link to VG Squirrel. Make sure you give a subscribe if you like retro video gaming. Thank you for the well wishes. We're just here checking out jury selection over here in the Afroman trial.
Goes to the auditor or treasurer? Yeah, and then the auditor is going to give you a paper to go to the treasurer. So 3 public offices are going to have the paper with your name on it say, pay you. It takes work to get that. But I could never promise anybody complete anonymity. It is what it is. I'm just telling you how it works. In the courtroom, we call it weighing credibility. So let's talk about weighing credibility. If everybody agreed what the facts were, we wouldn't be here. So there's opposing contrary facts. And then you're going to hear opposing contrary facts. You're going to go, what am I supposed to do with that? Well, I'm going to ask you to decide which is more likely, which is reliable, which is credible, which is believable. And this whole process is about watching the witnesses, looking at the exhibits, considering their communications and their meaning, and then deciding who's more believable. If a witness gets up and stands and says something that opposes a prior witness, you have a problem. Well, I'm telling you right now, you have a problem. Because that's why we have trials. We ask you to weigh credibility. Does it sound like something mystical? No, I hope not, because we do it all the time. And you're doing it to me right now. Don't tell me because you'll break my heart. Who thinks I don't know what I'm talking about? It's okay. That means I'm not a good communicator. But you could have that opinion because you're watching me, you're listening to me, you're considering me compared to Judge Judy or the last judge
We are not.
or your expectations for what a judge does. And you're deciding if I'm believable. And you should. Like, I hope I'm a good communicator. I hope I'm credible. But it demonstrates the point. Because what you do, and I instruct you to do, is watch the witnesses, weigh their credibility. Everybody that testifies is sworn to be truthful. That oath applies to the witness. It does not bind the jury to believe them. Deliberations, I've never been in a jury, so I'm just telling you what's supposed to happen back there. Is a committee decision. We send you back at the end of all the evidence, with the instructions of law, and we tell you to arm wrestle, or discuss, or persuade, or criticize, or analyze, and do whatever it is you need to do as long as it takes to reach a consensus. So, like, I'm looking for a committee. Everybody been on some sort of committee, right? It's how we do things, right? If you're on the bank policy committee, then you got a bunch of smart people sitting around, don't know what they're talking about, trying to make a decision that we're all going to follow. That's what we do.
You're not wrong.
No, because sometimes you want people to don't know what they're talking about, to learn, right? That's how it works back there. And weighing credibility, like juror number 3 might have a complete opposite take than juror number 9 on believability of a witness. And then you're expected to stake out your territory and explain why you think it's a complete opposite view. And you might realize that your first opinion is not so good. Number 3 might go, oh, no, I like 9. So I'm going to change my opinion. That's what service is all about. So weighing credibility is a big deal. Everybody understands the concept?
Yes.
Like, I'm making really good progress. I'm getting ready to turn you over to the lawyers. A couple more things. Is there anybody who has a conviction against judging others? There are certain faith systems that say you're not allowed to judge. You're not allowed to participate in civic function. Anybody have that?
No.
Religious conviction? Anybody know what Matthew 7:1 is? Judge not lest you be judged. And some places use that literally and say, as a member of the church, you can't do that. So that doesn't apply to them, right? Matthew 7:2, anybody want to take a stab at that? For so as you judge others, you yourself will be judged. I use this on every juror because 7:1 says, judge not lest you be judged in a manner hypocritical, applying a standard to somebody else that you would not want applied to yourself. When you deliberate, when you go back there as a committee, your job is to reach a verdict you can all live with, but it can't be a hypocritical decision that you want to apply to somebody not yourself. You would say, if I was involved in this trial, this would be fair to me. Got the concept? It's not easy. Like number 7, when you served as a one-day trial, would you say it was easy? 5, I'm sorry, number 5. Number 5, you finished. Was it easy?
Sorry. No.
But you got it done.
It wasn't easy, but we deliberated, and that's what it is. We all deliberate and we come to a conclusion, a final yes or no.
That's the goal. If
Yes.
anybody says it's easy, they're misrepresenting the importance of the outcome. Like a one-day trial sounds like it moved along pretty fast.
Yes.
Didn't exhaust you. The concept was understandable, but the decision-making process takes work.
Yes.
And that's what we want you to do, is take this seriously, not have distractions. So circle back to who's distracted. Anybody? Got other things? I think I know number 6 has a medical appointment for his wife. Right? I didn't forget you.
Yes.
I didn't forget you. Anybody else have something else? Number 11 works there.
Yes.
Anybody, something jumping in their mind? Okay. Mr. Klingler goes first just because he's the plaintiff's lawyer, not because he's taking sides. Go ahead, Mr. Klingler.
Thank you, Your Honor. Morning, folks.
Morning.
Thanks for being here. Judge Hein has done a lot of my work for me, frankly. But I do have a few more questions I'm going to ask you. And I want to let you know that I do voir dire jury selection a little differently than a lot of folks do. I think a lot of times you expect lawyers are going to ask you a bunch of questions and then they're going to decide, we're going to decide who's good for our case and who isn't good for our case, and then some of you might be excused, and if we think you're going to be good for our case, you have to stay on and you have to be here whether you want to or not. But I think you ought to have some say in whether or not you're here. So the first question I'm going to ask you is, are you willing to have a conversation with me about some of the things Judge Hein talked about, some of the things maybe we haven't touched on yet? Have a conversation with me, and at the end of that conversation, tell me if you think you want to be on this jury or not. Are you willing to do that?
Yes.
Raise your hand if you are. I appreciate it. Thank you. Now, there's some restrictions. I can't talk to you about the evidence. I can't get into the specifics. But what I'm going to do is get into some of the principles of this case, some of the issues that you're going to be grappling with if you are a jury on this case. So understanding that I can't maybe answer your questions, we're not going to tell you what the evidence is, we're not going to get into a lot of details, but just sort of some of the principles and issues. Are you still willing to have a conversation?
Yes.
Thank you. And at the end of the case, I will tell you, and not the end of the case, the end of my questioning here, mine and Mr. Osborne's, if you tell me that you don't want to be on this case for whatever reason, I'm going to do everything I can to see that you don't have to sit on this jury. Now, I don't have the power to do that solely. Mr. Osborne has a say, the judge has a say, but I have some say, and I'll tell you, if you don't want to be here, I don't think you're going to have to be here. And so I will do what I can if you tell me at the end of this that you don't want to be here. Is that all right with everybody?
Yes.
Okay. Thank you. Let me pick up on a couple of things Judge Hein asked you and just ask, I apologize if you answered this and I didn't quite get your answer, but do any of you know Mr. Foreman personally? Have any of you had a conversation with Mr. Foreman?
No.
No.
Have any of you heard his music?
Yes.
Could you raise your hand if you have? All right. And have any of you gone to any of his shows, his live shows?
No.
Have any of you bought any of the merchandise that he sells? T-shirts?
No.
Has some beer, I think, that has his name on it some places, maybe some
Someone
marijuana,
opens their
some
jacket.
places that has Afroman's name on it. Anybody ever bought any of that?
No.
I'm too old to remember this, but you're not. Back in the 90s, I think, there was a popular song, maybe Mr. Foreman's first real popular song, called something like I Got High, or I was going to clean my room and then I got high. And I've talked to people who really didn't know much about him, and then I mentioned that song, and oh yeah, I remember that song. I think it had some 315 million listens or views on YouTube. Anybody know of that song? Yes. Now, some of you have seen news reports and social media postings about this case. Would you raise your hands again if you have seen anything at all about this case on the news? Thank you. So I just want to ask you these questions. Did any of you share or forward any of those posts to anyone else? Any friends on Facebook or anything? Yes, number, I'll refer to you as 13, thank you. We're not using names here, so I apologize. We're using numbers today, so tell me about that, would you?
I just thought it was really newsworthy. I am a retired teacher. I remember when the song came out, the kids dug it. And so I shared it with people who share my experience of working with kids.
Yeah.
It had an impact.
Is that the Lemon Pound Cake song, or which one are you?
That was, I got high.
Oh, so
I was going to clean my room, I was going to do my homework, all that stuff. That was...
Gotcha, all right. How about this lawsuit?
I
post postings about this lawsuit and...
Yes, I've shared.
Okay.
Well, wait a minute. Yes, I have.
Okay. With friends?
Yes.
Judge Hein told you a little bit about what this case is about. Would you mind telling me, from everything you've heard, what would you say this case is about?
Your
as
Honor.
you sit here today.
Stop.
If we may have sidebar, Your Honor.
Oh.
So you guys come over here. Let me explain how this works. Lawyers often want my attention for like evidentiary or process reasons. So like I don't mean to like be rude to you. So when I go huddle up over here, it's my way of trying to clear the deck really quickly. You're going to get this white noise thing that I don't really care for, but it's what we do so you don't hear what they're talking about. So it's just our way of quickly dealing with this instead of running to a different place and having Shirley grab the paper for to run with us. So that's what we're doing for it happens all the time. If lawyers interrupt, say object, it's part of the process. So don't misunderstand them as rude. It's just what we do.
Okay. Pointing at.
Go ahead.
Okay, he says he's suspects he's about to ask about the social media. I'm scared to turn this up because I don't want it to blare out, but we can kind of hear. Oh, I think the reporter said she can hear them.
I cannot hear you, which it's not going on record. I know the speaker's on, but it's not recording.
Okay, I will summarize this. Certainly. Is everything else working? Are you getting any of this? What about the whole hour and a half we spent?
Yes, that was all. Just the sidebar. No, it's just the sidebar.
That would have been really fun, right? Just start over.
Everything else is working, it's just the sidebar.
Light brown hair? How did that happen in the trial?
Me?
No, me.
Oh,
No, the tape recorder worked until we tried to listen back a week later, and none of it worked.
oh my gosh.
Yeah, oh my gosh, no. Mr. Klingler is going to go ahead again. Thank you, Mr. Osborne.
You're good.
Okay,
You
thank
were
you.
recorded. Okay. So I was asking, if you would mind just telling, as you sit here today, what do you think this case is about?
Are you asking me?
Yes.
13? Okay.
Yes.
As I understand it, I think this case is about, it's a suit against Afroman, accusing him of having defamed the officers. If that's what I understand so far. I haven't actually read the paperwork, haven't seen
No,
the
that's,
suit, but that's what I understand.
that is.
Record for his art.
And I believe that's what Judge Hein said, and I appreciate your telling me that. Does anybody think this case is about the execution of a search warrant at Mr. Foreman's house? That that's what it's all about? Because a lot of the news media and a lot of the things that have been out there for 3 years now focus on the search warrant issue. But you'll find, if you sit on this jury, that that is not what the case is about. And so my question for you, and I appreciate it, and for everybody else is, does anybody have any confusion or question about that? This case is about defamation and false light, about alleged what we claim are false statements that were published.
So look at the attorney taking
about
notes.
These 7 deputies. Is everybody okay with that? Anybody have any questions about that? Because the reason I'm belaboring it a little bit is because it's been out there for so long, and some of you have seen a lot of it. And it's hard to put out of your mind what a case is about when you've seen media for a long, long time. But the case is about defamation. Everybody cool on that?
Yes.
So the Afroman's attorney is taking notes back here, and I think I've watched like one voir dire from it was an old video on YouTube because it was still square. Like, remember original recordings and YouTube uploads used to be square. So it was like a decade ago. It's like an old voir dire that I watched, or voir dire. So I don't always get to watch them. But I hear attorneys say all the time that the case can be made just with jury selection. And it's not just a matter of who you pick. It's also through your voir dire questions. You can start to sow some seeds and kind of lay the groundwork, the foundation of, you're going to hear this at trial, you're going to be able to sit through that type of stuff and pay attention. And it gives you a way to start like feeling out your theory of the case, the evidence you plan to present, and start hinting at your arguments during this stage. So you see this attorney taking notes here. I suspect that when it's his time to do some questioning, he's going to do a little bit of counter argument against what this attorney just did. Oh, Donna Adelson's Blood Online? That's
On the
cool.
court's docket and looked
I'd watch
at the
that.
filings in this case, kept up with what's being filed at the courthouse?
No.
Yes.
I tried, but I didn't succeed.
Okay.
So
Couldn't pull them up?
I got lost in the weeds of navigating the court website. I just couldn't get it.
You haven't read any of the motions and things that, all right. Thank you. So, have any of you got the impression from anything you've heard or read about this case that Mr. Foreman has been treated unfairly by the deputy sheriffs?
Can you repeat that question again? I'm sorry.
Yes. Have any of you gotten the impression from anything you've read or heard that Mr. Foreman has been treated unfairly by these deputy sheriffs?
We've got all the video gamers in the chat. We got video games in the chat. Good to see you. And thank you also helping out in the chat, reminding anyone that's just tuning in now that this is from day one. So the jury is deliberating, guys. And until there's a verdict, I can't tell you when the verdict's going to be. So thank you for the help in the chat. I know everyone coming in, they're like, oh, this looks live. I do try to keep information in the banners to help us along. And I'm going to drop video games link in the chat. So for all my video game fellow friends out there, if you don't already know video games, make sure you hit that button. Also, big thank you here. Prince of Wales had said life gave Afroman lemons. He made lemon pound cake. I disagree. I think lemon pound cake was made and it gave us life. So always good to see you, Prince of Wales. Hope you're doing well. Auntie wants a song about this bloviating judge. I feel like that might be the type of thing. I'm not all that artistically creative, but at some point you just lose your creativity. You get tired of hearing something, and maybe you just end up uninspired after waiting for so long for someone to stop talking. But I would love to hear any song come out of this, or even if the Pledge of Allegiance clip, where because it's Afroman standing in an American flag suit with everybody standing behind him. And I feel like that could be such a great clip to start off a new video that Afroman might do. So that would be super cool to see. I'm sure there's plenty of material here that Afroman was sitting in court already running through his head. Like, I want to make a song about this. Sassy Experience, always good to see you, says, Judge wants his 15 seconds of fame. Sir, go teach a first-year poli-sci class and put it on YouTube. You're doing absolutely too much and it feels out of order. He doesn't seem to think highly of YouTube content, so I don't know if he would do that. But maybe it'd be fitting if he doesn't think highly of YouTube that he should bring his opining over here. But yeah, this judge, I'm not a fan of this judge, if you guys can't tell. I have not watched him through a criminal trial, but I've seen several people raise some concerns about his actions over in the Pike County trial, where it seems like he got reversed. So, yeah, it doesn't come off good on first impression for me. And thank you for the 5. Violet, thank you for becoming a member. We've got Sassy with another saying, hey KNW, I'm late. This is a replay of the start. So this is day 1. And the reason we have this available, it's the court's official footage. That's why we saw the court reporter a few minutes ago saying like, hey, everything else is being recorded. I just can't hear the sidebars through the feed. But the Watchdog Wire, Chris Hicks, he went and obtained the official courtroom footage because WCPO9, who is in control of the only allowed camera, media camera, in the courtroom, hasn't been capturing the full footage. And they uploaded it. It's available on their channel. So please go support them, follow them, pinned in the chat. I want to reach out to Chris and see if he'll join for like a quick 30-minute chat on if you're interested in what's going on in your local courthouse, anywhere in the country, you know, what's the best way to get started on figuring out how do I go and request something? How do I find out what my local rules are? How do I apply in a way that's going to get me approved without restrictions put on it? How do I fight restrictions? He seems insightful, and I'd love to, for anyone that's out there that wants to find a way to go and promote access and transparency in courtrooms, I'd love to have him on. So let's see. And back to this, we'll get to the, he is gripping that lectern. Let me just hit the play button. Oh, hold on. Wait, he just got 1 million subs? He was waiting. He was really close to it. Hold on. That's hilarious. Imagine you sue somebody and it gets them to the 1 million mark on YouTube. I'll drop his link too if you guys don't already subscribe to Afroman. Yep, it's showing 1 million for me. If I zoom in. There you go. It's officially the 1 million. So thank you, Chicken Shite, for the update. What an exciting update there. And it's OG Afroman if you want to search for his name on social media. So there we go. The No, I don't. I mean, I keep refreshing. I don't see any information that the jury is ready with a verdict. So as far as I know, they're deliberating, but they had to wait some time for printouts. And then they were also going to have lunch. They were also told, like, if they were leaving, you know, they're going to get communication with the bailiffs to give their phone numbers to the bailiffs. So I don't really know how long they've been deliberating. I know that court recessed around 11:40 a.m. Eastern. So we're coming up on the 2-hour mark in 3 minutes. But again, that's including all those other variables. So, but super, super cool. I think it's super cool that Afroman hit 1 million followers. And of course, he said, actually, I think I might have the insights. Let me see. Because of the studio plugin. How do we see subscribers? All right, so if we look over here, and this isn't always up to date. So right now it's currently showing for March 18th, 7K subscribers today, 4K yesterday, and 3K yesterday. The day before that was just like 250 subs. So it'd be pretty unreasonable. Oh, I'm blocking it with the comments. But there you go. The 18th. So far, 7K estimated, 4K on yesterday, and then 3K on the 16th, 250 on Sunday before the trial started. So I think it would be unreasonable for anybody to sit here and say that this trial hasn't helped grow OG Afroman's following. And although not every follow means you're a fan of somebody, I would say the majority of somebody that are following people probably aren't just hate watching. I don't really know if OG Afroman's the kind of channel you'd hate watch anyway. But this would be, in my opinion, a strong sign of public support. The public supports Afroman by and large. So there we go. Back to voir dire. Prince of Wales says, I would super chat a grand, but I'm not high. That's okay. That's okay. If you ever want to get high and do that, I'll put it to good use, I promise. Put it to good use. Some legal documents. But thank you anyway for the 2. We've got... Ooh, it's Trenton. Says, I was just rewatching Afroman's testimony. I think he even should win on the claim I was on the fence about. He investigated a cop and based his claims on that. Yep, and I really think it was strong for David Osborne, his attorney in closing, to break down proximate cause. I think that was really important. Because to me, proximate cause, that made me start thinking about, we're here because of this police search on his home. So, we've got, let's see. I've got 2 banners up, just to make sure everybody tuning in now knows that this is not a verdict reading. This is a rewind, day 1 jury selection. With the nice rain sounds in the back.
Hold you for just a second and make sure there's nobody else. Is there anybody else? Because frankly, if you've seen most of these posts, that's kind of what a lot of them imply.
Exactly.
The last couple of posts I've seen over the weekend and the end of last week have implied that Mr. Foreman was being treated unfairly.
Thank you for that, appreciate it. And I'll get back to you, 13, anybody else, posts over the weekend, posts a year ago, anything at all, that have given you that impression? Because if it has, that's fine, I just want to talk about it. So, let me ask you, 11, we go by 11?
Yes.
Number 11. Can you tell me more about the impression that you've had from seeing these posts?
Just that said search warrant was executed unfairly and things were damaged in the process. And I didn't really read too in depth on it. It was just like skimming, hey, that's interesting, on my way. But that's basically the gist of what I saw online.
And if the judge tells you, and if the evidence in this case is all about statements made by Mr. Foreman on the internet about these deputies, and it's not about damage caused in the execution of the search warrant, would you be able, you think, to set aside what you've seen over the weekend and make a decision just based on the evidence that you hear and see in this court?
Yes.
Thank you. 13, I want to get back to you. The question I asked, now I forget, but I think you remember.
This man could be younger
No, go ahead. I think you said that you had seen you have had the impression that Mr. Foreman was treated unfairly.
I was concerned when the case first hit the news with the fact that his door was broken down, and that, I saw the videotape of the pockets, his clothing being gone, that they were searching through his pocket. It looked really invasive.
It did, didn't it? It looked really...
And I just knew that I wouldn't want that happening to me or anybody I cared about.
Same, girl.
And so I think warrants need to be executed really carefully.
Okay, I appreciate that.
Discretion.
Anybody else's trigger, anybody else's memory about what you might have seen or heard about the execution of the search warrant? Okay. Let me ask you this, 13, and I want to ask all of you this question. Do you think it's ever justified to tell lies about people that you know are lies on the internet? Even if your house got broken into and a door got broken down and damage was done, that wouldn't... Anybody feel differently? I mean, they had it coming, Number 3, what do you think?
They had it coming. I'm following your statement on how I want to say that.
I thank you for telling me that, because I don't always speak clearly. Some people might think, well, they had it coming to be attacked and lied about on the internet because of the way they executed this search warrant. They shouldn't have done that, so they had it coming. That's what I meant. So
yeah, that's not true.
you don't agree with that?
Right, I don't think they had it coming, no.
Well, now, I think you're going to hear a lot about freedom of speech in this case, in the First Amendment. And my question to you now is sort of similar, but it's a little bit different. I think you're going to hear from Mr. Osborne and Mr. Foreman that freedom of speech gives Mr. Foreman the
I
right
agree.
to say anything he wants on the internet, even if it's not true and even if it hurt people. And, I mean, I just like to get a little conversation going. Honestly, what do you think? I mean, the First Amendment, we all believe in the First Amendment. It's important. Some people might think, well, you know, yeah, First Amendment's fine, but, you know, some things are off limits. And some people might think, First Amendment, freedom of speech, you should be able to say anything you want. No limits at all. And that's one of the issues you're going to have to be thinking about in this case, and I'd just like to have a little conversation about how you feel about it. Does anybody here who feels like there should be some limits? For example, you can't go out and tell lies about people. Would you raise your hand if you agree with that statement, that you shouldn't be able to go out and tell lies about people? Anybody hesitating on that? Anybody have any little inkling in their mind, well, maybe? Yes?
My opinion is, if anybody tells a lie, it's not up to, it's up to the defense and the, geez, I can't think of the name, but it's up to both of the platforms to go and tell the truth, and it's up to us to weigh the truth. So they have to present their case.
Yeah.
They have to present it with full evidence, and then we are the ones that are given the evidence, whether or not it's right or wrong.
Absolutely.
So that's for your discernment.
Yeah.
You'll know.
Yeah.
You'll know. And that's how.
I think she needs to be struck for not understanding the burden, but if she says that she can be instructed on the burden and follow that instruction, she might be good. But she's saying it's the defense's burden to prove what against what the plaintiff is claiming. And just for what it's worth, I think psychologically that's what a lot of jurors expect. She's just saying it out loud.
About guilty or not guilty.
Yeah, absolutely. You're right.
So you can talk all you want to on social media, but it may not get to us because it doesn't pertain to the case.
Understood. Thank you very much.
That's the way I think.
Yeah. Any other thoughts on that topic? Law enforcement officers, I know you all marked on your questionnaire whether or not you had family or friends. I mean, does anybody have law enforcement in the family? I didn't think you did. No. And you may have answered this for Judge Hein, but very quickly, anybody ever been arrested by any of these officers or any sheriff's department person?
No.
Anybody ever been a subject of a search warrant of any kind?
No.
Yes, ma'am.
My son was, and back years ago, he was online doing something, and the FBI came to the house and wouldn't let us leave until everything was searched and all that.
And I'm sure that wasn't a pleasant experience.
No, it wasn't.
That wasn't local law enforcement.
No, not here. It was in Claremont County.
Okay. It was the FBI.
It was the FBI. But everything was fine. He wasn't guilty or anything taken to court. It was through the social media and gaming.
Yeah.
So,
good.
But yes, I've had the experience, and it's not fun at all.
Yeah. Well, I'm glad that worked out.
Yes.
Another thing that you will be hearing about in this case and thinking about if you're a juror is reputation. The idea of a person's reputation. I'm going to assume, without asking you a silly question, that everybody thinks their reputation is important and they'd like to defend it, protect it if it gets attacked. Is that fair to say with everybody?
Yes.
Okay. These deputy sheriffs and some former deputy sheriffs, put on a uniform and they face the public and they do what they do on a day-to-day basis. And sometimes they arrest people, sometimes they have to tell people to stop doing things, sometimes they do things people don't like, and so sometimes they get yelled at, and sometimes they might even get attacked. So they have to sort of have a thick skin, is the way I look at it, and I think a lot of people probably do. You know, they ought to expect more attacks and jabs and things than an ordinary person, because that's just part of their job. And I think you'll hear that that's certainly been their experience. And my question for you is related to an earlier question, just with this context about them being police officers. Does anybody think that since they're police officers, they ought to be able to take it if lies, if we prove that they were lies on the internet that damage their reputations, if those are told, if that happens, does anybody think, well, that's okay because they're police officers, they ought to expect?
No.
I see a lot of heads shaking no. Anybody think maybe they should be able to take it? Thank you.
I'm sorry, for your next question, I really need to use the restroom.
I will ask for a break.
How much more time do you need?
Probably 10 minutes?
I can wait 10 minutes.
I should have said 30, but...
I'm sorry. I mean, we can change it to 30.
No, you can't.
Are we sure?
5 to 7 was my range.
Okay, all right, Jim.
I'll range.
Thank you for reminding me to move along.
Go ahead.
The last topic, really, I want to talk with you folks about is damages, which is what this case is about. In a civil case,
Look at Afroman.
nobody goes to jail.
I know I always love to appreciate those that listen while they're working. They can't pay attention. Afroman is nodding. He said, yep, this is about the money. So look at him while he asks this question.
Talk with you folks about is damages, which is what this case is about. In a civil case, as you know, nobody goes to jail, nobody gets a criminal record, nobody gets a fine. The only thing the jury can do is make an award of damages, and that's money. That's what it comes down to. Every case, most cases have two kinds of damages. Economic damages, that's like doctor bills you had to pay, and property that was damaged, and economic damages come something with a price tag, something that money can buy. And then there's another kind of damages called non-economic damages that you'll learn you can award. And that's what this case is about. These deputies don't have doctor's bills and things that they want, things with a price tag that they want you to award money so they can cover their expenses. This case is about non-economic damages that don't have a price tag. But it's things that still have a real value, even though they don't come with a price tag. And so all a jury in a case like this can do is give a verdict that stands in, that represents what's been lost or the damage that's been done that you find might have been done. It's not something that's going to buy anything. It sends a message, it represents, it stands in for the damage that's been done. That's what a verdict in a case like this does. Does everybody understand that? It's hard to put a value on a money amount on non-economic damages. Because they have a value, but we really don't know what it is. There's no price tag. And that's what you, as the jury, are going to have to decide. If you find in favor of these plaintiffs, you're going to have to decide what kind of money would stand in for what they've lost and represent what they've lost. And at the end of the case, if you're on this jury and we get this far, I'll try to give you some guidance in my closing argument about how you might think about that, but it's your decision. And it's not an easy one, because like I said, there's no price tag. Anybody have any questions about that or concerns? Yes, 13.
So are those punitive damages? Is that what you're talking about?
This case will involve punitive damages if Judge Hein says it does at the end of the case. But it's a possibility right now, the way things stand, that you would be asked about punitive damages as well as what we call compensatory, which is the non-economic. So that's a separate category. Thank you for bringing that up. I wasn't going to bring that up. Punitive damages may be appropriate in a case where a person acted with particular malice and ill will. And that is an issue that we expect the evidence to establish, and we'll see where we stand at the end of the case with that. But thank you for bringing that up. That's separate from the non-economic that I was talking about a minute ago. It's a separate category of damages. Punitive damages is really meant to punish bad behavior. Non-economic damages that I was talking about are meant to make up for what has been
punishing
lost.
the defendant.
Yes. Punitive damages are punishment. Compensatory damages or non-economic are loss of reputation, personal humiliation, emotional distress, those things that don't have a price tag but have a lot of value. Thank you. I think I'm close to my 5 or 7 minutes. Folks, thank you very much for your attention. You've been very attentive and open and honest. I appreciate it. Thank you.
Thank you.
Do you have challenges to clause? Yes or no?
Yes, right now.
No. Step back. Okay, so here's the morning parade. These 12 people over there like ought to go to the head of the bathroom line if you folks don't mind. So as fast as we can, because the quicker we get through this, the sooner everybody goes home except the ones we need. So like you folks step out real fast, go. They'll give you like a 30-second head start. Go off the record.
Oh my god. They sound like they're stampeding out of there. Alright, so let's skip this. Oh, okay, they cut the brakes for us.
Let's go ahead and get settled in. Thank you, Mr. Klingler. And we'll let Mr. Osborne go ahead. He's got the same like 30 minutes to get us going. So go ahead, Mr. Osborne.
Thank you. Ladies and gentlemen of the jury, my name is Attorney David Osborne Jr. In this case, I represent Mr. Klingler. I'm going to ask a couple of the questions starting out that our Honorable Judge Hein asked. First one being is, do any of you know me? I know number 13, you know me from when I ran for prosecutor. Does anybody else know me? Anybody else been represented by my office? Okay. Does anybody know my secretary, Abby McCorkle?
No.
Shelby Hull, my other secretary?
No.
My wife's a teacher. Has anybody ever interacted with her, Martha Osborne?
No.
What about my brother? He's a teacher also, Clayton Osborne?
No.
Okay. So, when we look at jurors, we're trying to find a juror that would fit the case. The first thing we want to do is make sure that there's no conflicts. Hence why I ask if you know who I am, if I've represented you. Because, well, perfect example, if I was on the other side of a case, you might think a lot less of me than if I was on your side. So we would want to take that into account. Now, Juror 13, you've you knew me from when I ran for prosecutor. Has that influenced your opinion about this case any at all? Let's talk about when I ran for prosecutor. Do you think... So when I ran for prosecutor, I ran as a Democrat for this position. Now, I was called a lot of names, right? I was actually called a baby killer and a lot of things because people assumed I supported abortion and everything. So, sir, do you believe that I should have just stood there and take that?
No.
Why not?
I mean, why would you let somebody sit there and say stuff about you that may not be true?
But I put myself out in the public. I ran for public office.
That's true. And people have the right to say what they want, but...
You would imagine that's their opinion, right?
Yeah.
What about you, man? Do you think when I ran for public office and put myself out there to the public, that they had a right to have opinions about me?
No.
Why not?
Well, let me rephrase that.
Okay.
Yes, they have the right to their own opinions, but not to... I'm trying to figure out how to word it. Not so that it would be detrimental to your reputation or career.
Well, let's unpack that a bit. How would that change if you were the President of the United States?
What do you mean?
People say harmful things about the President all the time, don't they?
Yeah.
Could anybody be
Did you see
president?
everybody say something to us?
That would be impossible.
So when I talk about the freedom of speech, and I refer to the First Amendment of the United States Constitution, do you know what I'm referring to, sir?
Yes.
Okay. When was that amendment, or I should say, when was the first one, amendment number 1, first? When was that passed?
Well, I couldn't give you the exact date. 1776, I don't know.
A long time ago, right? So, do you believe that each person is different? Like the president is in a different position than, let's say, someone such as our bailiff?
Yeah, that's unfortunately, yes. We all like to be equal, but yes, it's not always the case.
So you would agree that public officials kind of are held to a different standard then than just a normal person?
Yeah, I believe so, yes.
And that would have applied to me when I was running for prosecutor because I was making every bit of my life known.
That's true.
Do you agree with that, ma'am?
Yes, I agree.
So, would that explain why I couldn't sue? It's not fair, is it?
No.
But it does make sense.
Yes.
So, we all understand now why Richard Nixon was called Tricky Dick. It was a nickname we all did at the time. I mean, we've had numerous ones today. So if public officials are held to a higher standard than a normal person, can you take that into account during this case? And I know Mr. Klingler talked about malice and ill will. Would it surprise you guys, specifically you, ma'am, to know that that is not the standard in this case when you talk about a public official?
Not sure.
Okay. What if I told you that for a public official there was an actual term called actual malice that is even more than just ill will? Would you have a problem applying that standard to a public official? Would you let your emotions, let's say someone said,
I haven't seen written instructions, but the judge did instruct on malice or reckless disregard when he was like verbally going through the instructions. So maybe there's a different statement on the written form.
something extremely derogatory, such as calling me a baby killer. If that was their legal right to do that and criticize me, would you have a problem finding not guilty for that?
So, I don't know, I don't understand the question, I guess, like
Let me tell you a story, I think that'll illustrate.
Okay.
I had a lot of cousins that went to Vietnam, and they all came back. And I remember sitting down,
talking to one of them, and he said that the biggest thing he remembers is getting off the plane and being called baby killer. And I always asked him how that made him feel. And the answer always shocked me, because he said he had no problem with it. He said he was fighting for that right. That's what our country is the right of freedom. Not absolute freedom, yes. So does that illustrate more of the point?
Yeah, right. I agree with that. You have your opinion.
And you agree that some people would present their opinions as fact,
Yes.
such as calling me a baby killer. Can we prove that wrong?
Yes, like, it's not like you're actually stealing children from their homes and killing them.
Good point. I should have thought of that during the election.
Hey, Nick Starl friends.
Now, this is a really stupid question, but I gotta ask it. Mr. Klingler has mentioned that Mr. Foreman might have an alcohol named after him or a marijuana strain. Does that affect any of you guys?
No.
And I'm gonna tell you why I asked that. So you guys are like, what would you? My grandma, who has passed on now, was a diehard Baptist. And if she ever caught me drinking, I know exactly what would happen to me. Because she was like, you don't drink. And so that's why I asked that question. But some people hold that belief, like my grandmother. So now you know why I'm asking questions. Because I want us to have a dialogue. I want you guys to understand why I'm asking questions, because some of the questions come out of thin air. And I don't want you guys to be confused. You have to forgive me, I take notes as we go to ask my questions from, especially as defendants. We talked about a sports analogy called NIL. I'm going to be honest, I don't know what it is. Sir, do you know what that is?
A sports analogy?
Yeah, it's something about name, image, likeness. I'll be honest, I don't watch sports, so I don't know that much about it. Would it surprise you to learn that this case is nothing about a person's image and use of it?
Yeah.
Would it also surprise you to know that as a public official, like when I ran for prosecutor and made myself a public official, I had no legitimate right to my image?
I'm sure I understand what you mean, legitimate right to your image.
I will rephrase that. That is a good point. Do you think Donald Trump should be paid for every time his picture is taken up in the newspaper?
No, take care of the national debt, but I mean,
But we all understand that public officials are photographed all the time. Actually, as Bob said, when officers put on the uniform and go out in public, they're photographed all the time. Mr. Klingler talked about reputation. Sir, what is a person's reputation?
Oh, somebody, how they want to be perceived, for your good person, bad person.
How a person wants to be perceived? I ask that because I always want to be perceived as Matthew McConaughey, you know, and get paid to do a Lincoln commercial, but...
I mean, reputation, I mean, A lot rides on the reputation.
That's true. It takes a lifetime to build, doesn't it? And everything you do is part of it.
Yes.
All the good and the bad.
Yep.
So when an officer puts on a uniform and goes out in public and does something wrong, does that affect his reputation?
Oh, yeah.
There you go. That was a pivot.
So a person can have a bad reputation just due to their own actions.
Yes.
Sir, do you believe that just because a person is a public official or a police officer, they automatically have a good reputation?
No. Why not? Have good and bad in every case.
Good and bad of everybody, right?
Yeah.
Good and bad prosecutors, right?
Yeah.
I make a joke of myself on that. So. Ma'am, what do you think about that? How does...
Definitely, you are acting yourself, and some people, if you act out of order, you know you're going to get a reputation on that. So it's whether you do good or you do evil. And you will be judged by people. Name the big guy up there.
So how a person does their professional duties looks on their reputation?
Well, yeah, you have to have a good reputation, I think. You know, you have to be, I stand on justice and value what your, decisions are and all that. And if you deter away from that, that's kind of a way of getting a bad reputation also. You have to be true to people.
So,
high or low, it doesn't matter, you have to be honest.
how does that, you said they have to be honest.
Well, if you're caught in a lie, you're going to find out real quick how quick that's going to further you into being unreputable.
How does that play into a public official? Because, let's face it, as you read the news today, you can pick either side, good and bad. How does that affect a person's reputation?
Well, everybody has what you call enemies and friend enemies. There's what I call friend enemies. They think you think they're your friends, but they aren't. I mean, we all have that, to be honest. So, my opinion is you have to be yourself, you have to be honest to yourself and to others. So if you don't, then that's where your reputation will kind of slide down and not be so honest. And is that what you want? So my opinion is you have to be yourself and know what's right and what's wrong.
So if someone said something like I was a baby killer during the election, should I have made a statement or released a statement clarifying that?
I say there's at certain points where you would want to defend yourself on that, but when it comes to being in the public, then you have to be very careful with how you go about saying it and defending yourself. But that's going to happen. Republicans, Democrats. It's always been that way.
I know. And when I ran for office, the first thing my mother told me was, it's going to happen.
Yes, it will happen.
And let's face it, the world is not the nicest place. Would you agree, ma'am?
Oh, yeah, I agree.
But that we don't silence the speech of people that's nasty, do we?
Yeah.
Has anybody ever said hurtful things to you that you wish they didn't?
Yes.
Have you ever said hurtful things to people that you wish you didn't?
Well, more than likely. I'm not good.
But you agree you have the right to do that?
Yes and no.
Tell me about that.
Just the moral compass part of it. Like, if I said something that hurt somebody and then I usually thought about it later, like, probably shouldn't have said that. But more based towards their feelings, I guess. Just how I was raised.
So when you look at that, you're saying you shouldn't be hurting their feelings.
Yeah.
Not necessarily talking about their right to say it.
Yeah, yeah. Everybody has a right to say it. That's the freedoms of this country.
So while I may have been hurt by being called baby killer, that's my personal feeling, and as a public figure at that time, and even today, I have to sort of take that. Would you agree with that?
Yeah.
I picked on you. I don't think I picked on you, and I don't mean it as picking on, as I try to keep a mental note of who I'm talking to, because I don't like to leave someone out because It's kind of like when the gentleman here said he thought they didn't like him. Just because I don't talk to you doesn't mean I don't like you. But I'm going to cover something here. It's completely off topic. But it's something I have to go through, and the judge will explain it later, which is, would you have a problem if I bumped into you in the hallway and didn't say I was sorry?
Yeah, that wouldn't be like the worst thing in the world, but it would bother me a little bit.
What if I told you that I'm not, once the jury's impaneled, I'm not allowed to talk to you in any way, even to say I'm sorry? Would that affect you?
No, then that would be understandable.
Okay. So,
And that's a common, I've heard several attorneys say that this is a common voir dire question.
some things are to be put in context with the law, makes sense.
Yes.
Okay. Have I picked one?
Thank you, Betty, for becoming
So
a
it's
member.
you I haven't picked on. Now you're in the hot seat. So, do you agree with his statement? That you can follow the law and that if someone bumps into you and doesn't say sorry, it's not meant to be an offense to you?
Absolutely.
Would you agree that with the freedom of speech, people may say things, but they have the right to do it?
Yeah.
Have you ever said anything hurtful on social media?
Probably not on social media, but I have said in person, yes.
Are you married?
Yes.
Then definitely you have. I've never found a married couple yet that didn't have a fight and say things they didn't mean. You hurt her feelings.
Look at Afroman.
You hurt her feelings. Yes. But you guys have the right to say that.
Yes.
Now there's a lot of questions about who's a public official. Ma'am, you knew it was coming.
Yeah,
Can you tell me what a public official is?
someone who serves the rest of us in public position.
So like the judge?
Yes,
Like, I'm not gonna get married. But like our prosecutor, Aaron Haslam?
yes,
Like our Sheriff Kenneth Dick?
yes,
Like Mr. Osborne who ran for prosecutor?
yes,
Failed miserably?
definitely.
Oh! You didn't have to say
I'm
that.
just joking.
Oh.
I don't even know you ran for prosecutor. I had no idea who ran.
Oh, that's okay. From the votes, I don't think a lot of people did. But that's okay. So they always say be thankful for what happens to you. I was thankful I didn't get the job. But, so a public official would be someone who works for the government,
Yeah,
who's out in the public where everybody would see it. Someone subject to public scrutiny. And it would even extend as far as when I was running for prosecutor. Because you would admit that if I was running as prosecutor and I got pulled over by the police for DUI, that would be pretty bad.
yeah.
Do you think the news would have any... Would you agree that the news would have a right to put that in the paper that I was pulled over?
Well, yeah.
I think I picked on everything. So I'm going to start over again. Do you think that that would cause people to form opinions about me?
Yes.
You believe those people are entitled to their opinions? As a public official, would you agree I should have a really thick skin when they say them in public? You don't have to say yes to everything, it's okay.
Well, I know, but I mean, you should be wary of your actions. You should understand that actions do have consequences.
And you would also agree that even taking a certain position in the public has its consequences.
Yes.
I mean,
Personally, I work in the school district. I am told constantly, watch what you post, watch what you do, watch what kids you're around, things like that. I know what my job entails.
So you're kind of, I wouldn't say a public figure, but under a certain amount of scrutiny.
Yes.
Parents can be mean sometimes, can't they?
Adults are the worst.
You would agree, though, that in some ways that is what makes us a great country, is that, like Mr. Hein said, we're not a dictatorship. You can't just turn off what people
Correct, yes. I've been in 10th grade twice, really learned my amendments. I'm an aide with a student that I go with individually, so I've been in 10th grade twice.
Well, I was
with the different students I've been with.
I was going to joke and say I still can't keep all the minutes straight.
There's one I'll never forget because one kid got really mad at me, and every time she had a punishment, she was like, "This is against my 8th Amendment right." And I was like, "What even is that?" And she told me, so I said, "I'm sorry."
Well, I'm going to ask you because
Cruel and unusual punishment.
Oh.
Because we didn't want to do what we had to do that day, and I was being cruel and unusual to her by making her do what she had to do.
At least she
So I will
understood
never, I will never forget that one just because of that kid. And she never forgot that one or let me forget it.
That was a good argument for you. I love kids. They come up with the.
Oh my God, yeah. That's what I said. I love kids. Adults didn't believe them sometimes.
Start wrapping it up.
Probably doesn't help my case.
There was a talk about damages and non-economic damages. How would you guys determine what a person's reputation is worth? Yeah, I'm going to pick on you again.
Well, it's not, I guess it's collaborative of everybody, but every juror is going to have a different opinion, so we have to come to a conclusion, the majority. But, or just make sure everybody is on board with that, but.
Would you expect evidence as to what
Oh,
a
I
person...
definitely, I hope that everything is presented in the case, because if they're not, then it's going to be damaging for either the prosecutor or the defense. So it's, you have to present a good case, and that's the only way, is to have the evidence and present it well. And then that's for us to decide whether or not it was presented well or not. Because I'm sure there's been some cases where it wasn't presented well.
When you say presented, do you mean that all the elements of the law have been met, or that just Mr. Osborne had the best beard in the courtroom?
No, if it's on defamation, then it should be paid every amount of information that you can get that was presented well and was checked into, presented.
So you would want to see the evidence of what was said, why it was wrong, how much the damages are worth, stuff like that?
Well, I expect everything to be coming, to be able to presume the amount of money, everything has to come in accordance with the evidence stated and how we present it. I mean, it's got to be, if it's on defamation, then we would know. But if it was, excuse me.
No, that's it, take your time.
It's just that evidence has to be brought up, and we have to know what is right, the right amount, and if it's false, we have to know the evidence and whether or not it pertains to defamation. You see what I mean?
Yes. Yeah. And so, sir, you would agree with her that you have to see the evidence and it have to meet the elements?
Yes.
And even as they're public officials with a higher bar than this lady here, they would have to meet that high bar?
I believe so.
Thank you, guys.
Challenge, comments? Okay. So we're making good progress, ladies and gentlemen. The next thing I do is talk to the lawyers about the privilege they have to excuse jurors with no explanation. It's the hunch. It's the art of the law. So I'm going to huddle up with them over here. We simply ask them yes, no, and then we'll reset the deck and keep bringing people in. So if you want to stand up, stretch a little, you're welcome to do that. Stay in your chair until I talk to the lawyers.
You are quite right. Chris, if you need that, can you turn it on? It's not, it's still not.
I can't hear. Oh my god, sorry. Sorry.
Okay, have a seat again. So these 4 people are going to be excused. When you leave, you don't have to leave. You're just not going to be in the panel. So if you want to stick around and watch, I'm not making you leave the building. You're just not in the panel. Like I get some people that are retired looking
Sorry, guys.
to do all day and I get easy entertainment. Just understand you're the public now, and you get the privilege of sitting there and watching. So 5 and 6 and 11 and 13 are all excused. Thank you very much. If you do leave, then you go to the clerk's office, you send you to the auditor's office, you send you to the treasurer's office. So thank you very much. 5 and 6, 13 and 11.
Thank you.
Thank you very much.
Good luck.
Thank you.
Thank you very much. So the next 4 jurors are seated over there. So number 14, let's have you sit over in that far corner, if you would, please. And then number 15, have you seated second in. Number 16 will go next to him. And number 17, no, would you go in the back? Okay. 16 on the end, yeah. And then number 17's in front. Right. Now, what we do now is focus on the 4 new people. So I'm going to talk to the 4 for the most part. The lawyer's going to direct your questions to the 4, just to keep winnowing this down. We'll speed the process along. What we're referring to you is number 14. Thanks for being here. What are you just dying to tell me?
That I don't want social media. I keep it to myself.
Okay.
I have a Facebook account, but I just use it for marketplace. And I just got my kids. because
How
I got
potentially
grandkids
criminal?
And I'm in line.
Okay. Congratulations.
Oh, well, I lost the share. There we go. See what I did, Sean? You show up and I start having tech
We'll do this
issues.
the hard way. Did you understand the concepts that the lawyers and I were talking about? Is there anything that got confusing for you, like you scratch your head and go, what? Some of it, yeah. Okay, like, I want to clarify it, so can you help me understand what was confusing?
Just all the legal stuff.
Okay, the legal stuff. For the burden of proof, slightly more evidence in your favor is the preponderance. The plaintiffs have to prove their case by...
All right, so let's take a quick segue here. There is no, I'm not aware of a verdict yet. So, for anyone that's new here, I do try to keep a banner ticking at the bottom of the screen. Sometimes I do forget to update it, but it'll tell you what we're doing. So right now we're watching day 1 footage that we didn't get to see previously. We're watching voir dire. They're picking the juries. This is before all of the evidence was presented, before the witnesses were called. And I don't usually see many trials where you get to watch voir dire, so this is new for me. And we just had potentially criminal come in here. He is a criminal defense attorney in Ohio. So potentially criminal, thanks for coming to hang out with us. And thank you for gifting 5 subs, super nice. I just dropped his link in the chat if you want to go check him out. He should also be in, his Afroman video should also be in the playlist in the description. I've been putting them all together. But Ashawn, if you have any, like if you want to throw in some tidbits about voir dire, like is this what you see here even though it's civil? Is this typically what you see? Let us know anything that you think would help us understand how things are done in Ohio. And always good to see you.
Slightly more evidence. You understand that concept? That makes sense?
Yes, sir.
Okay. Defamation. Making a false statement. Or false light is when a false statement puts somebody in an unreasonable light, misunderstood, by offensive light. Those concepts make sense to you?
Yes.
Okay. If I came back to you in a couple minutes, would you tell me what else I need to explain? The whole process is an education. Like I'm the school teacher right now. But I have a duty to make sure you can pass the exam. The exam is when you get the case in 3 or 4 days, whatever. You understand the rules well enough to make a valid verdict. So we all go to school all the time. Does that help you?
Yes, sir.
Okay, thanks. Number 16. What would you like me to know? What would you want to tell me right now?
Well, in this situation here, it'd be a financial hardship for me because in the next 2 weeks, when I work it, it'll be paying my rent. I won't be able to pay my rent if I next month.
Okay. What else do you want me to know? Did you understand like some of the legal concepts, things people were talking about?
Yeah.
All right. Thanks for that. And 17.
Well, I'm a farmer. I don't even use the internet, so I don't know anything about this case.
Dark County has really good crop land. Adams County mostly like cover crops and grasses and grazing, or what do you graze?
It's not as good as Dark County, but we do have soybeans and corn.
Okay. Farther north you go, the more it would be row crops.
Yeah, I mean, we raise a lot of cattle around here. I don't know if Dark County does.
No, not so much. Yeah, that's why I saw a lot of cover crop grasses. So are you in the row crops or are you in the...
Yeah, both cattle, row crop.
Okay, good. Used to be a big cattle area. We have a lot of dairy in the corner, but not so much hogs or feeder pigs or any kind of cattle. Right now, your blood pressure is down on crops.
Look at Afroman.
The herd is always the herd, right?
Yeah, I mean, cattle's high.
Yeah, but you have like cover, like to get the work done in the morning, get up early.
I got my son, he's in there.
Okay.
He feeds cattle for me.
So work's not a distraction.
No, I'm retired. I've retired 3 times.
Okay. So you're able to keep you here like 3 weeks?
But how long as you feed me?
I don't think I got that kind of thing. Anything that's confusing about you with regard to this case?
No.
So, Mr. 14, I can see you watching, right? You're paying attention to everything. Is that like normal for you?
Yes.
Right? Watching the lawyers?
It's what's everybody.
Yeah. Which one of the lawyers is ahead?
Not started yet.
You really believe that? You're really right. But you've been watching, right?
Correct.
You have impressions for using your eyes, right?
So forth, yes.
Yeah, I want you to. I'm looking at you to say what you're doing is what you should do.
Correct.
We want jurors not just to use their ears, but you have to watch people's impressions. If you're doing it with me right now, I'm doing it to you right now, we should. So when I ask you who's ahead, is to point out that you do constantly get information, but if you're deciding not who's ahead, you're doing it right. You're waiting until it's time to deliberate. But you are using your eyes, right?
Correct.
You didn't take the track. All done. So 15, are you watching, paying attention, working for you?
So it is.
Okay. Any problems with what you've seen or heard? So Mr. Klingler is going to direct his question to you forward again. It'll be less time. I'm going to speed this up as it naturally can. So go ahead, Mr. Klingler.
Thank you, Your Honor. Hello to you new folks. You were listening to my questions earlier, and I just want to ask all 1, 2, 3, 4 of you new ones. Is there anything that you remember that stuck out that you would have answered differently, or that that got your attention about some of my questions about, for example, freedom of speech and whether people should be free to tell lies on the internet about other people? That's kind of important.
Look at
for me to
Afroman's
know
face.
what you're-
Look, he peeks through right behind him. He looks like he's laughing.
and
Like,
whether
what?
people should be free to tell lies on the internet about other people. That's kind of important for me to know what your feelings are about that, one way or the other. Mr. Number, are you 14? You're 15. You're shaking your head a little bit. What do you think?
I don't think it's right, but everybody knows as far as telling.
On the internet? Yeah. What do you think about that? Telling things about other people on the internet?
I don't know, some people just talk about things they don't even know what they're talking about.
Yeah. Do you think it's possible for somebody to be really injured and hurt by lies?
Sure.
What do you think about that? Number 14? 14? What do you think about that?
Well, there's cool things going to be said on the internet that you should check into what's being said, try to find the truth.
Yeah. You might have answered this. Have you seen any of the stuff on the internet about this case or anything? How about the rest of you 4 new ones? Mr. 15. What have you seen?
I've just things on Facebook, all the news, and everything about it.
Do you think you have an idea from what we've heard today, from what you heard today, about what the case is really about? I mean, I know you said the legal stuff, and the legal stuff is hard for everybody, even the judges and the lawyers, but as far as what the case generally is about, do you think you got an idea? Do you think you would be a good juror on this case?
I'm partial to one side, but...
Pardon?
I'm partial to one side, but...
Which side are you partial to?
I know some of the sheriff's systems.
Do you know him personally?
Sir?
All right. You think that might affect your decision, or could you set that aside and decide on the facts?
I can set aside evidence.
Yeah. Appreciate that. And I hate these numbers. Number 16. Is that you? You're 16, you remember?
What is it? Yep, yes.
You're number 16. Have you heard anything today that makes you think you might be a good juror, or maybe might not be a good juror on this case? Gotcha. And number 17.
That's me.
How about you? You heard
Yeah,
anything?
I think I could. I don't know if anybody here. I think I could.
I see here on your form you wrote down, hope you don't mind me sharing this, you wrote down that you're judgmental and suspicious.
I've got kids and grandkids.
You've learned the hard way.
Yeah. I worked in probation for 4.5 years. So you get that suspicious stuff.
Yeah.
And good.
Yeah. Let me ask you about suspicious about, are you suspicious about law enforcement?
No, just in people in general.
Yeah.
Sometimes. And you got to take face value and see what comes from all it through good reading.
Yeah. Yeah. Good. Appreciate that. I told you I'd ask you this and I forgot, but other than what we've talked about, is there anybody right now who thinks they just do not want to be on this jury? You, sir? Anybody else? And while I've got you here on the spot, can you say a little more about why?
Well, I just don't like to be in control of somebody's life. I don't want to make decisions like that. You know what I'm saying?
You'd be uncomfortable making a judgment about anybody?
Yeah.
Yeah. All right, I appreciate that. Thank you very much. Thank you all.
Sounds 4 o'clock.
Yeah.
We'll get on here later. Go ahead, Mr. Osborne.
Thank you. Yeah, forgive me, I drink an obscene amount of coffee, and so I'm trying to down it before I came over here. I'm gonna pick on you first, because you're in the hot seat. Do you know the officers personally? All 7 of them?
All 7.
Which ones do you know? How do you know?
We've done business together, cattle in the past.
And you have an opinion of him? He's your friend? So, if I presented evidence that painted him in a bad light, would that affect your friendship with him?
What was the answer?
It could, Your Honor.
It could. Realize the mics need a lot of volume to pick up. Thank you.
Actually, that is a good point now that I think about it. I actually am naturally soft-spoken. I don't actually like to speak loud because it feels like I'm yelling in my head. If at any time you can't hear what I'm saying, just raise your hand and tell me to speak up. Okay. Sir, you were a probation officer at one time.
Yeah, assistant chief, Highland County.
Highland, oh God, you work with Rocky Costa then.
Yeah.
I'm not gonna say. So, what were your job duties there?
Just managing the staff, making sure everything was done.
So you didn't really interact with the probation?
Oh, yeah. You do.
They say some pretty nasty things about you, didn't they?
Oh, yeah.
Did that bother you?
Well, at first it did, because I was a retired Navy. And I started working there. It kind of, like the judge said, you know, when you tell somebody to do something, you need to do it. And that was kind of rough at first.
Especially when you're on probation, right? Did you ever think that those people didn't have a right to call you names like that?
For sure.
But you would agree to have a First Amendment right?
Yeah.
And you fought for that right for our country.
I'm sorry.
And you fought for that right with our country. When did you serve in the Navy, if you don't mind me asking?
1976 to 2000.
So if you remember right at the end of Tricky Dick and
Me and Jimmy Carter went in together.
get to that. I got a whole series of jokes on Jimmy. Number 14. I'm trying to keep it straight, man. So, sir, I know I've talked earlier about freedom of speech and everything. Do you believe that freedom of speech has a higher standard for a public official than it does for, let's say, a normal person?
No,
Why not?
I don't think so. Everybody's got a right to speak, but you should watch what you say about people.
So let me ask you a question. If the law said there is a higher standard, can you set aside your personal belief that there shouldn't be a higher standard and apply that law as it's directed to you?
Yes, sir.
Even if you don't agree? Number 16, you said you don't like passing judgment on a person. You also said this will be a financial hardship.
Correct.
With that financial hardship, is that going to be weighing on your mind as this case is going?
Yeah.
Would it be safe to say that, as you said, you have to work to make your rent, that as this goes longer, it's going to weigh even more?
Yeah,
Will that affect your ability to pay attention at trials?
yeah, because I'll be worried about paying bills.
So your mind's going to be elsewhere. And what kind of cows do you have?
Just cross-bred.
Crossbred Angus? Angus, Swartzstein Councilman, where they go through every fence I ever made.
Yeah.
And your son's taking care of all that? How did you do with the soybeans this year? I'm sorry. How did you do with soybeans? I got...
Not very good. Crops were bad last year.
I don't know what you mean on that. Hopefully this year's better.
Yeah.
Challenges for cause. Okay, so we're going to huddle up again. We're making good progress. The funnel's going from wide to narrow. To help you understand we're making progress.
I'm lowering the volume because they be beeping. And since we can't really hear this part anyway, we'll just jump forward. The excuse two more.
16 and 14 are excused. Thank you for being here. You don't have to leave. You can watch, or you can run out the door as fast as you can run. And I need number 18 in that corner, please. And number 19 in that corner. Okay, so thank you, number 18. How are we doing so far? Thumbs up.
Yes, we're doing good.
What are you dying to tell me? I want you to know that I asked the question. No, the concept makes sense to me. Anything confusing. You understand, like, the legal discussion we have on the way. We're at 10,000 feet on legal concepts. It'll get a lot clearer as it goes along, but at least in the high view, you're following what we're doing, right? Tell me about, like, social media, how you interact with it, how you use it, what you expect out of it. Can you start with that?
Well, I've seen like the posts about this, and I never really read into them or anything. Just kind of kept on going, minding my business.
Okay. Have you read anything like in the last 48 hours to really read it?
I've read nothing.
Okay. Thanks. Number 19, how are you?
I'm fine.
Yeah. I didn't really pay attention, but were you awake the whole time?
Yes, I was.
That's a struggle?
Nope.
It is for me.
Sorry.
No, but sometimes it drags on. We try to take a break every 90 minutes, like we'll structure the breaks better when I get everybody else out of here.
Good.
Okay. But like stamina-wise, you've been attentive and strong. Right, same thing with you, also number 18. Stamina, physical. Yes, no?
A little bit.
A little bit what?
I was all a little in and out of wanting to fall asleep.
It takes work. You have to invest energy to not go comatose mode,
Yeah,
right? Are you able to do that 18?
we'll find out, I suppose.
Okay. You able to do that 19?
I'm going to be fine.
Okay. Do you have a sense of who's ahead?
No, I don't.
Do you have a sense of what the arguments are?
Yes, I do.
Okay. Which is what I would hope you'd say. Because who's ahead is deliberation. That comes much later. You heard me say this before, right?
Correct.
Yes. The temptation, because we all do it, is to have incremental decision making. We gather information, we process it, we get to a small decision. Then we gather more information, we process it, we combine it to the first, and we make another small decision. And then we build our decision making over time.
Correct.
Like when you buy a house, you look at a house, you go yes or no. When you look at another house, you go yes or no compared to the first one. And you look at a third house, you do yes or no compared to the first two. And then you make a group decision along incremental decision. Get the concept?
Yes.
That's good. Until you make a decision by yourself in a jury in the absence of everybody else. Like buying a house without consulting everybody that's going to live in it. Get the idea?
Yes.
Okay, so you're doing fine. Do you know anybody, number 19, involved here?
No, I don't.
Okay, tell me about like social media or what you do with it or how it affects you.
I'm on Facebook, and that's about it. Where I live, I can't stream or do any of the Netflix or anything. I'm on Facebook with my friends. I was an advocate at the Chillicothe VA, and so I have friends in other counties. I moved back recently, and no, I don't know anyone or even what it was all about.
Okay. You're up, Mr. Klingler. And then they're going to just direct questions to you. Yeah, go ahead.
Well, let me start with number 18. Social media, what impressions do you have about this case?
I mean, like I told them, I've seen the posts about it, but I've never really clicked in to read into them, or so I've really just seen the headlines. Nothing else other than that.
And you ever shared them or forwarded any posts about this?
No.
Looks like you've got a little girl or boy, huh?
Little girl.
Okay. And is it, childcare going to be okay for you if you sit for 5 days here, or is that an issue?
Well, I can't really pay the babysitter. I'm not working.
Yeah, so that is an issue.
Yeah.
Number 19. Do you think you would or would not be a good juror for this case?
I hope that I would be a good juror in this case.
What would make you a good juror?
To listen to all that's presented and to come to a conclusion, discussion in the jury room. If I had a different opinion, listening to other people's opinions to see, and depending on my opinion, how strong it was, I would stick to it or change.
So have you been a juror before?
Yes, I have.
Good.
But I was an advocate for veterans, so I had to listen to both sides and try to do what was best and try to come to an idea of what I needed to do to assist.
I see. So it wasn't a trial like this?
No, and it was back in '83.
Okay. All right. Thank you, I appreciate it.
It's a good memory.
What about you, 18 for just a second? Do you think you'd be a good juror or not in this case?
I'm honestly not sure.
What question do you have that makes you not sure?
Just being able to, let's say, form a proper opinion. Just because, I mean, I grew up seeing Lisa around school. I went to school with her daughter, listened to all his music. Just kind of flavor on both sides.
Thank you, I appreciate that. all I have.
Thank you. Go ahead, Mr. Osborne, ask your comment.
Thank you, Your Honor. We got two hot seats, so I'm going to start with you since you in it. You said favor on both sides. What exactly do you mean by that?
Maybe just, well, with law enforcement too, I have a cousin who's a state trooper. So more than just police officers.
Right, there is no wrong answer. It's,
No, I'm just trying to find out how to word it. Just I do favor law enforcement, but I do also favor right and wrong. I mean, it's right and wrong. And I'm not sure. We're trying to figure out how to word this.
That's okay. That's actually the whole purpose of board here, so we get this, so you're doing fine.
Yeah. I mean, it really, my opinion would be formed in here because as I said, I've never read anything online. I've seen headlines. Didn't really take the time to go through it and look at anything.
So would it be fair to say then that you're saying because you have a family member who's a state highway patrol and a law enforcement officer that you're not going to give preferential treatment to these gentlemen? And ladies, sorry. You would give preferential treatment to them? Would you give preferential treatment during the trial to the officer?
It would really just depend.
What do you mean? You say you lean towards law enforcement, but you say it's the evidence. I'm trying to figure out how the evidence plays in between them.
I feel like I would be fair, depending on what I hear. Like, yes, I do have law enforcement in the family. I'm not saying I would favor it. Just if I hear what's fair.
Could you, as the judge instructs you on the law that applies to this case and applies to public officials such as the plaintiffs, can you apply that, whether it's fair or not?
Yes.
And so you can set aside any personal beliefs, any kind of animosity you might have, feeling that the law is wrong? And your relative who's a state trooper, he's held to high standards, state trooper, isn't he? Tie has to be right, hat has to be right. They really strict about the image, aren't they? Everything has to be done by a book.
Yes.
And if he doesn't follow it, in trouble. Number 19, you just moved back to the county?
I retired in 2020, moved to Florida for a while. My daughter moved back from Arizona, bought some land. I made a tiny house on her land, and that's where I live.
Before I say, if you had said you moved from Arizona, I was going to ask what's wrong with you.
Well, they moved from Arizona to here, and I don't know what's wrong.
It's a little colder here in Arizona. Although the strangest thing was when I was in Flagstaff and saw a cactus with
Move along, please.
Oh my God.
Would your work with the VA affect you in any way in making decisions today?
I would hope it taught me to listen to all sides and what everyone had to say with my veterans coming in with issues, with going to the staff, the doctors, nurses, whomever I had to talk to, listening to what happened there, and then trying to come to a decision on what was best. I would hope that would help me here, listening to both.
Ma'am, I have one more question. It wouldn't apply to you. Do you know anybody from my office or me or anyway? None of my family, Martha, Clayton? Just wanted to make sure of that because where you moved just back, I wouldn't have.
I've forgotten everything. I graduated from West Union, but for some reason I sort of put everything out of my mind when I left.
Thank you.
Thank you, Mr. Osborne. Challenges for Todd? Yes or no?
No, Your Honor.
One more huddle with the lawyers. Come on over.
And then I think they get into openings. All right, let me lower this volume because they have been not a good time.
Everybody should stand up, but not 15 and not 18, because the other 10 are the panel. So if you stand up, I'm going to give you the oath, and then we're going to take a lunch break. So don't stand up, 15, don't stand up, 18. Everybody else stands up. This is the oath that you take now as the jury in this case. Mr. Heller, go ahead.
You do solemnly swear that you will well and truly try the issues wherein Sean Cooley et al. Plaintiff versus Joseph Edgar Foreman, defendant, a true verdict rendered according to law and evidence. So help you God.
Everybody else gets to sit down. 18's going to leave, 15's going to leave. All you folks in the back today, thank you for being here, because I can't make this work without you being ready to go. You never know how many it's going to take. They all go to the clerk's office to get a voucher. Is that how it works? Okay, so if you didn't do it today, you can come back and do it later. But all you folks can leave while I spend 5 minutes talking to them. So get out of here. Or you can stick around and hang out.
Oh my God.
So lunch break is coming like in a few seconds. I need to give you an explanation of your responsibilities as jurors. This is going to primarily have to do with communications. But the first thing is to say, I often try to tell you ahead of schedule what to expect, only so you can not live on the end of a yo-yo string. In some respects, serving as a juror means you now sit and listen and I run your life. But that's not really fair, so I'm going to tell you that we're going to work long days. We're going to try to get as much done, because you can never get more time without starting early and working longer. So I need you to tell me if it's not working, if fatigue is a problem, or if something's going on in your life, right? But how you communicate is really important. You're not allowed to go talking to people about the case without there being a structure. So your people to talk to you about the case is the bailiff, Chris. So Mr. Pike's the first person you talk to, and then he's got to document what the problem is so everybody knows about it. That's not quite the same as saying, hey Chris, haven't seen you for 10 years, how's your family member? Like a social thing like that is not what I'm talking about, but as soon as you start talking to them, somebody's going to think it's about the case. So if you can hold off on personal conversations with all the court staff, do that. But I'm not going to lock you in a social box. They have a duty to make sure that if you're talking to people, we know about it, because everybody, both sides of this case, need to understand they're getting a fair, impartial, disinterested jury. I got my pending case right now where a juror was talking to a court staff member during the lunch hour, and now the guy in prison thinks they were fixing the jury. And it's a mess. I don't think it's a problem, but it takes a lot of work to solve things that are not a problem. So if you can not make it a problem, okay. So number 7 wants to say something, Chris. It's a social thing, right? It's a work thing?
It's this thing.
Then you talk to him about it, he'll make a record of it, and I'll deal with it.
Okay.
Thank you. Because that's the discussion we have to have.
Yes.
Is work
Yeah,
things,
that's what I knew it
work
was.
things affecting the defendant, work things affecting the plaintiffs have to be dealt with structured. Thank you.
I don't socially know anyone in this
Hang
room.
on. Great. Do not fall into the trap of incremental decision making, except in your own brain. Now, when you go back there and you're hanging out waiting for me to get together and start my process and you wonder why I'm late, it's probably because I'm working with the lawyers. But while you're back there waiting and wonder while I'm late, you start talking to the second juror about what do you think happened this morning. Now your incremental decision-making is starting to involve the second person, and then the third person starts listening in, and pretty soon half of you are in a conversation about the trial that the other half are not involved in, and now we're doing it wrong. So you always have to be on guard. It's okay to socialize, make a new best friend, talk about whatever you want that's not this case, but conversations flip so fast, you've got to always be on guard. Thank you, 19, for helping us go through that again, because I'll repeat it like repeatedly. Don't fall into the trap. No independent research. Like if you want to go by somebody's house, no. You hear an address, no, you don't go check it out. Yeah, all the evidence has to come from this chair and the exhibits. You're not allowed to go to social media to check. No search queries, no. Zero, no. Because you're getting something that the other jurors aren't getting, that the lawyers don't know about, that's not evidence, and then that's a problem. Every juror has to self-report their error. Oh, and every juror has to report the other juror's error. I can't police it, but you have to. Just don't start it. When you go home and somebody says, hey, what are you doing at the courthouse? If you say anything about this case, then you might get an earful that you didn't want because they just shot their mouth off. Might be better just to leave them in the dark, or say, I can't even, don't go there, judge scolded me, lay it off on me, but that's how it works.
Tell your friend that wants you to violate your oath as a juror and start talking about the case that if I violate this, I'm going to make you go sit and have this judge talk to you for 4 hours. And then they'll be like, oh, I don't want that.
I'm a small county. You say something to a squad member, they tell you exactly what happened because they were there. You didn't even know it. You just have to always be on guard about no outside information coming in. The attorneys are well-mannered. They know what they're doing. Not exactly that they can't say, I'm sorry. But if they see you downstairs and they're walking up the steps at the same time you are, they're going to stop so you can walk up the stairs by yourself. That's not rude. That's keeping distance so one side doesn't think the other side's getting an advantage. Like, I'll try to be somewhat distant. But in one respect, you're my client. And that means I want you to understand how to do things. So if you don't understand, then you would try to explain to Chris that we need clarification or whatever. My goal is to help you be fully educated so you, when you come to deliberate the case, you'll have all the tools. And I'm going to have to re-educate you because some of the stuff you heard from the lawyers isn't really the law. It's okay, nobody did anything wrong. It's just how it works. So let's take a lunch break.
Well, they're going to be...
I don't know, like I don't eat much. 45 minutes is enough time to get where you got to go back. Yes, no.
Last time we did this, it was an hour.
That 45
Yeah,
minutes.
McDonald's and all them get slow.
Okay,
slow
now,
around here.
be back here quarter after.
They want more
45
time?
minutes. Just take it. Get out of here. Go have a good lunch. Thank you.
Alright, I'm going to turn this down in case the next jump. And when we watched day one, remember the feed started in the middle of the plaintiff's attorney's opening statements. So we'll be able to watch whatever we missed from that. If you guys just want to run through opening statements again, we can do that. There was also a small part, I don't know how much it would have been, but during cross-examination of Brian Newland, right when he got asked about, you've been accused of stealing in other traffic stops before, right? He answered, he said, yeah, and then the feed, it froze, and then it went to, the error screen for, 6 or 7 minutes, it looks like, and then the feed ended. And then when we started, it was in the middle of redirect. So we could rewatch that, too. We could rewatch his whole testimony. You guys let me know. Let's see what they do when they come back from this lunch. Oh, wait, maybe he has some stuff for the record. Oh my god.
Whatever it is, I just want to get things on the record. We left off the record. side, are we on?
Yes, we are.
The sidebar mic wasn't picking up what we did. So plaintiff's challenges for cause were 5, 13, and passed. Defendant's challenges, peremptory challenges were 5, 13, and passed. Defendant's peremptories were 6, 11, and 14. To get the last two jurors, 15 and 18 were excused by agreement. The court granted challenge for cause as to 16, denied a challenge for cause for 15, who was not seated anyway. So there was an agreement to have 19 and 17 as the last two jurors. We don't know who the panel is, we just know that priority order. I don't use the A word because we don't really know that that's where they're going to be at the end. The lawyers did a good job of being expedient. We'll go with like preliminary instructions opening 15-ish minutes or so, like it's all flexible. Hein's theory is you don't know where you're going, you'll never get there, so I'll cut you off soon. If you're making good progress, making the points, then I won't. It's always sort of in flux. But be ready to go with witnesses all the time. We'll decide later today what time we start tomorrow. Anything for the record, Mr. Osborne?
No, thanks, Your Honor.
Klingler?
No, Your Honor.
Anything, Mr. President? Oh, no. Okay, off the record, thank you. Have a good lunch.
Oh my God. I'm sorry. I'm sorry, I wasn't ready for that. Oh my goodness. It's every time they switch.
We're taking a break. Sometimes
Sorry.
my work with the lawyers doesn't go as fast as I hope. So I'll try to respect your time consistently. But when I get behind the topic, because the lawyering with the judge to get the case to move forward just takes time. If you get it 45 minutes for lunch, they get 25 minutes. I had my coffee and breakfast bar, so I'm good to go. That's how we do it on the fly, so don't misunderstand.
Look at your mama's toys profile picture.
And that we're not trying to work hard to get this to you. Looking ahead, we're going to have some preliminary instructions. We're going to have opening statements from the attorneys. Plaintiff's going to start calling witnesses. And then we're going to finish. But I don't know what time that means. The building closes at 4, except it doesn't. Right?
We're here as late as you want to, Judge.
If we could work 15 minutes longer and finish a witness, I would. And you could thank me on Thursday. Or not at all. But that would often be my goal. We won't start something at 5 minutes before, but if we can start something at 3:15 that goes to 4:15, we will. Just because it's the only way to make it come together at the end. Thanks for that. Sitting as jurors is often like learning a new sport.
Oh boy.
You can sit in the
Here we go,
stands, have
Chad.
no idea what the rules are, and try to figure it out while the game's in action, or somebody can explain it to you. Like I learned hockey by watching television, having nobody around. It took a whole long time to figure out how it works. I don't want that to be your experience. So I'm going to give you some explanation of the rules. You know, I talked to 10,000 feet. I'm going to try to bring it down to like 5,000 feet to help you understand better what's going on. The final instructions are going to be given to you verbally. You have written copies to look at. There's a lot here. So I'm going to like to start taking out excerpts to help you understand. Because as spectators in the courtroom, you need to understand why witnesses are testifying, what the purpose is, where the fight is, what the points are, to be more effective. So it isn't meant to confuse you, it's meant to help you learn more along the way. I talked about burden of proof. Burden of proof is the preponderance of the evidence, slightly more evidence in favor. Just as a reminder, 7 plaintiffs in one set of facts still need 7 verdicts. It might mean that one plaintiff did prove or did not prove their case the same as the others. Along the way, you're going to have to take notes like you are. And figure out was their testimony for each of the 7 people on all those necessary elements. Thus, you need the notes. When you use your notes, you're not going to be able to take them home with you, so don't put your to-do list or your grocery list on there.
They ask Afroman to autograph their notes.
You take the notes while you're here. Try not to do too many notes. If you try to write everything down, you'll never get any of it because you'll always be behind. So you write down keywords, you write down phrases, you write down things that will jog your memory that you can use when you deliberate. Don't take the notes back to the jury room until the end of the trial. So when we take a break or overnight, just leave your notes in your seat, pick them up tomorrow. Don't tear pages out, don't take things with you along the way. They're meant to be an aid, not a distraction. Your notes might be wrong, especially compared to other people's memories. If I gave you a series of 10 numbers in a row, 8 of you would get it right. The other 2 would wonder how they got it wrong because they wouldn't think they got it wrong. That's all about how comprehension works. So if you take notes, just remember you might have taken it, like I forgot to put the word not in that sentence. Now the meaning changes. So use them to your advantage, not to your distraction. Evidence, what comes in the courtroom, is how you make your decision. But the same caution applies every time you leave. Don't investigate, don't talk. Make everything that you decide this case on come from this room. Sometimes you hear things you shouldn't have heard. I say, ignore that. You have to. If somebody starts talking about a fact in deliberations at the end of the case, you shut it down right now. Evidence is not what the judge says. It's not what the lawyers say. It's not what the witness doesn't answer. If the lawyer asks a question of the witness, and the witness shakes their head, and there's no answer, that's not an evidence. Non-verbal has to be verbal, especially when there's an objection, and the nodding of the head this way means I understand the question. In fact, the answer would have been no, but I wasn't allowed to say no because it was objectionable. So you have to be careful when a question's asked, there's no answer, to not use your eyes as the answer. It won't happen too often, and it'll happen all the time, because you really are learning with your eyes and your ears. Weighing credibility. We talked about this. Just a quick reminder is it's nothing strange. It's what we always do. We look at the witness. We think about the reasonableness of their testimony. We think about whether they're in a place to have seen or heard whatever it is they're talking about. We think about any interest or bias that the witness might have that would change their impression. Think about the passage of time and whether the passage of time changes their recollection. Bias and interest, intelligence are all legitimate parts of who we are, but you have to consider what their interest in the outcome affect how they present the facts to me. And there's no equation on this. 5 of you can say somebody's credible, 5 can say they're not credible, and then you just argue it out. It could be, well, I think they're really, really not credible, and somebody goes, well, they're only a little not credible. That's part of what we do. So just recognize it's okay when that happens. In your deliberations, you decide what weight, what believability to give to a witness. You can believe everything they say, you can believe nothing a witness says, you can pick and choose. That's up to you. The oath that they take, as I said before, applies to them being truthful. It does not constrain you to believe something you don't want to believe. As a general rule, people shouldn't explain what something means. That's called an opinion. As a general rule, people should say what they saw, heard, experienced, not what it means to them. And then we break that rule all the time because people are allowed to have opinions about what it meant. So recognize reciting facts and things that you experience is a fact. And then when they say, and this is how I felt about the fact, I'm going to let that in. But it really is something that becomes more subjective, not wrong, it then becomes not an observation of fact, it becomes my impression of what they mean. If a person gives an opinion, that doesn't mean you have to follow it. It just means their logic. But you see how evidence changes from recitation of facts to conclusions about what they mean. Just be on guard that goes on. All of it's fair game. You just need to know how to sort it out, because my impressions, my opinions, are just mine. There's two claims, you've heard me say this before, I'm going to try to give you a little bit more of an understanding. And you'll get this in writing. Defamation is a false statement that causes injury. It would be a short way to understand it. The false statement can be a writing, a verbal statement, it could be a document, so it isn't like statement meaning verbal. Something written is considered a statement. Something published as a picture would qualify as a statement. So it's not constraining. Libel and slander. Slander is a spoken word, libel is a written word. They're still defamation. So don't get lost. I think that slander of words is different than pictures or statements, whatever. Plaintiff has to prove by greater weight of the evidence, preponderance, that there was a published or distributed statement that was false, and when making the statement, there was an actual malice, motive. So the purpose or motive is malice. False is sort of relative, or truth is sort of relative, because a minor inconsistency or a minor falsity, if it's 99% true, 1% false, you might go, that's essentially true. Because the little thing, the 1%, wasn't really enough to make it false. I think we all like absolutes, when in fact there's not always absolutes. But truth is a defense to defamation. So what's truth? Philosophical question for the ages. The same kind of equation applies when you're deciding truth or falsity. Minor differences doesn't necessarily make it untrue or unfalse. You then get into what is it in your mind, and you might have different opinions about how much has to be accurate, but there's no equation with regard to truth and false. You're going to have to sort that out along the way on yourselves. It has to be substantially true to be true. Substantially, not absolutely. Actual malice, like the motive for the publication, actual malice. Knowing it's false is actual malice, or a reckless disregard about whether it's true. So to make a false statement with malice, actual malice, means you know it's not true. Or you're disregarding, callous disregard, recklessly disregarding whether it's true or not. So you do get into this higher standard for public officials. There was discussion in the jury selection, should there be a higher standard for public officials? That's where the higher standard is. To say the distribution has to be with actual malice. If you're not a public official, it's a lower standard. So like the lawyers were talking, legitimately asking you questions about that. This is where it factors in. So knowing it's false when you make it is a higher standard for the public official. Or recklessly disregarding whether it's true or not is the higher standard. If you're an average person, not a public official, it's a lower standard in the distribution. There was some discussion about freedom of speech. Freedom of speech gets involved in the publication of a statement. Freedom of speech is whether you're allowed to publish or not. Don't misunderstand freedom of speech. Freedom of speech doesn't go to the falsity or the truthfulness. Was there a statement that was published? Was the published statement false? Second element. And was the publication with actual malice? Third. Freedom of speech goes to the first element, publication. If you have the opportunity to publish, then that's the freedom of speech. The freedom to publish something falsely is not the law. That's where we get into the second and third steps. The 7 plaintiffs have been declared to be public officials. In the pretrial process, the question was, are they just average people, like average people, or do they have a public official status? In the facts of this case, they were acting in a public official status. So we raised the bar on the amount of proof they have to have. That happened as a matter of law, but tell you they're public officials. It's not even an issue, the lawyers know it. So that's where that comes in. If the plaintiffs, individually or collectively, some number of them, prove defamation, false statement with malice published, then it's presumed that their reputation was injured. So at that point in time, it's presumed that they were damaged. And then I'll explain like economic, non-economic damages. The explanation you heard earlier was in fact pretty accurate. Economic damages is something you have to pay for as a part of the injury. Like you get stitches, you have to pay a doctor to buy bandages. That has a price tag to getting the doctor. So it's presumed that they suffered non-economic damages, which you might think of as embarrassment or loss of reputation, but there's a presumption that injury occurred. With regard to damages, there's no slide rule. Then you apply your own concepts of what you think reputation's worth, or what you think embarrassment is worth, what you think changed position in social settings is worth, what it's worth if friends look at you differently. But if you're an engineer, this just drives you crazy because we don't have formulas, we have juries. And every jury is composed of individual people and they get to make their collective decision. So in that regard, the presumption exists, you decide how to value it. But remember, all 3 of those elements of defamation have to be proven before you even get to damages. The second claim, this false light, is really better understood as like invading somebody's privacy. It's a first cousin, like 10,000 feet, I want you to think the related claims they are. But false light is putting a person or a plaintiff in this case in the position of being offended because of what was published. The offense has to be highly offensive to a reasonable person. So did the defendant's publication highly offend a reasonable person? Now we're getting into words that don't have formulas either, because you're the reasonable person. It's not enough for the plaintiff to say, I was offended. That would be subjective. Your role is to be a step removed to say, objectively, we would find that that statement is in fact highly offensive to the average person. So when you hear testimony that the person says they're offended, that's their opinion. Whether that opinion lands with you from an objective perspective is how this all works out. So with their testimony, how are you going to refute that I'm offended? Well, you decide if what was false and distributed about them, put them in false light with their friends, was in fact offensive to the objectively reasonable other person. False light means the defendant knows the plaintiff would be justified in feeling that they were seriously offended or aggrieved. So what the defendant knows at that particular point in time. There has to be a major misrepresentation. That's the idea of it can't just be a little I'm offended because something minor happened. It has to be something significant or something measurable that involves their person's character or a history or their activities or something like that, where you would find that there was an injury as a result of that. There really isn't any dispute when we talk about publication, distribution. Like there was no First Amendment violation here because all the material did go out. We often talk about First Amendment violations when the government or a private person prohibits somebody from distributing. Some of you have seen or heard, had observations about what's distributed. So like publishing isn't really the issue in this case. It's the falsity, the motive or malice that might come from that. And then was that in the second claim objectively offensive to an average person or not? That's good enough for 5,000 feet. Hopefully you're getting the ideas, like more and more I'll give you little details along the way. But you wouldn't have a chance of knowing why we're putting witnesses on and what they're talking about if you didn't know what the rules are. So that's enough. Mr. Klingler's going to go first with his opening. He wants more time than I'm going to give him, but it's like 15, 20 minutes of overview, flyby. Here's where we're going with this. It's not testimony. Like I would recommend you not take notes, so to misunderstand that what he says is not part of the evidence. He's just giving you a table of contents. This witness to show, I'm going to call this witness. He's giving you the outline of his case. Okay, start thinking.
Oh no. Mute it in case it beeps. It looks like a buffer on my end. All right.
So you don't forget. Oh, in your notes, if you happen to write down something a lawyer said, but there was no answer, what the lawyer said is in evidence. So then you have to cross that out. Thank you, Mr. Klingler. Go ahead.
Thank you, Your Honor.
All right, so I don't know what you guys want to do. We missed the beginning part of this opening statement, and I also don't see that the Watchdog Wire has uploaded day 2 of the court footage yet. So I can't just say like, oh, let's jump and watch the beginning part of day 2 that we didn't get to see because the feed started late. So we could either just run all the way straight through and keep waiting until there's a verdict. If you guys want to do that, I think that might be a good idea. Because there is a little part that we missed from the middle of Newland's testimony as well. So there's about 2 hours and 20 minutes of this feed left. And I don't think the judge has a problem if the jurors want to stay late, but if any of the jurors have to leave at a normal time, I'm sure we'll get word that they're done deliberating for the day at that time if they do. Or we'll be able to see if there is a verdict and WCPO goes live to broadcast it, we could obviously switch over there. So I'm fine with running through this whole footage if you guys want to hang out and see if a verdict comes in the next 2.5 hours-ish. They've been out since 11:40 a.m. this morning Eastern. It is about to be 3:40 here. They did do lunch, but I mean, I would imagine that they've been deliberating at least for 3 of these hours, even if they took a long lunch. So who knows, you guys? I don't know anything else, but let's just keep rewatching and we'll take it as we go.
Good afternoon, folks. Hope you had a good lunch break. So this case is about intentional lies that hurt people. It's not about freedom of speech. Lies that hurt people, as Judge Hein said, that's what defamation is. That's the definition of defamation. And when a person publishes things that are untrue about somebody on the internet, and it injures those people, then that person who published that is responsible for the damages that resulted. Now let me tell you the story of this case. Mr. Joseph Foreman, stage name Afroman, is a rapper, hip-hop artist, songwriter. He's quite famous among some folks. He has a big fan base. He makes money producing music and selling merchandise. He travels around doing live shows. He lives here in Hamilton County. His former wife lives here and his children live here. But he often travels, he's often gone on his road performances. Now back in 2022, 2023, Mr. Foreman began posting music videos about several Adams County deputy sheriffs. At first, he called them thieves. He said they stole $400 from him. Lots of videos, lots of songs. I think some of you probably heard them. He posted songs that alleged theft by these deputies on the internet that was seen at least 12 million times. Then he posted other things about these deputy sheriffs. He posted that Detective Brian Newland is a pedophile. He posted that Brian Newland likes to fondle little boys. He took special interest in targeting the one female deputy sheriff in the department, Lieutenant Lisa Phillips. He posted that Lisa Phillips likes to have sex with women. And in fact, Lisa Phillips isn't really a woman at all. She's got a penis instead of a vagina. That's what he posted about her. That's not all. She's had sex with my former wife. And a word I don't like to use, but you're going to have to hear it because it's all over the place. She eats pussy all the time. That's what she likes to do. Videos, posts, all over the place. Her daughter came home from school in tears because of what the kids were saying. All of these posts were untrue. All of these posts, Mr. Foreman knew they were untrue. And that's the actual malice that you heard about. He doesn't have to hate people. He doesn't have to anything else. If he knows they weren't true, that's actual malice. For public officials, he can't do that, and he did. Now, these deputies asked the defendant years ago to stop these posts, to take them down. He didn't. He ramped them up. Freedom of speech. I can say what I want. Worse and worse. You'll see what they are before the trial's over. Now, I'm going to ask you to come back with me to the summer of 2022. Adams County, here in West Union, here in this courthouse, the sheriff's office downstairs. There's a group of deputy sheriffs, several of them. A lot of them were raised here in Adams County, lived almost all their lives here. A lot of them have had their whole law enforcement careers here in Adams County. Some of them left Adams County for a while but came back home here to be with the people that they know and know them. Some of them could have gone to the city of Cincinnati or Columbus or somewhere else and made more money, but they stayed here in Adams County to be law enforcement officers, deputy sheriffs. They have wives, spouses, husbands, children, go to Adams County schools. This is where their lives are. 7 of those deputy sheriffs are here today. And Randy Walters, there on the left, Mike Eastep beside him, Lisa Phillips beside him, Sean Grooms beside him, Justin Cooley beside him, Detective Brian Newland beside him, and Sean Cooley, Justin's father, beside him. What brought them together was some information that Brian Newland came across in the summer of 2022. Some information that caused him to have to do something. So he typed up a search warrant and he took it to a local judge. The local judge looked at it, approved it, signed the search warrant, And Detective Newland started gathering deputy sheriffs to help execute this search warrant, and it was a search of defendant Foreman's property out on Russellville Road here in Adams County. Detective Newland will tell you that any search like this is potentially dangerous, so you like to have as many people as you can. The deputies had guns, of course. A couple of them had rifles, which is normal protocol in a situation like this. And there were about 10 of them altogether who were gathered to execute this search warrant in August of 2022. And these 7 were some of those deputies. The evidence is going to show that they approached, the evidence will show, first of all, none of these deputies had any idea when they woke up that morning that they were going to be executing a search warrant. None of them had any idea that by doing their duties that day, their lives would be turned upside down. That evening, they approached the premises, spread out the way they had a plan. They knocked on the door, no answer. Tried the doors, doors were locked, doors were secured. They ended up gaining entry with a battering ram, had to knock the door down. Again, that's procedure that happens in executing warrants, and that's the way you need to get in. Nobody was home. Nobody was home. Mr. Foreman wasn't home. He was away in Chicago doing a show. The deputies searched the house. They found a small amount of marijuana. They found a significant amount of cash. They seized the marijuana. They seized the cash. That's what they do. And that was pretty much it. No evidence of a major crime was found. And so what happened was, after a while, the local sheriff ordered that, decided there's not going to be any charges filed here, and so he ordered the cash to be returned. It was over $4,000 total cash found in some of Mr. Foreman's clothing and another place in his house. Shortly after that, shortly after the cash was returned to Mr. Foreman, he began claiming on the internet and every place he could that the sheriff's deputies had stolen $400 from his money, hadn't returned it. You're going to hear the evidence about that, and we're going to demonstrate to you that that's not true and that he knew it wasn't true. There was an independent investigation done by Claremont County, but that didn't keep him from continuing to declare that Brian Newland in particular and the rest of these deputies are thieves. Okay, that's just the beginning of it. Then he went beyond calling these deputies thieves. As I've indicated to you, he called Brian Newland a pedophile. Not called him, he posted it, published it all over the internet in various posts. He found a photo of Detective Newland from a shot with a cop event that Mr. Newland attended with little kids, disadvantaged kids, kids in the community, shot with a cop to get them to know law enforcement. Mr. Foreman found a photo of Brian Newland holding one of these children that he worked with. And Mr. Foreman blocked out the face and put a smiley face on it and posted this picture of Brian Newland, and it says, "Brian Newland is a pedophile. Watch your kids around this man. He likes to fondle little boys' testicles." Posted it all over the internet, not once, not twice, many, many times, seen thousands of times by people. People in the community started making comments to Detective Newland. His daughter came home from school crying because some kids had called their dad a pedophile. He used to coach a cross-country team. Some of the kids on his cross-country team started calling him a thief and a pedophile. He'll testify, he'll tell you that his daughters used to have kids over all the time. They like to hang out at his house and do things. After all this started, that stopped happening. Like, kids didn't come over. Finally, Detective Newland felt like he couldn't continue to work in Adams County anymore. Adams County was his dream job. He started here as a deputy, worked his way up to detective. This is where he wanted to spend his career, but things soured out. He couldn't stand working here anymore. He resigned his job from the Adams County Sheriff's Department and went to Cincinnati and now works for the Norwood Police Department. He commutes, drives every day because he felt like he can't work here anymore. Now, Mr. Foreman, as I indicated a moment ago, saved his most severe attacks for Lisa Phillips. Lisa Phillips worked as a resource officer in the Adams County schools for 18 years. She used to greet the children, including Mr. Foreman's children, when they were dropped off at school in the morning. Said hello to them, made them feel welcome. Mr. Foreman posted that Lisa Phillips likes to have sex with other women. He used other words. She ate my ex-wife just like pizza. Pussy, 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 eating, blah, blah, blah. Over and over, thousands of times on the internet. People saw it, people laughed, people from out of state, but people here in Adams County would sometimes yell at her when they saw her. Hey, Lisa Lick'em-Low Phillips, that was his nickname for her. Over and over. This has been going on for like almost 3 years now, folks. And it's taken a heavy toll on her. Her child came home from school crying, saying, because the kids were saying, did your mom have a sex change? Because of what they saw that he had posted. We asked him to stop. He doubled down.
5 minutes.
Thank you, Judge.
You're welcome.
She's out on call doing her duties. Someone yells at her, hey, Lisa Lick'em-Low, calls her a thief. She's had to miss days of work because of the emotional upset. Her doctor has her own medication. Because of this, because of lies. Just Friday, on the eve of trial, he published the most egregious thing you can imagine. I don't know if any of you have seen it. I think you will in this trial. It's basically pornography about Lisa Phillips. Mr. Foreman also targeted Deputy Randy Walters for special treatment. In several videos seen by thousands of people, Mr. Foreman declares, I used to fuck his wife. I used to fuck his wife doggy style. His daughter came home upset because the kids at school were saying, hey, is Afroman your father? We asked him to stop. He didn't. He's still published. There's new videos today come out. In your face. I'm going to do what I want. Justin Cooley was targeted by Mr. Foreman as a thief. Sean Cooley.
And remember, for damages, so when we heard this attorney's closing argument, he was asking the jury to award $1.5 million to Lisa, $1 million to Brian, and $1 million to Randy with the ex-wife.
Mike Easton and Sean Grooms all
or the wife, that
suffer
ex-wife,
by being called a thief. They're sheriffs. They go to people's houses to do things. Hey, you're going to steal my money too? Their reputations and the damage. It's harder for them to do their jobs. You'll hear all the evidence. That's what this case is about in terms of the facts. At the end of the case, you'll have to decide if Mr. Foreman should be held responsible for what he's done. That's what the case is about. Should he be held responsible? I indicated during our jury selection process the kind of damages we're going to be asking for, the non-economic, the value damages. You'll hear all the evidence, you'll have to decide how bad was this. I think you're going to decide it wasn't just a little minor, said something bad about you. It was about as bad as you can imagine for these deputies. Reputation, pain and suffering, humiliation, personal embarrassment, loss of reputation, all that stuff, you're going to have to put a value on. And I will tell you this, as I said earlier, I'll try to help give some guidance. You can reject it or not, because it's your choice. But at the end of the day, I'm going to be asking you for a number for all these people that is in the 7 figures. That's how serious we take this. And there's also a punitive damages element that may go to you depending on what the judge decides. And that's going to be another decision you'll have to make based on how bad you think this is and what this conduct deserves that's been done to these people. At the end of the day, it's about what's legal, what's moral, what needs to be done to make up in some way for what's been done to these deputies that have spent their careers defending this community and living in this community. That's all I have. Thank you.
Thank you, Mr. Klingler. We'll turn now to Mr. Osborne.
Good morning, ladies and gentlemen. I'm going to reintroduce myself. My name is David Osborne, Jr. I represent Joseph Foreman. Let's go by the stage name Afroman. And I want to thank you for your service today. This is not going to be an easy case. This is going to take a week of dedication of you to go through. Not an easy thing to ask. But something we appreciate you are willing to do. This case is about the freedom of speech protections contained within the First Amendment of the United States and the Ohio Constitution. It is about an American citizen's right to make public comments about the actions of public officials, actions that took place in his own home, actions that took place within his home were part of his artistic, creative expressions. And Americans maintain a right to criticize, to mock public officials. And that includes law enforcement officers. On August 21st, 2022, Detective Brian Newland drafted a search warrant. That search warrant was based upon an interview conducted with a confidential informant. That confidential informant gave Mr. Newland information. He put it in a search warrant. Then he went and he saw Judge Roy Gabbard, and Roy signed it. From there, they went to execute that very same day. Officers from the Adams County Sheriff's Office, 7 of the 10, descended upon Mr. Foreman's residence with a hastily prepared search warrant. For a man who's famous for a song that said, "I got high," the amount of force used was excessive, to say the least. After all, based on the song, a bag of Doritos would have been enough to take him out. But they deemed it necessary to not only go to his residence with assault rifles, body armor, and even a riot shield to execute their search warrant. And all that led to a destructive search of Mr. Foreman's residence. Deputies searched Mr. Foreman's home, every one of his outbuildings, behind the couch, under the hood of a car. And you know what they found? A couple of little joints, which, let's face it, because I got high, that was expected. And then they found cash. His cash, not theirs. His. They seized all that. It was cataloged, returned to the office by Brian Newman.
Newland then does what's required by law. After you search, you have to return a thing to the court that says every single thing you seized. A return on your search warrant to tell the court what you took. In that, he puts a number for the amount of cash that was there. Now, Mr. Foreman, let me back up, because there's something I forgot during the search. For a search for marijuana, or whatever was in the search warrant, we'll introduce that later, they disconnected his security camera system. He has a security camera system in the house. He's had break-ins before. Most Americans, he has a security camera system. Yet in the middle of their search, they disconnect it. They say it's going to be because they want to take it for evidence. Do you know where that evidence ended up? On the couch over there. Just disconnect it and leave it there. Now, what precipitated next is the primary focus of the lawsuit. Mr. Foreman did what he's done through his entire career. He took his life experiences and turned them into music, social commentary, and artistic expression. After all, one only needs to look at the song, Because I Got High. The lyrics are there. I was going to clean my room because I got high. He was rapping about his life then, and his posts are talking about his life and his experiences. During the search of Mr. Foreman's home, deputies' actions during the search was captured in two places. One, the security system of Mr. Foreman. Joe's security system was active until they cut it. You also have body camera footage. Now, we don't have body camera footage for all 10. Not everybody was wearing body camera. But the officers that did, there is body cam footage. And he used this footage from both those locations to make his music videos. He posted them on social media, like Facebook, YouTube, Instagram, and even TikTok. The plaintiffs decided they did not like what Joe had to say about him, or how they portrayed him, or how he used the footage of their behavior as their job as law enforcement officers, as public officials. Their response was to sue him in order to silence his freedom of speech, threaten his livelihood. After all, have you ever heard of a law enforcement officer suing a person for making a social commentary on them? Or have you ever heard of an officer suing anybody because someone said they didn't like what they had to say? Officers deal with it all the time. I dealt with it during my election. You don't sue me. You respect the freedom of this country and move on. Because, let's face it, we don't have freedom of speech. 250 years ago, the founders of this great country wanted to limit the government's involvement and what government officials had power over to say. And that's why we have the freedom of speech we have today. Before we get to the evidence, I want you to understand this case started with a number of claims. Of them, 2 were dismissed by the court.
Do not go there. Do not go there. You know and I know that the jury doesn't need to know what's not there. I'm not hiding the ball. Claims filter out like they should. I gave the instructions, and you don't need to get distracted about what's not there.
Afterman's face.
Mr. Klingler talked about punitive damages. Maybe, but you don't need to know that because we're not there. I'll tell you that if you need to know later. There's a lot of things this case is not about. So he doesn't need to talk about what it's not about. It's only what it is about. Go ahead.
Forgive me. I have to readjust my evidence. It should be noted that public officials, such as these gentlemen and Ms. Phillips over here, are held to a higher standard than an ordinary person. They're public officials. They are expected to be criticized and monitored. The evidence will indicate that Mr. Foreman created songs with titles like "Will You Repair My Door?" "Lemon Pound Cake." These songs went viral, yes. People connected with the message and understood what Joe was trying to say. The videos and songs resonate with the public because they address something that people care deeply about as Americans, and that is how law enforcement officers conduct themselves. Joe also made statements on social media about the search and the officers involved. Some of these statements were openly critical and expressed Joe's opinions about what happened. Statements about missing money. And he used some strong language, some exaggerated language, we call it hyperbolic language, to present his message and his opinion. But all these statements were a matter of public concern as well as statements about his personal opinions. The experience of law enforcement officers executing a destructive search warrant is well beyond question, as it is a matter of public concern. The plaintiffs are going to point to specific statements that Joe made. They're going to claim these statements are defamatory. They're going to attempt to remove them from their context. Statements aren't in a vacuum. There's context. If you get called a name, if my wife yells at me, there's probably context to it. That context is what we're going to show you. Because if you look at those statements in isolation and simply ignore the conduct that sparked them, you can't understand really what's going on. You'll be asked to forget much of that context of the statements. At least not the, I should say the least of it is that the plaintiffs are public officials and the public has a right to criticize them. The evidence will show that Mr. Foreman's statements fall into three categories. The first, many of these statements are his opinions. Opinions are not assertions of fact. They are Joe's subjective views about his encounter with these public officials and the execution of their duties. The First Amendment protects the right to express those opinions, even if they're harsh, even if they're mean, even if the person who is the subject of them hates them. They are protected. Second, many of the statements are exaggerated, rhetorical exaggeration, as you might expect from a musician. After all, if you didn't have because you got high, if I said I just didn't want to clean my room, no one would have bought that song. You have to exaggerate something. You'll see he used colorful language, sarcasm, and satire. No reasonable person would have understood these statements to be literal assertions of fact. For example, Mr. Foreman created nicknames and made comparisons to cartoon characters. No reasonable person would understand those as a literal assertion of fact. That is a rhetorical satire flourish that has always been part of our social and political commentary in this country. After all, pick up the newspaper, you're going to see a political cartoon making fun of somebody. Watch Saturday Night Live. They make fun of people all the time. They even make fun of Joe. It just happens. It's part of our freedom of speech and also Mr. Foreman's artistic expression. The third is the extent that any of the statements assert facts. They relate to matters of public concern. Matters of public concern are exempted. These statements address how the search was conducted, what actions were taken, and how Mr. Foreman experienced this as a homeowner with these people executing their hasty search warrant. Indeed, the public's concern for such issues is reflected in the viral response that his content got. The plaintiffs bear the burden of proof in this matter, not Joe. They must carry the day. They must prove every element of their claim. Looking at the invasion of privacy due to false light is one of the claims that they're claiming. The plaintiffs must prove that Mr. Foreman portrayed them in a false light that would be highly offensive to a reasonable person. The evidence will show that he did not. He used real actual footage of them performing their duties, stuff in the public domain. Joe's statements were based entirely on his personal experience and within his county of residence, which that is something I do want to clear up. Mr. Foreman lives in Adams County, not Hamilton County. Mr. Klingler was wrong about that, so he is a resident of this county. Regarding the defamation claim, plaintiffs must prove that Mr. Foreman made false statements of fact, not his opinions. That's very important. Because we all have opinions as Americans. It's one of the great things about this country is we can share our opinions whether we like them or not. Whether they like them or not, they can hear my opinions. But they must prove those statements were not opinions. Because public officials, they must prove that Joe acted with actual malice rather than just simply exercising his First Amendment right. The evidence will show they cannot meet this burden. Plaintiffs claim that Joe portrayed them in a false light, but evidence will show Joe used direct footage from security cameras. We can see what they did. They executed the search warrant. It's all on camera. There's nothing false about showing that one. There's nothing false about Mr. Foreman having opinions about how they did and then. However, when they executed that search warrant, that became a matter of public scrutiny. People could watch it. People could see what was done and form their own opinions. And they can share those opinions. And he has a right to create artistic expression based on those opinions, based on their content. The plaintiffs, it goes without saying that they don't like what Mr. Foreman said about it. But they don't have to. That's part of our right in this country. They don't like his commentary. They don't like his art. But the First Amendment does not protect speech that we like. It protects all speech within it. It protects commentary, criticism, especially on occasions such as this. It protects speech that I would not like. Speech I've suffered. It protects it. You may not like the speech you hear, but it's protected. Throughout this trial, you'll hear testimony and see evidence that demonstrates several key points. You will see the actual videos and social media posts Mr. Foreman created. You'll be able to judge for yourselves whether they are false, whether they're his opinions, whether they're artistic expression that is all protected. It's about the right to comment on and criticize public officials without fear of retribution, without fear of getting sued. It's about the right to create artistic expressions that are matters of public concern. The plaintiffs are law enforcement officers. They perform a cardinal public function. But with that public role comes public accountability. It also comes a certain standard that you have to understand. And as public officials, they can be criticized. They may not like it, but it's life. Plaintiffs have the burden of proving their claims. The evidence will show they cannot meet that burden. The evidence will show that Joe's videos, posts, and commentary were artistic expression. They're matters of legitimate public concern, his opinions on the law enforcement officers and how they were performing their duties. If the plaintiffs prevail in this case, what message will that send to this country? It sends the message that if you criticize law enforcement, if you comment on how they conduct themselves, if you mock them, if you create art with them in it, they can sue you. That's not the America we live in. That's not why we have a Constitution in the First Amendment. That's not why the First Amendment is in the Constitution of the state of Ohio. Ladies and gentlemen, upon the examination of the evidence at the end of this trial, I'm confident you'll conclude that Joe did nothing wrong. While the plaintiffs are unhappy, upset with what was said, he exercised a right he had, a right that every American has. He commented on matters of public concern. He created art. He did what any stand-up citizen would do. He made his voice heard to the people. At the end of this trial, I'm going to ask you to return a verdict in favor of Mr. Foreman on every one of their claims. I'll ask that you vindicate his First Amendment rights. And I'll ask that you send a message to the American people that you can criticize public officials and that we are not living in a dictatorship where if you don't like what is said, you just sue someone to shut them up. Thank you.
Thank you, Mr. Osborne. I'm going to start calling witnesses, but I will tell you what this case is not. Okay, this case is not going to be an analysis of why the magistrate issued a search warrant, or what the facts were leading to the search warrant, or the backstory of the warrant. That's the subject for criminal cases. So the fact that there's a search warrant is what this case is about, not the backstory of it. So you keep talking about the criticism of the why and the whole deal. That's not relevant testimony. We're living with, there was a search warrant, nothing backstory. This case is not about excessive force in entering. The court's already determined as a matter of law that it was not excessive. You'll see testimony of damage, but that's a legal standard about whether it's more than customary or expected in the realm of a search warrant. Search warrants are lawful forced entry. So you won't get, was that too much force? That's outside the realm of testimony. And I call these third thing. This is not about vindication of the defendant or messaging to the public. That's things that happen from the political branches of government, the legislature, or the executive offices. Messaging is not what you're concerned with. It's the message that you're sending. You're not messaging. It's all about how these facts affect these people. So when these little distractions and diversions come at you, I'm going to try to continue to narrow and keep you focused not on the distractions but on the issues in the law. Otherwise you're going to ask later on, why did the judge give us instructions on messaging? Because that's not how this comes out. So I'll do this periodically along the way when things start going astray. Ready to go, Mr. Klingler?
Yes, Your Honor.
Tee it up.
The plaintiff calls Detective Brian Newland.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God. I do. Thank you. You can be seated.
Well, since you're a public official, we won't expect to have your private residence address. Go ahead.
Thank you, Your Honor. Would you introduce yourself to the jury, please?
My name is Brian Newland.
And Mr. Newland, where do you live? No street address, just generally?
I live in Adams County, Ohio.
And how long have you lived in Adams County?
From 1995 to 2010, and then from 2015 to current.
What were you doing between 2010 and 2015?
I was in the United States Army.
Honorable discharge?
Yes.
What do you do for a living?
I'm a police officer.
And when did you start in law enforcement?
I originally started in law enforcement in 2014.
And what position was that?
As a deputy sheriff.
Where?
The Adams County Sheriff's Office.
And then how long were you a deputy in the Adams County Sheriff's Department?
The Adams County Sheriff's Office was my first full-time job in law enforcement, and that was from 2014 until 2023.
All right. And why did you become a deputy sheriff?
After I got out of the military, I just wanted a job that I thought would be exciting, something different, so I chose law enforcement.
Do you have family here in Adams County?
Yes.
Can you tell us who?
All my family's here, my kids, my grandparents, my mom, my brothers, cousins, aunts, uncles.
Did your children go to school in Adams County, or do they?
Yes.
You were involved in the execution of a search warrant back in August of 2022.
Yes, I was.
And I want to take you back to the night of August 21st, 2022. Were you part of a team that searched Mr. Foreman's home?
Yes.
What was your role in obtaining that warrant?
I prepared the search warrant based off information I was provided, and then I met with the judge and the prosecutor at the time prior to serving the search warrant.
And was a warrant approved?
Yes.
Can you tell us where what the subject of the search was? The property of the search.
It was the residence of Mr. Foreman. I believe the address is 1699 Russellville Road.
Okay, that's here at Adams County, correct?
Yes.
Now, were the other plaintiffs here in the courtroom, were they also deputy sheriffs or part-time deputy sheriffs that participated in that search?
Yes, they were.
And was Mr. Foreman at home during the search?
No.
Were Mr. Foreman's children present during the warrant execution?
No.
Was anyone present other than you and your fellow officers?
At the time of arrival, no.
Was anything seized or taken from Mr. Foreman's home?
Yes, there was some money and a small amount of marijuana and some miscellaneous drug paraphernalia.
Why was the cash taken?
It's common with any type of drug seizure. We seize the money in cases proceeds from drug-related sales or drug trafficking activity.
Was that money potential evidence?
Correct.
What was your role in seizing this cash, Detective?
I'm sorry.
Well, maybe I got ahead of myself. Was cash located in the property?
Yes.
Do you remember how much approximately?
Approximately $4,000.
And did you play a role in taking that cash?
Yes.
What was your role?
I was provided the cash, or provided the money that was located by another deputy. I counted out the money, put it in an evidence bag, and then at the end of the search, I transported it back to the sheriff's office.
All right. Did you take any of the money?
No.
Did you ever take any money from the evidence bag?
No.
Did you ever take any of Mr. Foreman's money?
No.
Was your counting of the cash recorded on your body cam?
Yes.
And have you had a chance to review that?
I have.
Has Mr. Foreman accused you of taking his money?
Yes.
Are you aware that the cash was ultimately returned to Mr. Foreman?
Yes.
And can you tell us why that was?
The prosecutor at the time decided we're not going to pursue any current criminal charges, and the property was released back to him.
Okay. Were you present when Mr. Foreman picked up the cash that had been seized?
No.
Do you know whether any press was invited to attend the return of this cash?
I learned that there was later.
Okay, but you weren't there.
Correct.
Can you tell us what happened when the money was returned to Mr. Foreman?
Your Honor, I would object to that. He's already testified he wasn't there.
Okay, let me rephrase it. That's fair. Was an allegation made that there was less cash than there should have been?
Yes.
And who made that allegation?
I believe Mr. Foreman.
How did you learn about this discrepancy?
The evidence technician that releases property had called me and told me that the count was short.
Tell us what you mean by that. The count was short.
Just that there was more money listed than what there was inside, and that was less money was returned than what was indicated.
And where was this amount indicated?
On the bag.
On evidence bag?
Correct.
If I'm understanding you correctly, the amount of money that was indicated on the evidence bag was more than what was actually returned to Mr. Foreman?
Correct.
All right. And were you able to account for that discrepancy?
I wasn't.
What happened?
Once the The allegation was made, the sheriff contacted Claremont County Sheriff's Office to conduct an independent investigation.
Do you know whether an independent investigation was conducted by the Claremont County Sheriff's Office?
Yes.
And do you know the results of that investigation?
They were to determine that I miscounted the money during my original count.
All right. Did they conclude that any money had been taken?
I just said there was not any money taken.
Did that
Obviously.
stop Mr. Foreman from continuing to claim you had stolen $400?
No.
Did he accuse anyone other than you of stealing money?
Multiple times he accuses all of being thieves.
Do you know where he made these allegations?
Instagram, Facebook, YouTube, social media.
How did you learn about these accusations on the internet that you were a thief?
Friends and family were sending them to me.
Were the accusations true?
No.
I think you said you've reviewed your body-worn camera from that night?
Yes.
And were you able to tell what happened?
From what it appears, if I began counting money, I stopped to reshuffle money that was in my hand and then began counting again after putting money down. And there was, at some point, there was a discrepancy in the amount that there was and the amount that I counted.
Was it a miscount?
Yes.
Now, were any charges that are brought against Mr. Foreman as a result of this warrant execution? I may have asked you that, I'm sorry.
No.
Sometime after the execution of this warrant, Detective Newland, did you become aware that Mr. Foreman had posted certain things other than being a thief about you on social media?
Yes.
And how did you learn about these posts?
Friends and family were also sending them to me.
Ms. Bradshaw, could we see Exhibit 16?
Yes, we need to switch it to the HDMI, right? Right, Chris? Okay. So it can be on the screen.
What does she want to put the card on?
She needs to switch to left wall, I believe.
It's left.
I'm going to laptop up here.
Okay.
You want to get a card?
Yes.
Okay, can we blow that up some? All right. Detective Newland, we're showing Exhibit 16. Can you tell us what this is?
It's one of the posts from Mr. Foreman that I was sent about me being a pedophile.
And am I reading the date right, September 2nd, 2023?
Yes.
And I'm not going to ask you to read it, but I will read part of it just to make sure it's in the record and that people are clear on what it said. This is the uneducated can't count pedophile police officer that stole my money. His name is baby-making Brian, child molesting, newborn baby mama, newborn Newland, Detective Brian Newland. I have a song coming out about him. The chorus goes like this. I pledge allegiance to the flag. Brian Newland is a flag. He used to play with little toys. Now he plays with little boys. Watch your little boys around Brian Newland. He's very bold. He will fondle little boys' testicles and butt cheeks right in front of you in broad daylight. This is a public service announcement. Stay safe. Did I read that correctly?
Yes.
Can we see exhibit 17, please? Can you just scroll down so we can see the whole thing for a second? All right. So I'm not going to read this whole thing, but it says, in part, if you pay me back the money you stole from me, I won't tell the world about your pedophile pilgrim family, you know, like your brother, that's named Will You Stop Sending Dick Pic Williams, a.k.a. William Newland. If you get arrested in Adams County, all you got to do is lie on me and Brian will let you go.
And this is the crazy part, because this isn't the only time he does this with the social posts, but there's more in these posts that go directly to commentary on this raid on Afroman's home. And he's like, I'm not going to read the whole thing. And then he takes like 5 minutes to figure out what it is he wants to read. So it gives you the time to read the whole message yourself and get the context. And this is being said in the context of, you know, they can't count my money. Like, this is commentary on counting money. They're grabbing down guns. They're kicking down your doors. They'll try to kill you in front of your kids. No charges against her or you, by the way, giving false information to the police and attempting to have me murdered. Like, this is, in this context, it's not like he's randomly making this attribution or commentary or opinion. He's doing it in the context of responding to a raid on his home.
And is that a picture of your brother beside your picture?
Yes.
And was your brother convicted of a misdemeanor?
Yes.
What was that?
I don't recall what the charge was.
It was a misdemeanor charge?
It was a misdemeanor, correct?
Did you have anything to do with that crime?
No, I did not.
Have you ever been accused or convicted of pedophilia?
No.
I didn't realize he also said you want to be Eminem, whack-ass rapper at the end. Is there like a SoundCloud for Brian Newland?
Let's look at, let's see, number 18, is that a video?
Yes.
All right. Should we play the whole thing? Or what, do we have, a clip?
Yes.
Well, yes. Baby making Brian newborn Newland. Yeah, the serial statutory rapist.
And so I think that might be the line that people, maybe they're arguing over that line. I don't know.
With the pedophile brother fired from the People's Police Station, will you stop sending Dick Pic Williams?
All right, and let's take a look at number 10. this a, yeah, okay. Let's see. He used to do hard drugs. It says there in the third or fourth line. Did you ever do hard drugs, Detective Newland?
No.
He snitched on all his friends. You have any idea what that's all about?
No.
Now he steals money from traffic stops, bogus raids, and from Adams KK County Sheriff Evidence Room under the camouflage of law enforcement. Did you ever steal money from a traffic stop?
No.
Did you ever steal money from anybody?
No.
Then down below it says, baby making Brian Newland t-shirts on sale. You see that?
Yes.
Let's look at Exhibit 15, please. And can you tell, Detective, is this a picture of you at the, entering the, or somewhere on the property of Mr. Foreman during the search?
Yes.
And let's take a look at 14.
So here, I mean, he's saying brother of a pedophile. I don't know, does that count as a correction?
And do you know where this was taken? I guess you weren't there.
It appears to be the inside of the interview room at the Adams County Sheriff's Office.
Would that have been where his money was returned to?
Yes.
And part of what it says is, when I went to get my money and we realized baby-making Brian Newland had stolen $400 out of the evidence money. Again, did you ever steal any of his money?
No.
Let's take a look at Exhibit 15, please. Or did we do 15?
Yes.
Sorry. Number 2.
I'm getting sued for telling the truth and the truth.
Stop. Objection.
Yes, Your Honor, I would have an objection to this video.
Tell me what it is.
And it pauses on the they stole my money sign.
Because this video, if I'm not mistaken, was published within the last 2 weeks. The law on this has changed. Ohio has actually passed what's called an anti-SLAPP law, which therefore extends immunity to things, actually, in a way, increasing a person's freedom of speech rights in Ohio. Thus, this evidence to be tried here would be tried under a completely different standard than when this case was started.
Comments, Mr. President?
That law doesn't apply to this case, Judge, or this evidence.
Your Honor, it would apply clearly. He has no analysis other than to say it did. I submitted a written brief to the court on this matter.
I think that was submitted Sunday.
So, like, I'll note the objection, overrule it, and allow it to be played. Got your objection down. Thank you.
Thank you, Judge. Can you expand a little bit or not?
I cannot.
So we can see the sign? Okay. Detective Newland, can you see what that sign says?
Yes.
What is it? Would you read it for us?
They stole my money.
Okay. Go ahead and play.
Videos selling my proof. How can you take me to court when you stole my money and it's $400 short? You vandalized my property, and you filed a lawsuit properly. I'm a rapper, so I'm rapping. What? I can't talk about what happened? What happened? Videos I expose might cause
What does
a...
that say? Sorry, what did you read? Could you read what that said?
Yeah, Brian Newland stole my money.
Brian Newland stole
from
my
me.
money. And that was just published in the last few days, as far as you know?
Yes.
Can we look at number 3, please?
Getting sued for telling the truth, posting videos, selling my proof.
Okay, basis.
Same basis on it, yes.
Noted, overruled. Go ahead.
And you take me to court when you stole my money and it's $400 short. You vandalized my property, and you filed a lawsuit properly. I'm a rapper, so I'm rapping. What? I can't talk about what happened? What happened? Videos I expose might cause a...
And that was the same video, obviously. Does it tell where that was posted?
It looks like this one is on YouTube.
And the other one was Instagram?
Yes.
So 2 different platforms, same video.
Yes.
Can we look at Exhibit 9, please? And I'm looking specifically about halfway, a little more than halfway down, do you see, Detective, where it's posted, not only did he steal my money from my house, he stole money out of the evidence room at the Adams County Sheriff's Department, away from my house, making the Adams County Sheriff's Department the new crime scene. I'll just stop there. Again, did you ever steal any money from his house or from the Sheriff's Department evidence room?
No.
What's the platform?
Can you see what that one was, Detective?
I can't see on here.
Is that Facebook? No. It's Facebook? I'll represent that it's Facebook, Your Honor.
Thank you, go ahead.
So, and we can take that down or whatever, we don't need to keep it up, I don't care, but I'm done with the exhibits right now. Detective, I just want to ask you, the first one we saw with you holding, it looks like a child with a smiley face.
Yeah.
What was that originally a photo of?
That was from one of the shop with the cop events at the sheriff's office.
What's a shop with a cop event?
It's where the community donates money, and then local law enforcement will take lower income children to Walmart and let them shop for Christmas.
And did you participate in that event regularly?
Yes.
And do you know what year that picture was taken from?
I don't recall.
All right. And the little boy you were holding there, can you tell us anything about who that was? Not his name, of course, but who it was?
I was just a cool little boy that got picked for Shop the Cop and chose me to be his officer.
Chose you to be what?
His officer.
And what did you do? Did you do something with him, shop with him, or what?
We put him in the cruisers, turn the lights inside, on parade through town, and we go to Walmart and help him shop. And we come back to the fire department or wherever and help them get their toys ready or play or, and feed them pizza, stuff like that.
And you did that more than 1 year?
Yes.
And that was a photo that Mr. Foreman or somebody on his behalf took and used in that pedophile posting?
Yes.
So, Detective, what effect did it have on you when you saw these posts that you're a pedophile?
I was angry, sad, depressed, upset.
Why were you sad or upset? Isn't it just somebody exaggerating or making jokes or making a comment?
I didn't find it funny at all. I work in law enforcement, have kids, have friends, family. I was involved in the schools, and then I'm being blasted all over social media for the entire United States to see that I'm a pedophile.
Did you ever have any evidence that other people were?
All right, so Pam, I think this is in reference to Afroman, because Pam's down at the courthouse, Pamela, right? I don't know if, like, I want to read your name as liaison, but that's not what it says, but my name is trying to go there, but it's Pamela. So Pamela is there at the courthouse so that there are people lined up on the sidewalks with signs to support Afroman, and then says he just left again and walked down the sidewalk again. So probably hanging around still, maybe pacing around waiting to see if they'll stay and keep deliberating or come to a decision. So very cool to have updates from you. Thank you so much.
Seeing these things, other than the fact it's on social media, but did anybody ever say anything or do anything to indicate they'd seen it?
I've had comments made to me since day one.
Like what?
If you want the most recent example, yesterday there was a cheer competition in North Adams. I woke my 3-year-old son in to watch his sister cheer, and somebody asked me if that was another little boy I'm touching.
Yesterday?
Yesterday.
Where? What competition?
At the North Adams cheerleading competition.
What other examples?
Every time you go to an event, another comment's made or somebody says something. Another one I can recall is meet the team night for my daughters. We was in line to get slushies and people were making comments behind me.
What comments?
Just called me a thief and a pedophile and why was I there? And then started playing music, playing some of his songs on their phones.
Some of Mr. Foreman's Afroman's songs?
Yes.
This case isn't about your kids, they're not plaintiffs, but did this have any effect on your kids that affected you in turn?
Your Honor, I'm going to object to this. We had a motion, I filed, the court responded.
He knows better than to ask a question, because I don't care about the kids, because he didn't bring the kids in, so sustained.
What other indications have you had, Detective, that people are seeing and responding to this accusation that you're a pedophile?
Just what's been said to me. It's been shared, been sent to me. I've had people make comments at games, while in the store. It's just, there's so much stuff's happened, I don't even remember half of it.
So you were a Hamilton County deputy sheriff. Sorry, I said that earlier. You were an Adams County deputy sheriff, and you're not anymore?
Correct.
Why?
I ended up leaving the sheriff's office just because of this, because of being called a pedophile and a thief. Explain
to us just a little more about why that was so upsetting that you actually left your job.
Because the sheriff's office, so I'm from Adams County, it's where all my family and friends are from. The sheriff's office was my dream job, my position. I was friends with everybody, and it was where I planned to stay. It's been my career. I dedicated a lot of time, over 10 years, to Adams County. You know, whether it was a call-in at 1 o'clock in the morning or working 14 hours, I dedicated a lot of my time to Adams County, and I loved working at the sheriff's office. But it just got to be so much. If you go to a call or take a phone call or you make a traffic stop, something said. Go to Walmart, something said. I stopped going to my kids' games for a little bit because every time I would show up, everybody would be looking at me or something would be said to me, and just spared their embarrassment.
So when did you leave the sheriff's office?
I ended up leaving in October of 2023.
You have, do your kids' friends come to your house and hang out?
They don't anymore.
Did they used to?
They used to have huge slumber parties, especially on their birthdays. They'd have 10 or 11 kids over, and essentially once this started, it stopped. I don't recall the last time my daughters have had a friend over, if they've had one ever since then.
Detective, did you ask Mr. Foreman to take down these posts?
I didn't personally.
Did you, through your attorney?
Yes.
And have they been taken down?
No.
Are they still there?
Yes.
Those are all of my questions. Thank you.
Is this a good time for a 10-minute break?
Oh, they're gonna do that beep.
Yes.
Then we'll do that. Go off the record for a 10-minute break. Thank you. Okay, thank you for this. Go ahead, Mr. Osborne, cross-examination.
All right, before they do cross, you guys, I am trying to look for updates. I haven't seen any type of updates from Local 12, which is like WKRC or WCPO9. The best we've got is Pamela hearing from her friends that, you know, Afroman's still at the courthouse, right? Like, no indication that everybody's left for the day. And with the verdict, nobody can tell you when somebody's going to have a verdict until the jurors tell a bailiff at the court, so the bailiff can let the judge know that, hey, we've reached a verdict. So nobody can predict for you. So sorry, we can't answer those questions about when will there be a verdict. Also, I want to give a thank you here. Kim, thank you for gifting a membership. Super nice of you. Hope you're doing well. Johnny Knoxville also said, want to sue the cops? Meh, can't. Qualified immunity. Cops want to sue you? No problem. No problem. Don't make content about what they do at your house, because they're going to sue you. So thank you for the 5. And yeah, that type of conundrum pisses me off. So, and then BMAC Nana Banana, member for 17 months, thank you, says, oh, how I love your content. Keep up the great job with the banana emoji. Thanks for hanging out with us for yet another trial. Always good to see Nana Banana, aka BMAC. So we're doing a rewatch. We're doing a rewatch of footage of day 1. So we watched voir dire, which was really cool to see. This wasn't anything that was missing, like the direct, but part of the cross-examination of Brian Newland was missing from the WCPO court feed that we've been watching all week. So we're going to see like a few questions and answers that weren't there, as well as some of the redirect questions. The redirect was cut off in the beginning as well. So we're going to see that, and we're just going to play this through and see if we get a verdict or if we get news that the jury's going home. You know, we'll wrap it up. If not, we'll end when this ends, and when I see news that there's a verdict or any type of jury note, I'll pop live again. So here we go.
We have Deputy Newland, Detective. Go ahead.
Thank you. So Brian, you're still employed as a police officer, correct?
Yes.
You're employed in Norwood, correct?
Yes.
When you went to Norwood, you got a pay raise, correct?
Yes.
You were asked questions about a search warrant. Is it correct to say you were the chief in charge of executing that search warrant?
Correct.
Okay. And you counted all the money?
I did.
You had full control of it the whole time?
Not the entire time, no.
So, walk me through the process by which you cataloged the money.
So while we were conducting a search of the residence, another deputy located the money, I believe, in a jacket pocket from a suit. He handed me the money, explained to me where he found it. At that point, I start to count it in the same room. Once I count it, I collect it, put it in evidence bag, and take it downstairs.
So let's back up. That was very general. So when you counted it, where did you count it?
I counted it in the bedroom where it was located.
And you counted it on the floor?
Yes.
And you made specific piles?
Yes.
Okay. Now, that's not all the money that was recovered is what was coming out of the suit, right?
Correct.
Where was the other money recovered?
There was more money covered from, I believe it was an office downstairs.
Okay. And where did you count that money at?
In that room.
On the floor?
I don't recall if it was on the floor or maybe on a desk that was there.
Okay, and you were wearing your body cam the whole time?
Yes.
What was the time difference between the suit jacket money and the money downstairs?
I don't recall.
You reviewed your body camera?
Yeah, it's been a year. I reviewed it every year ago. I don't recall what the time frame was.
Now, Mr. Newland, let's ask that question. You were deposed, correct?
Yes.
You were deposed on August 8th of 2025, correct?
Correct.
Have you watched the body cam since then?
I haven't. Well, I take that back. I've watched pieces of it. Haven't watched the entire thing.
What pieces have you watched?
Just of me recounting, of me counting the money
So,
from the bedroom.
You watched only the part of your body cam where you recounted the money in the bedroom only?
Correct.
You never watched the part for downstairs?
I did not.
You never watched the part where you sealed the evidence bag?
No.
Did you seal the evidence bag?
The evidence bag was not initially sealed, no.
What do you mean by initially sealed?
So it's not a self-sealing bag. It has to be taped. So it was placed in an evidence bag and then brought downstairs to a central location until it was transported to the sheriff's office.
And the central location, where was that?
In the kitchen.
And you left it there alone?
No.
Who did you leave it with?
When I first went downstairs, Officer Cooley was sitting at a counter and I asked him to keep an eye on it while I continued the search.
Okay, and did he keep an eye on it?
As far as I know, yes.
What do you mean as far as you know?
I mean, I wasn't there the entire time. I went on to continue searching the residence and come back down.
But wouldn't he be in the chain of custody?
Yeah.
So did he sign the evidence bag?
No, I didn't. He wasn't in charge of the custody in that sense of signing or sealing the evidence bag. I just brought the cash down while we was still conducting the search and asked for him to keep an eye on it.
So the cash was never left alone?
That's my knowledge, yeah.
Were you interviewed by Mr. Robinson in relation to this matter?
No.
And remember, for anyone that missed it, Michael Robinson is the detective from, well, maybe not detective from Claremont County Sheriff's Office, neighboring county. And not for nothing, but didn't this guy end up going over to Claremont County? In any case, before Newland gets a different job, this guy from a different sheriff's office does an investigation into this claim of this missing money, this potentially stolen money. And part of his investigation, he does not interview Brian Newland. So what's the point of even doing this investigation if we don't even speak to the people that we should know handled this envelope with this cash at some point in time? It's just bizarre.
Did you make a report about the missing money?
I didn't know.
So there was this question about return on a search warrant. Can you explain what that is?
The return?
Yes.
It's just an itemized list of property seized from a location during a search warrant service.
Did it include an amount of money seized on it?
Yes.
Does that amount of money match what was written on the evidence bag?
Yes.
So as far as the court knows, there was more money taken than what was returned?
I'm sorry.
So as far as the court knows with the return, more money was taken than what was returned?
That's the way it appeared, yes.
Did you put in an amended search warrant return?
I don't believe so.
So you never corrected your statement to the court?
Correct.
Okay. Does the Adams County Sheriff's Office have a policy and procedure pertaining to the counting of money as evidence?
I believe so.
What do you mean you believe so?
I haven't worked there in almost 3 years.
Well, before you worked there, did they have one?
It was, I don't necessarily know that it was a written policy, but it was to have 2 people count the money.
Did 2 people count the money?
No.
Oh, I'm confused on that. Can you tell me why?
So explain to me why it matters, like where you're going in this case's context. Tell me why it's relevant.
Your Honor, this is relevant because if the evidence of Mr. Robinson is admitted, which he has not been here yet, but if it is admitted, this would be direct evidence since he did not interview the person who counted the money. This would go to counter Mr. Robinson's report. And actually in my motion in limine, I talked about it in the idea that we did not have time to depose Mr. Robinson and determine what his investigation was or who he interviewed. As such, I'm asking a leading question of Mr. Newland because he didn't follow the policies and procedures. This was not taken into account by Mr. Robinson, and Mr. Robinson has made certain conclusions in his report that this would tend to cause issue with.
Mr. Robinson on your witness list?
Mr. Robinson is listed on Mr. Klingler's witness list.
Is he going to be called?
Depending on what happens, he might be.
But my concern is going to be hearsay, and everything you're asking the wrong witness is in that category. I get what you're doing, I'm just trying to follow the trail of breadcrumbs.
I'm afraid I'm not understanding the hearsay argument, Your Honor.
He's going to say what another person said and observed. He didn't see it, but read about it, or doesn't have it firsthand. He already said he wasn't involved in that part of it. Give us some room to work.
I have moved past that. That's where I was talking about the policies and procedures, which would not be hearsay in the idea he should
No,
know.
I get that. I'm just trying to track where you're going, so I don't miss the ship sailing. Go ahead.
So, Mr. Newland, you worked at the Adams County Sheriff's Office from, what's the date on that? 2014 to 2023.
Yes.
I think I counted 5 just like sua sponte objections from the judge during this. I believe it was during Newland's testimony.
During that time, when you started the Sheriff's Office in 2014, you reviewed the policies and procedures?
Yes.
So you would have seen the policy on counting cash?
If there was one at the time, yes. I don't recall.
So you don't know if there was a policy at the time?
Correct.
Okay. So how do you know it was supposed to be counted by 2 people?
That was the practice that we normally adhere to. It would be counted by one and then recounted by a second.
And the second person would initial the evidence back?
No, it was just kind of like almost like a system of checks and balances. And then the seizing officer would still initial the evidence.
This may sound an extremely stupid question. How many times did you count the money?
I counted it one time.
Why only once?
At the time there was so much going on, I counted the one time, put it in the bag, and until we got done.
So when you retrieved the bag, you never counted it again?
Correct.
Did you seal the evidence bag before you left?
I did not.
Did you seal the evidence bag at the Adams County Sheriff's Department?
Yes, it was sealed at the Adams County Sheriff's Office.
I didn't ask if it was sealed, I asked if you sealed it.
Yes, I would have sealed the bag.
Let's go back to the deposition of August 8th, 2025. Do you remember that day?
Yes.
Do you remember I asked you about the money?
I remember our conversation about the money, yes.
Do you remember I asked you if you sealed the evidence bag at that time?
I don't recall you asking that.
Really? Okay. Did you ask the sheriff to do an investigation on the missing money?
I didn't, no.
So I just want to get something clear here because my notes are a little fuzzy. You were in the Army at the same time you were a deputy, right?
So, yes, I was in the reserves at the time.
Okay. So that's why you would have been a full-time deputy in 2014 and then discharged honorably from the military in 2015?
Correct.
Okay. You said this job was exciting.
Yeah.
What do you mean by exciting?
So, like I said, when I left the military, I wanted a career that would be not mundane, but kind of like an exciting, something new type of career. So I chose law enforcement.
And you've been called derogatory names before, correct?
Yes.
Significant derogatory names, correct?
Yes.
And that's by members of the public, correct?
Yes.
And that was prior to 2022, correct?
Yes.
Now, you mentioned you have some brothers. Do you have a brother that worked in law enforcement?
Yes.
Was he the chief of People's
He was.
Police? Why did he leave?
Why does it matter?
Your Honor, it has been brought up because one of the images has William Newland, and as you read through the post actually talks about Mr. Newland leaving the police department, so therefore I am building a foundation to show the truth of what statements are in there.
Is that the reference to the plaintiff's picture we're talking about?
It's a reference to one of his exhibits, yes. Give me a second, I'll tell you what exhibit.
As long as it refers to that exhibit, I get where you're going, so you can keep going.
Oh, hold on here. Very cool. Haha Hypno became a member, and of course I looked, and it does say hypnosis before I jump the gun here. Sometimes YouTube will give me member notifications if somebody becomes a member through any channel. It'll just show up where we're watching. Are you watching this live with us right now? Haha Hypno. Because earlier this week we took a look at an amicus brief by Penn and Teller to the Supreme Court of the United States saying, hey, we urge you to consider why forensic hypnosis that's used for prosecutions and criminal investigations, is flim-flam. It shouldn't be used. It was very, very cool. So, cool to see you pop up. Thank you so much for becoming a member. But also curious, if you're watching this live with us, if you've been able to see that, because it's related. It's very related. Very, very cool. I'm going to drop a link to your channel.
I'll re-ask the question. Why did your brother leave the People's Police Department?
He was charged with some kind of crime through the Adams County Prosecutor's Office.
Yeah.
He was subsequently convicted, and he resigned or quit sometime during the process.
And it is a fair statement to say it involved minor children?
I really don't know anything about the investigation.
You don't know anything about your brother's crime he was charged with?
Just what I've seen on...
So someone really did laugh. Remember we were watching this, we heard someone laugh? Because in this feed it sounds like clearly a laugh from the courtroom. Also, Haha Hypno answered and said, I agree with Penn and Teller. Very, very cool to have a comedic hypnotist in the building sharing their thoughts on that. Super, super cool stuff. Also, thank you to Johnny Knoxville saying the jury is going to reward each cop $4.20. Oh, that'd be so perfect. Thank you for the 2. But yeah, let's listen. Right? You guys hear this laugh?
Minor children?
I really don't know anything about the investigation.
You don't know anything about your brother's crime he was charged with?
Just what I've seen on Jail Tracker in the past.
So you're not close to your brother?
I'm not, no.
Okay. Are you close to your family then?
And the reason I think it's so important is when we're watching from this angle, from the camera pool, I'm like, well, maybe it's just coming from someone that's sitting in the gallery. But I don't know. That kind of seemed like it was coming from this area. I don't know. Maybe a cough? Maybe a cough? You could be right. You could be right.
Yeah, most of my family.
Then why not your brother who's in law enforcement?
Well, we were both in the Army at the same time, separate parts of the world. We kind of got close again, and then once this, his issues happened, we kind of just drifted apart again.
So you drifted apart once he had a criminal problem?
Correct.
Let's talk about that. Has anybody asked you about that prior to 2022 when he was charged?
No.
No one asked you about your brother?
I'm sorry? Like before he was charged and it came out to everybody? No.
So no one asked you about your brother being charged with crime?
Yeah, after the fact. I've been asked about it.
When was the first time you were asked about it?
It would have been shortly after he was charged or arrested. It was all a complete surprise to me.
And that was prior to Mr. Foreman's video and post, correct?
I believe so, yeah.
So now you've said people have treated you differently since Mr. Foreman's post.
Yes.
So people come and ask you about your brother. Did they treat you differently because of that?
It was just on a smaller scale. I was asked about it, and then that was it. It wasn't shared, and I wasn't put in music videos and everything else because of that reason.
But your brother's criminal charge and everything was in the front page of the local newspaper, correct?
Yeah.
So everybody in Adams County knew that your brother was charged?
Correct.
And so did people treat you differently at that time?
No.
Not at all?
No.
Why didn't they treat you differently?
That'd be a question for them.
Okay. Would it be because they knew you?
Since he said he doesn't know, you shouldn't ask that question and strike it.
Strange question.
Thank you. See, that would be a classic example of testimony from the lawyer, not the witness who said he doesn't know. Go ahead.
If you don't know if they treated you differently when your brother's was on the front page of the paper, how do you know that your treatment today, or as you testified to, was due solely to Mr. Foreman?
Well, prior to this, nobody called me a pedophile. Prior to this, there was nothing published about me being a pedophile. Prior to this, nobody asked me if I was molesting my own 3-year-old son.
What about the officers you work with down in Norwood? They think it's a joke, don't they?
Do they? Which part?
Let me rephrase the question. Did the officers that you work with at Norwood put up a picture or an image of Mr. Foreman on your computer?
Yes.
Did you ask them to take it down?
No.
Did they think it was funny?
Yes.
And they're in law enforcement?
Yes.
Do they think any different of you because of this?
I don't know.
They don't treat you differently?
I don't really, I mean, I work with them, but I don't really associate with them. I go there and I do my job and I come home.
When you interviewed for the Norwood Police Department, they never held anything Mr. Foreman said against you?
I don't believe so, no.
Would it be fair to say it did not affect your professional career then?
Oh, it absolutely did.
How so?
Even if I move locations from Adams County to Cincinnati or to Los Angeles, people still ask if I'm a pedophile. People still ask me what it's about. People still ask me if I'm a thief.
But the people you work with do not ask that, correct?
They don't ask me, I know.
When you were interviewed, your future employer never asked you that question.
No.
So then when you say it damaged your reputation, you're only referring to people in the public, correct?
No. That's just what people in the public is what I know. Maybe people do have bias against me, in law enforcement, I don't know.
Were you ever passed up for promotion because of this?
Not that I'm aware of.
Were you ever disciplined because of this?
No.
And you agree while you're out in the public, people are seeing you perform your law enforcement duties?
Yes.
And based upon what they see, they will make comments about you, correct?
Yes.
So how you perform your duties reflects on your reputation?
Yes.
And you've testified in the courtroom before, correct?
Yes.
Have you ever testified in a civil case before?
No.
Have you ever testified in a civil case that involved the duties of a police officer before?
No.
You've had citizens comment on your execution of your duties before, correct?
Yes.
Not all those comments have been positive, have they?
Correct.
And so you would agree that as a police officer, you are subject to public scrutiny?
Yes.
And you've never sought to keep your status as a law enforcement officer secret?
No.
Have you ever been in the local newspaper?
Yes.
Was it positive or negative?
Positive.
But not everything they write is positive, is it?
Correct.
Yeah, take it to trial.
As you've said that people can comment on your execution of your duties as a police officer, did you follow the procedure correctly in execution of the search warrant?
In the execution of the search warrant itself, yes.
So you knocked on the door as required by law?
Correct.
Okay. And then you decided to kick it in?
Correct.
And then when you couldn't kick it in, you went to the side door with a battering ram?
Correct.
Why did you try to kick the door in with your foot?
Is this what we're not trying?
Your Honor, he has opened the door and saying that
No, I closed the door. So I don't think we're trying the search warrant case.
Your Honor, he is claiming that his reputation is linked to how he performs his official duties. I am merely introducing that he has not followed procedures, and therefore a person can criticize him on that, and therefore he would have that as part of his reputation that everybody would have to consider.
Well, we don't have any standard against which to measure that, which is the whole point. So how are we going to get a standard against which to measure that? Otherwise, you get a dance in the pea patch. I said we're not dancing it.
If we can't present that he hasn't done his job correctly and that would reflect negative on his reputation, then I don't understand what we would be presenting that, because his reputation is exactly what he is claiming is damaged. It is the very issue that they're going to ask for money damages about.
Do you have an expert that's going to say there's a violation of a search warrant process?
No, we're just going to introduce the policies and procedures in place at that time.
There are some?
There are, yes.
Well, then put the foundation out there first. Like my prior decision, made that clear. I'm trying to work with you, don't get me wrong, but I'm pretty good about staying laser focused.
I'm trying to ask the questions now so I don't have to recall Mr. Newland after the Sheriff Kenny Dick is called, so he can tell us what the policies were at that time. But I can save this line of questioning and recall him later for it if that would be more amenable to the court.
I don't see policies and procedures on your witness list.
Exhibit list.
The witness list or exhibit list, Your Honor?
It's all together, so exhibit list. I might have an old one.
There is an amended one, if I may.
Do you have one, Mr. Klingler?
Yes.
Amended when? Mine stated March 12th, so if you amended it on Friday, I might be out of date.
March 12th.
I've amended witness list. Let's see, Sheriff's Office policy and procedure.
Policies and procedures for Adams County Sheriff's Office. I
So that's
see.
is it the whole policy procedure manual?
Yes, Your Honor, although we're going to try to tailor it to just what's relevant so we don't have an entire manual.
And Judge, we've stipulated to the authenticity of
That comes in.
that document, so I don't know if he needs a witness to come and authenticate it.
Keep her going then, Mr. Osborne.
I would note I would need Mr. Dick to come in and say they were in place at the time, as Mr. Newland can't remember that they were in place.
Well, we might be able to stipulate to that too.
Now, it's not every time you're in public that people yell and scream thief or pedophile, correct?
Correct.
There's quite a few times you can have a peaceful meal with your kids and never have any problems.
Correct.
It's only at certain times this occurs, correct?
Correct.
Have you ever been accused before of stealing money from traffic stops?
Yes.
It was not Mr. Foreman that accused you, correct?
Correct.
Have you seen a copy of Mr. Robinson's report?
I may have seen, I don't believe I've seen the whole report. When he first conducted the report, or conducted the investigation, I was provided a copy of the report, or a partial copy.
But you never sent that to Mr. Foreman, did you?
I didn't know.
You would agree if someone called someone a baby killer, that would be an exaggeration?
I'm sorry?
If someone called someone a baby killer, that would be an exaggeration, wouldn't it?
Yes.
Nobody would take that seriously, correct?
I'm sure somebody would.
So when you talk about your reputation, are you talking about your reputation only in Adams County, or are you talking about it in the whole world?
My reputation in general. Adams County, Hamilton County, the entire world.
The entire world. So you care what people think about you in Australia?
When it affects me and my job, yes.
How does Australia affect your job?
I'm not saying that it does. I'm just using it as a generalization. If it affects me and my personal life and my job, yes, it matters to me.
Now you're claiming that by being called a thief, you were painted in a false light.
Yes.
And what exactly does that mean?
That I was being painted in a false light.
You've been accused of stealing from traffic stops before.
So being accused of stealing in traffic stops before was when money was seized and forfeited by the courts and no longer returned. And I was, unquote, quote unquote, called a thief. Never to this extent.
Okay.
Never to this broad, you know.
But you would agree there is some similarity here. Money was seized here too.
Correct.
So could you explain to me which statement or how the statements of being a thief and a pedophile pertains to your private life?
Because I'm more in my private life than I am my work life. My work life aside, my private life includes going to school events, going out to eat, going to Walmart, shopping, my day-to-day activities. You know, being called a pedophile and a thief, you know, in the world of social media, you know, as a whole world sees that platform. It's been shared hundreds of times, liked and commented on hundreds of times. You know, I'm thought of as a pedophile now. I'm called a pedophile. I'm asked if I molested my 3-year-old son. There's just so much stuff that's been done and said in my personal life, conducting my personal business, that's where the majority of it is, my personal life.
Do you wear a uniform every day?
No.
So how would I know if you're in your private life or public life?
If I don't have a gun and badge, then I'm probably not at work. So if it's outside of work, it's probably my personal life.
So you don't believe that Mr. Foreman saying you stole his cash is an opinion of his?
I believe it's an opinion that he portrayed as a fact.
But it's his opinion?
Correct.
It's not a fact?
No.
Because you didn't steal the money?
No.
Do you think when he called you a pedophile, that was an opinion of his?
Again, an opinion that he portrayed as a fact.
Okay. But an opinion of his?
Correct.
Okay. If he had put a picture of you next to Stewie from Family Guy, would that have been an opinion of his, mocking you?
Yes.
And you're in no way saying that calling you a thief or a pedophile is anything about your private life?
I'm sorry, yes, it is my private life.
No, I said it's nothing about a fact of your private life.
Oh, no.
Have you ever publicly explained your side of the story?
No.
Have you ever publicly went to the People's Defender and asked them to print your statement that you're not a pedophile?
Why is that relevant?
Mitigation of damages, Your Honor. They're testified that they're trying to build up damages in the fact of saying Mr. Foreman never took down posts, but if they've never taken any steps to mitigate it, such as portray their side to the media, that can be taken into account when considering damages for mitigation.
Is that right, Mr. Klingler?
No.
Why not? Why not? They can explain this.
When someone's attacked and lied about, they don't have a legal obligation to go to the press and get more press coverage by denying it. He's not only can do by asking them to take down the posts, if we won't take them down, everything he does to try to mitigate it is just going to cause more attention to it. There's no requirement that he go to the press and argue his case in the press or try his case in the press. That's not what we're supposed to be doing.
Mr. Osborne?
So if we take the position of Mr. Klingler, that means that you don't ask for a retraction of any kind. You just let your expenses, your damages build and then go sue for it. When you're asking for damages, you have to consider mitigation factors. And in this case, the duty is to mitigate your damages on this. And he's not taken any steps as such, so we have a right to introduce that so that we can argue for mitigation of damages if liability is found.
And that, ladies and gentlemen, is how we educate you, by letting the lawyers explain what's going on. Next question, go ahead.
Sorry, Your Honor.
No. I told you I was going to do this, you just didn't see it coming. Go ahead.
And so it's correct that you didn't request any posts to be taken down until after the lawsuit was filed, correct?
Correct.
And it goes without saying that you've produced no records to show an economic, concrete, money value damage, correct?
Correct.
And you've never seen a doctor about this, correct?
No.
So when you talk about emotions, you're not talking about having to see medical treatment or anything?
I just deal with them on my own.
Did you ever send a cease and desist letter?
No.
And you're suing for money damages, correct?
Correct.
You want paid, correct?
I want it to stop. I want him to stop being portrayed every morning as a pedophile and a thief.
Your Honor, if I may have a few moments to talk with my client and see if there's other questions that we may have at this time.
Do you have other examination for this witness?
I have a very brief, but a few follow-up questions.
What's that mean?
Yeah, 5 minutes, 5 questions, 5 minutes, I would think.
Okay. Go ahead.
If I may have a moment to speak with my
Yeah,
client.
that's what he's doing, redirect.
Oh.
Go ahead, Mr. Klingler.
Oh, okay.
So we had missed the beginning part of this as well.
Sure.
I'll jump around a little bit, Detective, because I want to just follow up on some of the points that Mr. Osborne made. These other names that you've been called by other people at other times as a law enforcement officer, did any of those cause you to quit your job and find a job in another place?
No.
You said, I think, that some officers in Norwood posted, was a picture of Afroman, of Mr. Foreman, on your computer?
Yes.
Did they post a picture of the accusation that you're a pedophile?
No.
As a public official, you're subject to scrutiny, I believe was Mr. Osborne's question, and you agree with that, correct? You're subject to scrutiny.
Yes.
And when you became a police officer, did you think you were signing up for being called a pedophile and having to lose your job?
No.
Do you think do you think being called a pedophile is just an exaggeration?
No, I don't.
You got asked a question about your emotions and whether or not you've seen a doctor, and I believe you said you haven't.
No.
Can you tell us anything about the atmosphere in law enforcement circles that, as you've experienced it, and the attitude toward therapy and emotions and that sort of thing?
There's a stigma on seeking medical help or seeing a doctor or taking therapy. You're just expected to take it and move on, and it's all fun and games, kind of like, them posting that picture on my computer. I didn't find it funny at all, but they did. Like, it's just that stigma, around law enforcement in general.
This bothers me, and I agree that I'm sure there's stigma and people avoid seeking help because of the stigma. But also, if you're in law enforcement and as part of this lawsuit, you're claiming that you're dealing with depression and all of these issues, and you don't go to the doctor, and as part of your lawsuit, you're trying to explain, well, here's why I can't show that I have, something to back up, that I really have these emotional damages. If you're still employed in law enforcement in some degree, and you're saying, I should be going to seek this help, but I'm just not because people will make fun of me, then I have a problem with you still serving on the force, active duty. Like, if you should get treated according to yourself for the purpose of this litigation, while you're under oath, you're saying this stuff, maybe there's an issue with your fitness for the work that you're doing. It's a catch-22 that he's creating because he's trying to flare up and exaggerate his position. My take on it is he's exaggerating it for the sake of this lawsuit and doesn't really need the help. But if we take it at face value for the purpose of this lawsuit, then it flips over to his line of work. And you're not seeking this treatment, but you're saying over here that you need it. And then you're out there holding a gun, dealing with tense situations every day. Like, it's one side of it's problematic. Whichever side you want to take at face value, I think it's problematic. But okay. But okay, here we are. Also, I want you guys to check out, we heard people talking about Larry Flint, the SCOTUS case earlier. That is Hustler Magazine versus Falwell. So Zadija is also recommending this. I hope I'm saying that right. I always hate when I have to say someone's name for the first time. I hate getting names wrong. Unless I'm intentionally trying to mock somebody, But Zadija, thank you so much for the 2. And thank you for the actual caption name of the case. I do a quick glance over at the Wikipedia for the background. I don't have time to read a whole decision. Although I'd like to. So this is a throwback, guys. This is decades ago. 1988. There we go. 1988. Hustler Magazine, Inc. v. Falwell. It's a landmark decision by the Supreme Court of the United States in which the court held that parodies of public figures, even those intended to cause emotional distress, are protected by the First and 14th Amendments to the U.S. Constitution. In the case, Hustler Magazine ran a full-page parody ad against televangelist and political commentator Jerry Falwell Sr., depicting him as an incestuous drunk who had sex with his mother in an outhouse. The ad was marked as a parody that was not to be taken seriously. In response, Falwell sued Hustler and the magazine publisher Larry Flint for intentional infliction of emotional distress, libel, and invasion of privacy. But Flint defended the ad's publication as protected by the First Amendment. In a unanimous decision, 8-0, the court held that the emotional distress inflicted on Falwell by the ad was not a sufficient reason to deny the First Amendment protection to speech that is a critical part of public officials and public figures. Constitutional limits to defamation liability cannot be circumvented for claims arising from speech by asserting an alternative theory of tort liability, such as intentional infliction of emotional distress. So, I wonder where I wonder where the other two, like the invasion, like the false light, if that would apply to this same framework. Known for its explicit pictures of nude women, crude humor, and political satire, Hustler, a monthly magazine published by Larry Flynt, printed a parody ad in its November 1983 issue that targeted Jerry, a prominent Christian fundamentalist televangelist and conservative political commentator. The parody was mimicking the popular advertising campaigns that Campari, an Italian liqueur, was running at the time that featured brief, contrived interviews with various celebrities that always started with a question about their quote-unquote first time, a double entendre meant to give the impression that the celebrities were talking about their first sexual encounters before the reveal at the end that the discussion had actually concerned the celebrity's first time tasting Campari. The Hustler parody, created by writer Terry Abramson and art director Mike Salisbury, included a headshot photo of Falwell and the transcript of a spoof interview, where, misunderstanding the interviewer's question about his first time, Falwell casually shares details about his first sexual encounter, an incestuous rendezvous with his mother in the family outhouse, while they were both, quote, drunk off our God-fearing asses on Campari. In the spoof interview, Falwell, and it's in quotes because it's somebody else playing him, goes on to say that he was so intoxicated that, quote, Mom looked better than a Baptist whore with a $100 donation, and that he decided to have sex with her because she, quote, showed all the other guys in town such a good time. When the interviewer asked if Falwell ever tried it again, it, in quotes, once again mistaking the interviewer's intention, Falwell responded, sure, lots of times, but not in the outhouse. Between Mom and the shit, the flies were too much to bear. Well, dang. Finally, the interviewer clarifies that he's asking if Falwell had tried Campari again. Falwell answered, I always get sloshed before I go out to the pulpit. You don't think I could lay down all that BS sober, do you? The ad carried a disclaimer in small print at the bottom of the page that said, ad parody, not to be taken seriously. And the magazine's table of contents also listed the ad as fiction, ad, and personality parody. Falwell sued Flint Hustler Magazine and Flint Distribution Company in the United States District Court for the Western District of Virginia for libel, invasion of privacy, and intentional infliction of emotional distress. Before trial, the court granted Flynn's motion for summary judgment on the claim of invasion for privacy, and the remaining two claims proceeded to trial. A jury ruled against Falwell on the libel claim, stating that the parody could not reasonably be understood as describing actual facts about Falwell or actual events in which he participated. On the claim of intentional infliction of emotional distress, the jury ruled in favor of Falwell and awarded him $150,000 in damages. Flynt appealed to the Fourth Circuit. The Fourth Circuit affirmed, rejecting Flynt's argument that the actual malice standard of New York Times Company v. Sullivan applied in cases of intentional infliction of emotional distress, where the plaintiff was a public figure, as Falwell concedingly was. The New York Times standard focused too heavily on the truth of the statement at issue. For the Fourth Circuit, it was enough that Virginia law required the defendant to act intentionally. After the Fourth Circuit declined to rehear the case en banc, the U.S. Supreme Court granted Flynn's request to hear the case. So, opinion of the court. Let's see if they mention explicitly, like, oh, they disclosed it as parody. So we've got, at the heart of the First Amendment is the recognition of the fundamental importance of the free flow of ideas and opinions on matters of public interest and concern. The freedom to speak one's mind is not only an aspect of individual liberty, and thus a good unto itself, but also is essential to the common quest for truth and the vitality of society as a whole. We have therefore been particularly vigilant to ensure the individual expression of ideas remains free from governmentally imposed sanctions. The First Amendment envisions that the sort of robust political debate that takes place in a democracy will occasionally yield speech critical of public figures who are, quote, intimately involved in the resolution of important public questions or, by reason of their fame, shape events in areas of concern to society at large. In New York Times v. Sullivan, the court held that the First Amendment gives speakers immunity from sanction with respect to their speech concerning public figures, unless their speech is both false and made with actual malice, the actual malice standard, with knowledge of its falsehood, or with reckless disregard for the truth of the statement. Although false statements lack inherent value, The quote, breathing space that freedom of expression requires in order to flourish must tolerate occasional false statements, lest there be an intolerable chilling effect on speech that does have constitutional value. To be sure, in other areas of the law, the specific intent to inflict emotional harm enjoys no protection. But with respect to speech concerning public figures, penalizing the intent to inflict emotional harm without also requiring that the speech that inflicts that harm to be false would subject political cartoonists and other satirists to large damage awards. So this is interesting. Like, what if we have a split verdict here, and they're like, all right, well, we don't know if you really defamed somebody, but we're going to say that you inflicted harm. We have a quote here. The appeal of the political cartoon or caricature is often based on exploitation of unfortunate physical traits or politically embarrassing events, an exploitation often calculated to injure the feelings of the subject of the portrayal. And to me, this right around, you've got unfortunate physical traits, politically embarrassing events. You have the raid, and then you have Lisa's voice. This seems to apply exactly to the consideration for Lisa, the way I'm looking at this. This was certainly true of the cartoons of Thomas Nast, who skewered Boss Tweed in the pages of Harper's Weekly. From a historical perspective, political discourse would have been considerably poorer without such cartoons. Even if Nast cartoons were not particularly offensive, Falwell argued that the Hustler parody advertisement in this case was so outrageous as to take it outside the scope of the First Amendment protection. But outrageous is an inherently subjective term, susceptible to the personal taste of the jury and panel to decide a case. Such a standard runs afoul of our long-standing refusal to allow damages to be awarded because the speech in question may have an adverse emotional impact on the audience. So long as the speech at issue is not obscene, and thus not subject to First Amendment protection, it should be subject to the actual malice standard when it concerns public figures. Clearly, Falwell was a public figure for purposes of First Amendment law. Because the district court found in favor of Flint on the libel charges, there was no dispute as to whether the parody could be understood as describing facts about Falwell or events in which he participated. Accordingly, because the parody did not make false statements that were implied to be true, it could not be the subject of damages under the New York Times actual malice standard. The court thus reversed the judgment of the Fourth Circuit. So, and there's a whole bunch. So if you guys want to read this, there's a bunch of citations in here if you want to look at what they're saying is related. I think we had this Gertz case cited by Osborne in one of the motions that we looked at as well. Not sure, but I think, unless it was a different Gertz case, but I mean, seems relevant. So there we go, very cool. And again, that was only a portion of the opinion, it seems like. So it wasn't the full thing. But very cool to get the summary here, and shout out to Zadeja. We've also got, let's see, just Jenny, that's me. Jenny, not from the block, says, Kat, I'm hungry, take a bite of that cake for me. I'm going to make a cake one of these, maybe this weekend. My birthday's at the end of the month, so maybe I'll do a lemon cake, you know? Just keep it on theme. Let me refresh for news stations before we start continuing the rest of day one. Let me just do a quick refresh. No updates from the Watchdog Wire. Let me check X for updates from... We're going to follow J1 Shakir Jones. Let me share a link here. Dropping that in the chat. So let's see, moments ago speaking with OG Afroman as a jury in Adams County, Ohio is currently deliberating over whether the rapper is liable in a civil case leveled against him by several sheriff's deputies. Afroman tells me it's his First Amendment right to say what he wants through his music. More on Afroman trial, and they just say the news outlet there. So yeah, this to me, it was just published. So, what? 15 minutes ago. Let's see if they've got anything else on WCPO. Nope, nothing on WCPO. Let me check Local 12. I mean, unless the jury like sent a note in the last few minutes, I don't think that's going to change, but they're still deliberating as of 15 minutes ago. So let's hit the play button. Let's go back over. We'll hit the play button. And I don't know, should I... If we run this up, if we finish this out, I feel like I might end the stream and then come back if I see that there's a verdict. But who knows, maybe we'll get one in the next 30 minutes. We'll see. Let's see, guys. Oh, I didn't share it. There we go.
Yes. Those are all my questions, Judge. Thank you.
Back to you, Mr. Osborne. Thank you.
Thank you. Just a few more questions, Brian. You would agree that there was mistakes made during the search and counting the money and everything, correct?
Yes.
So it was not done perfectly, correct?
Correct.
You mentioned that as an officer, you're supposed to take it and move on. Is that part of having a thick skin as a police officer?
I guess you could word it that way, yeah.
Is it correct to say that the officers at Norwood found it funny, but you didn't?
Correct.
So some people find things funny that you don't find funny?
Yes.
Your Honor, I have no further questions for this witness at this time.
Go to step down. What do you got that's going to get me 30 or 40 minutes, Mr. Klingler?
Our next witness, Judge, is Lieutenant Lisa Phillips.
What if he slipped and was like, our next witness is Lieutenant Lisa, he messed up. That would be so funny.
Can you get through your direct by 4:15 to 4:30?
That may be difficult.
And give me somebody you can get through.
I think I can get through my direct, Judge.
That's the goal. Thank you. Let's go.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God.
Yes, sir.
Thank you. You may be seated.
Go ahead, Mr. Klingler.
Thank you, Your Honor. Would you introduce yourself to the jury, please?
Lisa Phillips,
And Lisa, where do you live?
Adams County.
How long have you lived in Adams County?
At least 24 years or so.
And what do you do for a living?
I'm a deputy sheriff.
When did you start your career in law enforcement?
2001.
And what were you doing at that time?
Well, I graduated high school in 2000 and went to the police academy.
What academy did you go to?
Greenfield Police Academy in Hillsborough.
And how long have you known you wanted to be a police officer?
Since I was a kid.
What was your first position then out of the academy?
Part-time at West Union Police Department.
And then when did you become, was your next job a deputy sheriff?
Yes, sir.
When did you start as a deputy sheriff?
September of 2002.
And do you have family here in Adams County?
Yeah. Yes.
You have a husband?
Yes, sir.
And a child?
Yes, sir.
How old is your child?
She's 21.
And did she go to school here in Adams County?
Yes, sir.
Do you have other family in the area?
I got grandma and cousins and family like that.
And did you ever serve as a school resource officer?
Yes, sir, I did.
Tell us about that.
I took the job full-time at the sheriff's office as a school resource officer is what I started off as, deputy sheriff, school resource officer. Then was there for the kids, just to keep the kids safe, out of any kind of danger. I also was there for the kids, as far as bonding with the kids, keeping them, as far as like way of life, just you need somebody else to be there, Sometimes they need somebody to talk to. I did that quite a bit.
And did you sometimes greet the kids when they got dropped off at school?
In the morning, I directed traffic at the school.
And did you have occasion to know any of Mr. Foreman's children?
I don't know him by name, but I have let him out of the vehicle before. Or not let him out, but greeted him at the door of the vehicle.
How long were you a resource officer for Adams County Schools?
18 years.
So let's go to the night on August 21st, 2022. Were you part of the team that executed a warrant on Mr. Foreman's property?
Yes, sir.
That home was located here in Adams County on Russellville Road?
Yes, sir.
And how did you come to be a part of that warrant team?
I was called in. I wasn't actually working.
You weren't on duty?
No, sir.
And is that part of your job? Even if you're off duty, if you need to be called in for something, you drop everything and go do it?
Yes.
Was Mr. Foreman home during the warrant execution?
No, sir.
Were any of his children present?
Not initially.
Did you see any of his children that night?
In the vehicle with their mother.
Just to clear that up, can you tell us what happened?
Come in the driveway, and I was on the outer post of the house as far as like the perimeter area. And she pulled up with the kids, and I went over and spoke with her, and I told her it probably wouldn't be good for the kids to see us, so they wouldn't be there and to be upset or anything.
Excuse me. Do you know whether the children lived there or did they live somewhere else?
They live up the road. Up down the road from there.
With their mother?
Yes.
So then, did they leave, or did the children never went into the house or anything?
No, sir.
Did you take any money that night?
Yes, sir.
Sometime after this warrant was executed, did you start becoming aware of things Mr. Foreman was posting about you on the internet?
Yes, sir, I did.
We have some exhibits that we want to show you. Do you have them lined? Do you have them lined up, Natalie?
I have them pulled up, but they won't play today.
Let's go to the first one. Is that the order that we put them in?
I have the order.
Okay. Which number is this?
This is number 19.
So Lisa, we're showing you what we've marked as Exhibit 19. This looks like a post from September 17th, 2022. Was that shortly after the execution of the warrant?
Yes, sir.
Can we blow it up just a little bit? Okay, down. Near the bottom of that first paragraph, just go down a little bit more, right there. Has anybody in Adams County verified her vagina? If you haven't, you should, or she might. Whop out something bigger than yours. If this lady is your friend, I wouldn't leave her alone in my house. Or I'll put it this way, if you leave and your video system is messed up, etc., etc. And then down below a little further, my name for this particular officer is Lieutenant Mona Lickumlow Lisa. When did you first see this posting, if you recall?
Shortly after the warrant.
That was over three and a half years ago. Is that right?
Yes, sir.
Let's go to the next one. And you see here, it says disconnect after stealing my money.
What's the number?
Sorry.
20.
Exhibit Plaintiffs 20, Your Honor, thank you. Is suing me for humiliating her, giving her mental stress, ridicule, and the loss of her reputation. She doesn't like being called Lieutenant Mona Lickumlow Lisa full of shit Phillips, but she loves stealing money and disconnecting cameras of law-abiding, tax-paying citizens. That's March 25th of 2023, is that right?
Yes, sir.
Go to the next one. Which number is this?
Number 21, and it's a video.
Lieutenant Lickumlow Lisa, stop looking at pussy back there. That's your problem. You're always looking pussy and you don't even know how many pussies you've licked. You don't even know how many video cameras you done disconnected.
Well, no, that was 21?
Yes.
Did you see that video when it was posted?
Yes, sir.
Let's go to the next one.
Lieutenant Mona Lickumlow Lisa, and my ex-wife just like pizza. She jealous of me.
I don't need to know as much as the record needs to know it. Work with me here. Go with it. 22.
This is my favorite part of the trial, I think.
Mona Lickumlow Lisa, and my ex-wife just like pizza. She jealous of me and my love jail. That's why she disconnected my camp.
Was that the same one over again, or was that a different one?
That is number 22.
That's
the
22.
same. Yes.
Same one, all right. Lieutenant Lickumlow Lisa ate my ex-wife just like pizza. Is that what you understood that to say?
Yes, sir.
Let's go to the next one.
This is 23.
Mona Lickumlow Lisa, and my ex-wife just like pizza. She jealous of me and my love jail. That's why she disconnected my camera.
That's the same thing on a different platform. Do you know what? Can you tell what platform that is?
Sir, YouTube.
And the other one was Instagram? Don't play it, just pull it up, see if we can.
Number 22.
It's
Number 22.
Lieutenant Mona Lickumlow Lisa.
That's 22 again.
That's YouTube?
Yes.
I'm just trying to figure out which two platforms. Were they both the same platform?
Do you want me to go to the next, or both of those are both YouTube?
Oh, okay.
And then there's more exhibits of this.
Yes, I don't know why we had two of the same one, but I'm sorry.
Lieutenant Mona Lickumlow Lisa.
Can we stop here for this? So, for the record, are we saying that Exhibit 22 and Exhibit 23 are duplicates?
They are not duplicates, they are postings of the same video. One was posted on October 4th, 2022, one was posted on October 23rd, 2022. They were posted on his YouTube account on 2 separate occasions. One is like that.
Can we clear that up for the record, Your Honor?
I think we just did.
I don't know which one was posted when.
No, I get it. You're thinking like I'm thinking. Go ahead. Now we're on 20.
Let's play the next.
24?
Yes. Exhibit
Baby mama lick 'em low, Lisa. And my ex-wife just like pizza. She jealous of me and my love jam. That's why she disconnected my camera.
When was that post? Did you see a date? Is that a different date? Should have the witness testify, probably ideally.
It's September 25th of 2022.
Okay, and is that a different? That's a different date from the other two?
Yes.
Thank you. Next exhibit. Number
25.
Baby mama lick 'em low, Lisa. And my ex-wife just like pizza. She jealous of me and my love jam. That's why she disconnected my camera.
And is that a different date? Whoops. Was that a different date? Well, it's not up there anymore, is it? Or?
It is up there.
Okay. Can you tell, Lisa? Sorry.
Yes, sir. It's October.
Hold on, before we get too deep in the weeds, look at this. From Adams County Sheriff's Office, Colorado. The Adams County Sheriff's Office has received a flood of social media comments, DMs, and phone calls about the Afroman defamation trial. It's clear this is important to a lot of people. There's just one small issue. That's the ACSO in Ohio. We're the one in Colorado. Different states, same name. Wrong Adams, hashtag wrong Adams County. They did a whole map. Look at the video.
Afroman. So some of you have heard, most of you haven't. Adams County Sheriff's Office in Ohio and Afroman are in litigation with each other. We know some of you have heard it though. So we want
Who said and sewing him? Hold on, look at this guy. They said raiding Afroman's home and then sewing him.
So we want to provide you a quick geography lesson. We are the Adams County Sheriff's Office in Colorado.
We're the square state.
They are the Adams County Sheriff's Office in Ohio. So, before you start sending us messages, calling us, emailing us, DMing us, you may want to Google it.
They said Google it. Okay. Is that it? Alright. There we go. They made a whole video. Oh, man. Here we go. And as far as we know, they're still at the courthouse. Last update, like, I don't know, 20 minutes ago at this point. I see the chat asking. It was a Joe over on X asking, I think. But I don't see it now. And I can't reply to X comments through here, so I have to say them out loud. But for anybody wondering, so I'm sure that's not the only person wondering, we heard like 20 minutes ago that Afroman's still at the courthouse, jury's still deliberating.
October 4th of 2022.
Thank you. Different date. Okay. Next exhibit. Is that it? All right. We have another video. We're ready to do that?
Yes.
I'm just assuming I'm going to object in a
Yes,
second for this,
you're gonna
because I think
object to
this
this.
is the one I'm going to renew my objection on.
So don't play it, just tell me what it is first. What is this?
This is a video that was posted, I believe, last Friday.
Your Honor, I will enter an objection on this. The law has changed. As I said, in April of 2025, a new law was passed, an anti-SLAPP law, which would apply to this, and therefore would have a completely different standard of evidence, and we would renew our objection to it being admitted, or even posted at this point.
Mr. Klingler?
That law does not apply to this video or to this case, Judge.
Your Honor, that pertains to matters of public for the press. It also covers artistic expression and stuff. Just to have no analysis is not an answer to the question. But I will renew it. I have
Really good objection. I'll be consistent and overrule it. We'll play it, and you might be right, but we'll overrule it. I think I'm right.
It's okay.
Number 26.
And this is not 26, I apologize, Your Honor, it's 34. Sorry, we're out of order because of the way that they.
No, I appreciate it. 34.
Then for the record, Your Honor, my objection would pertain to Exhibit 34, just for the record.
Did you see this already, Mr. Osborne?
Your Honor, when they listed it, I did find it and take a look at it. I was never supplied a copy, but I did find a copy on YouTube.
Thank you. Go ahead.
driveway, singing how I lick pussy. And I need to learn how to count how many pussies I've licked. You know, and this has made it hard. To where I have to swallow because of you.
Not the language I would use.
Things is being said. Are you Lieutenant Licking Low, Lisa Phillips, Pussy Licking Phillips? I like to go to Walmart and be called a guy because of your voice. Or asking if you got a pecker. How would you like that? Would you like a female or a guy asking if you got a vagina? Probably not. How about standing and have me on their gate? Obviously, I haven't had a sex change. I have a child. Well, I've had that, yeah. They didn't make money off of me. They didn't say I should have to prove I don't have a penis. Okay. I was on my way to work one morning, right in Panhandle, stopped at the stop sign. The commissioners had a contracted crew that was working in Panhandle. I get hollered, Lieutenant Licking Low, Lisa Phillips. No one calls, or you don't even have to be working to get a holler from Lieutenant Licking Low, Lisa Phillips, Pussy Licking. I'm not a crooked cop, I'm not a thief, and I sure don't have a penis. There's been times that videos have been sent to me that I've had to go home because I can't handle it. You know? You know, I'll tell you what's sad is the fact that, number one, that I have to be emotional because your client lies. I've had a deep voice in my entire life. I did not wake up one morning and beg God to have a deep voice, all right? I had not had a sex change. I do not have a penis. I shouldn't have to prove I don't have a penis. Or about having a penis bigger than the rest of the guys that I work with. And pulling people over and licking pussy, I mean, come on.
So you're asking for damages due to emotional stress. Can you say emotional stress? Can you tell me exactly what that is?
Look at me in the face. Tell me what it means. What does emotional stress mean to you? Obviously, it's right here.
You're saying there's no one else to call, or there is other people and you don't want to call?
I'm not going to put anybody else in the middle of it, so.
Lisa, I'm sorry. I didn't know that hurt
His
you like
suit,
that.
remember, it's all the faces.
You know, you kind of intimidated me.
So not only does he have the officers' faces on this suit, but he also has all the parodies of the officers' faces on them and the nicknames.
I mean, you're a cop. I know you're.
I
I'm
think
sorry.
we're gonna see the whole
you got
video,
raided
you
my
guys.
house. You knocked down my door. I was upset. I would never shoot you, or I would never try to punch you. I thought I'd crack some musical jokes that I didn't know they hurt you that bad. I'm sorry. I think you're a nice looking lady. I didn't know you was a biological lady. I'm sorry. I was just having fun with the bad situation. I'm sorry, baby. I'm sorry. Oh man, Jesus. Hang on, let's take a little break, everybody.
He really recorded this. Look at this, guys. It's not really that vulgar anymore, in case you looked away. It's a little vulgar, because you still see some cheeks. But he's walking on a bridge on a roadway. This is like... You guys know the song 99 Red Balloons, right?
Okay.
Oh, wait. Oh, they included this part about... This is about grooms, right? Oh, no, this is about Newland.
Look at Lisa used to toss my salad for hours. Lisa used to lay on the floor and let me piss in her mouth.
I hate it because the kids knows who I am. That's his kids in the car.
That's what I think it is. That it?
I think it was lost on me because we were looking at her on the stand. It was lost on me that they included that girl saying that. I wonder if the jury picked it up better because maybe they were looking directly at a screen that somebody there is saying like, hey, Lisa used to do this, and maybe that's where they think the source of this rumor came from. But one thing I'm thinking about is he really asserting that somebody's a man, but he's also, like, I don't know. In the video, the recreation, it's girly. She's buying, like, a girl's shaped outfit to walk around in after, which to me the impression, although I think the whole video is parody, the impression is that the reenactment actress is being treated as an actress, as a woman. So that's not really an ongoing, continuing assertion that somebody is not who they say they are. Like, I don't know, to me this is complete parody. So are we saying that there is update? You guys are yelling verdict in the chat. No verdict. Don't do that, chat. Don't do that. If you're asking if there's a verdict, use a question mark very clearly. It's helpful. Let me refresh WCP09 anyway, just to make sure. Yeah, I don't see anything on WCP09, and if I refresh over on X, I see... Alright, Dizzy's sharing it, so... Although Dizzy's just saying cat. Is that cat there's a verdict? Okay. Who's airing it? They're gonna be late airing it, aren't they? They're gonna be late airing it. Alright, 15 to 20 minutes. And local 12. So hopefully we have a camera feed. What I'm gonna do, and I'll drop a link that way we don't get lost. I'm gonna condense this down. We're gonna do a verdict stream that's all condensed. What a perfect timing. We just got done doing the watch of the Lisa Lickum video. Let's run this up. Schedule it for today at 6:20 p.m. Make sure that's there. And it's Local 12 that's saying it. Maybe they can have like permission to use the camera feed if well, the one guy from WCPO 9 was there. He wasn't the one running the camera. But at least WCPO is there. Somebody's there. So, all right. So when I end this stream in a second, it's going to redirect us. We have a verdict coming in 15 to 20 minutes. So let's pretend it's 5 minutes. Go get your snacks. Go get your snacks. Dropping a link here as well. Let me drop a link over to the verdict stream. That this should redirect you, but I know some devices don't take it over. So the link will also be in the chat. Verdict stream. And what I'll do is I will see if any, I don't know, I'll invite some lawyers up, see if they want to come up. And there we go. I don't know if we'll see the live reading. I'm hoping someone gets in there with the camera. If not, it might just be a tweet update that we read from, you know, either Local 12, WCPO 9, you know. Also, before we end this one, big thank you, Mark Lyon, for the commentary on the great production value in these videos. Right? And it's like, I feel like they were produced rather quickly, you would think. So, awesome to see. Clearly artistry, right? It's a production. And then also making her sit through a 10-minute outro is crazy. And remember, that was the plaintiff's attorney that played that, right? It's not like somebody forced somebody to sit through this thing that's going to make them cry on the opposing side. It was her own attorney that wanted to show it to the jury and had her sit there through it. Amber, thank you again for the sticker. We have Woman from Siglord. Thank you. We're going to redirect you guys. Wait, we got one more. Lori, Los Richie, thank you so much for the 10. Says thank you for all your hard work. I enjoy this, guys. I am very happy to not be sitting watching things by myself. YouTube is my favorite place because it gives us a chat, right? We have a chat function. And before I ever had my own channel, I love to be chat side, still love to be chat side, because it's really cool to see what other people think about things in real time. You know, sometimes it's surprising, but you got to know sometimes people don't think the exact way you might. So I think seeing people's reactions is critical, and we should all be open-minded to it. And then let's see, we've got Suna Skylion says, hi, can you give my mom a shout out? She loves you. Oh, that's so nice. Well, Suna Skylion, hello, Mom. We're going to call you Skylion Madre. So thank you so much for being a fan of this channel. Very, very cool. I'm honored. Thank you so much for the super. And hope you guys both follow us over to the verdict. We're going to hit this end. I see 77 people there already waiting. So let's go join them, you guys. Thank you so much. Dropping the link one more time in the chat if you need to click it to get over there. And see you there. Verdict reading in 5 to 10 minutes.